Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not.
Dati mihi Anglican, please. Very much love you. I didn't ask you to interrupt me.
Is that correct?
Oh, for Christ's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Wow, what a day, what a weekend. It's been a bit of a weekend, I think. Wow. Let's see. Let me make some room. Straighten everything up. Make it look somewhat presentable here. All right, good morning, good Monday morning. Big shout out first and foremost to Kim R, who was first in chat and used her first in chat moment to say not guilty, free Karen Reed. So Kim, congratulations, you're first in chat. We're punishing you as we have punished you many times before because you are in fact a habitual offender. Habitual offender. I think I said that wrong. But that's well beyond repeat offender. There's at this point there's a problem. Just kidding. Welcome. Oh my goodness, we missed a man out of Minnesota. I looked at that and I thought about it, and had it not been so heavily enshrined in pickles, or politics, not pickles, we would have followed that manhunt. But it's done. That's the good news. The shooter has been arrested as he should be. And hopefully full justice is headed his way if he's guilty of everything that he's accused of doing, which is heinous. Yes, they found him a couple miles from his barn, hiding in the woods in a pile of poop or something. I don't know, like a mushroom. He was in the dark. Anyway, enough people have been terrorized by that. So, all right, welcome. It sounds like hot this morning, like it pops. Not sure why it pops. But we are going to be going to, why is that? My power went off last night, if you can't tell. That's why it took a minute to get logged in this morning. Everything, everywhere. You know, and now that everything just crashed.
Bring the jury.
Well, we'll fix it. Pop out chat. Okay, there's Kim. Gotcha, Kim. Okay, all right, we're back.
I don't like podiums, Your Honor.
Have them send someone with more experience.
Hey, none of that, Kaylee. All right, here we go. There was something I was trying to adjust. What was it? Oh, yes, I know. I have to turn off the key on channel 1. Got it. Okay, now I'm with you to stay for the long haul. All right, we have just a few things. I don't need a topographic map for today. That was fun, though. All right, we have a few things. We have the siren counter, which is up to 294. I think we're going to hit 300 today. I just feel it in my bones. We are in verdict watch. We're in verdict watch, and I believe it starts at 8:30. Is that when I can start the timer? Because that was 8:37. That was like 7 minutes ago. I think they're supposed to be brought in. The judge said you can't deliberate until I bring you in the morning. Where did my timer go?
I was kicked back, taking it easy.
Oh, here it is. Found it. I almost deleted it. It was so close. All right, we are waiting for word that either deliberation starts or that the jury's going to be called in and told they can start deliberating. And when they do, I'm going to start the counter, hopefully as close as possible to the time they start. As we can, just to get as precise as we possibly can. The jury's already deliberated for 1 hour and 50 minutes, roughly. Hope you all had a wonderful Father's Day, by the way, yesterday. All right. They are back deliberating. We're going to start it. We're starting it.
In front of the Walmart.
All right. Well, the timer, we'll get everything set up with the timer and everything else. It is going. So we're a tiny bit off, but it's going. We have to do a couple things. I had a fabulous Father's Day, by the way. Fabulous Father's Day. And completely blew my diet. I've been out. I went out for a bike ride first thing this morning, just to make up for the number of cinnamon rolls I consumed yesterday with a ton of frosting. But we will. Yes, let's celebrate. Let's celebrate birthdays right now while we wait for anything in the Karen Reed trial, and we'll have some other stuff coming as well. So, all good. Do we have any birthdays? And then we'll talk about some of the other things. Any birthdays to celebrate today, other than Mackenzie Jabley? We can add your son's birthday, Mackenzie, but we need your son's name. Or just call him son. While we're waiting for that, I bought the bug salt. Hubs loved it, Judy. I'm telling you, they're so much fun. And they're functional. Kelly H. gifts a membership to kick everything off. Thank you very much, Kelly H., for your generosity, your repeated generosity, day after day. Amy P., member for 6 months. Look at that yellow courthouse. Good morning. It's a great day for a not guilty verdict. Thank you, Amy. Kevin M., member for 21 months. One of our OGs says, hoping for a verdict today. Kevin, congratulations on 21 months. AC's Wildflower, member for 14 months, says, hope all had a happy Father's Day and happy verdict watch day today. I've got my fingers crossed for some verdict music. Rob, Rob, you know I can't say your name. I can't say your name. Let's go. What's another month? Maybe I can get a verdict on my renew day. That would be awesome, Rob. And congratulations on being the king of all sofas, I guess. That's it. Let's see. Mandy Winslow, welcome to the jury. Mandy, thank you for your support as a jury member. Thank you. Love that orange courthouse. Nikki Zeebs, member for 26 months. Says, yay, 26 months on my baby's 8th birthday. Love it so much here. We've got a couple birthdays coming up. Mackenzie and Nikki both have kids with their birthday today. Kels Bells, member for 17 months. Not guilty. Free Karen Reed. Real Justice for John O'Keefe. Thank you, Kels Bells, 17 months. Judy M., member for 19 months. Hey, 19, love to all. Shelly Kelly, member for 10 months, hoping to hear the verdict music today. Me too. I think I've got it still. It's been so long. Yeah, got it. We're good. We are good. We are fabulous. Oh, Teresa comes in with a 25-month, another OG anniversary message. Teresa, thank you. And it just says gallery. I'm here. That's what she says. But it's more than that. It wouldn't be the same without you here, Teresa. Michelle M., member for 8 months, says, fingers crossed for a quick verdict today. Thanks, Ari, for all you do. You're great. And chat is amazing as well. We owe our amazing moderators thanks for that. They're absolutely wonderful people. All right. Let's see if we have any birthdays. Possibly. Samantha, thanks for catching that one for us, for adding Renee. Is it Mackenzie or is it Mackenzie's? Let's see. Me too. My son, 21 today. Adam. Michelle, your son's 21. Okay, somebody keeping track of these, right? To add an Adam. Melissa says, please say prayers for Matthew's test and procedure today. We will do that. We've got you in mind, Melissa and Matt. Thank you for that. Yeah, we have many. Josh, he's working. You're making him work for it. It's going to be one of those days where we probably a 2-verser. Corey Hill says, the camera guy popped in for verdict watch. Corey, love it. Thank you very much. Good to see you again, my friend. Thanks for, I know you lurk sometimes, but See, you didn't know I knew, but I do. Thank you very much. Good to see you. Beezy Sup Playa Bree, member for 26 months. Wow, Hoslong is my membership. Breezy, it's 26 months. You're an OG. Love it, love it, love it. I learned quite a bit. Yeah, just I was understating it. I didn't want to call you out. I was being a habitual lurker. All right, where are we at? We've got something I want to say this morning while we're waiting for birthdays. I was watching some of the media coverage of the defense team arriving at the courthouse this morning, and to give you a background of what's why this was significant. There's a gentleman on Twitter who is quite outspoken regarding the Karen Reed trial, and this particular individual happens to fall on the hanger high crowd, okay? Because he's like, it's more than just like find her guilty. He's like hanger high. And so everything that happens in court, he posts a post that just like describes it as if, I don't know, it's unicorns and rainbows for prosecution and just absolute devastation for the defense. No matter what it is, Alan Jackson could just drop the one zinger of all one zingers, and Mr. Brennan could have turned and worshipped him appropriately for the literary skill which he possesses. It could have happened, and he would describe it as that Mr. Brennan points 10 fingers of shame at Alan Jackson, and the courtroom mocks him or something, mocks Alan. That's the sort of post that it's like he's a troll, but it's like I think he believes it anyway. So this guy, I'm not calling out any names. This guy posts something, and it comes with just a description. It's not saying what's in the picture. It just says, that in some cultures, a hand gesture where you put your finger over your thumb over your two fingers here and raise the pinky finger and the pointer finger. It's like the devil horns type thing, and he posts that. And the picture that goes along with it is Karen Reed doing this, which is as close to I love you as I can do with my right hand, because my pinky will not extend when my fingers are down. And it's the love sign. It's the I love you. Okay, it's like this, but he describes it as this, which is a little different. Well, this morning, as I'm watching the defense team get out, Mr. Lessie gets out of the car, and he does this big. He's like, "I love you guys, To everybody, they're all quiet. He's just like showing the love. Mr. Yannetti gets out of the car. He's like, he's full on giving him the horns. So I think LTL Media had a great view of that when it happened, but it was pretty funny because it was definitely a pointed thing directly at that one account. Anyway, I thought that was funny. I thought I'd share that. All right, let's see. I missed the birthday reminders. I think they were in there somewhere. Okay, here we go. Josh says, Isla, Denise C., Luca, Ariane Zeebs, Peggy, Adam Renee, Luke, Debbie M. 1, 2, 3, 4, 5, 6, 7, and 8. I've got eight people on the song. Does that sound, Josh? Great work today. I know that was a ton of work. Thank you for putting that together this morning. We will, anyway, let's see. Let's sing first. One moment, we have more. Okay, we'll wait for a minute. Emily Aaron says, I bought a new car this weekend, 2 weeks after my car accident. Lucky Insurance will cover all of what I owed on my old car. That's good. It would be nice if they also covered all of what the new car costs as well. That's what insurance should be for, right? People are guessing correctly on text message with me. How to check how long I've been here. Lily, The color of courthouse shows over 2 years, but you can go to, I think it's the accounts and subscriptions page on your account that should show you how long you've been subscribed. Should. It's not easy. You have to hunt around for it a little bit. Isla is the pronunciation. Hold on 1 second. Got an urgent message on Airbnb. Nice. Airbnb says they can't verify our ID. We're literally hosting someone right now. They're like, we don't know who you are. All right. Let's see. Let's check for the birthdays one more time. Here we go. It's Ile. How do you say the first one again? Isla. I said it wrong. Isla. We might have to spell it like EYE space LA for me to remember. Isla. Okay. Isla, Denise C., Luca, Ariane Zeebs, Peggy, Adam, Renee, Luke, Josh, Kenton, and Debbie M. Sorry, you got a hiccup there in the middle. Hopefully that's the last one because we're going to sing. Let's get the birthday song underway so we can celebrate these birthdays appropriately. Let the shenanigans begin. There you go, like Island. Okay, Island. Isla. It goes like this. I'm gonna sing here in my studio, and you're gonna sing wherever you are. Even if you're in a library, hum quietly to yourself. There's no reason not to participate, unless for some reason you participate and would like lose your job or distract someone who's in pain and suffering, or like in a bad way. Everyone else, you need to basically sing along. So it goes like this. I'm going to scream. I'm in the library, so it's okay. Stand up, take your breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. It's going to be a good one. It's going to be good. Got a lot of names here. Might be a 2-verse. Happy birthday to you. Happy birthday. Happy birthday to Isla, Denise C., Luca, Ariane Zeebs, Peggy, and Adam. Happy birthday to you. We got these ones in verse 1. We're going to do these ones in verse 2. Probably could have saved Adam for verse 2, but if you. Happy birthday to you. Happy birthday to you. Happy birthday, Renee, Luke, Josh Kenton, and Debbie M. Happy birthday to you. There we go. Isla, Denise C., Luca, Ariane Zeebs, Peggy, Adam, Renee, Luke, Josh Kenton, and Debbie M. It's your special day. It is your birthday. I realize there are a million places you could be, a million people you could have been with, could have celebrated with, a million places, a million people, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we return that pleasure back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. Free pancakes. Happy birthday. Did they start yet? The deliberations have started, according to Court TV. Who knows? They're in the know. Oh, I just got a text. I'll read you this text when the birthday song's over. The dancing is going great. High kicks look good. Drum solo coming up. Everyone help me out on that one. Big finish, right? Beautiful, beautiful. Excellent, excellent. Thank you all for your help. Are we anxious or just me? We're all a little anxious. We're all a little anxious. I'm not sure if a quick verdict in this case would mean good for defense or good for prosecution. But I was surprised that the defense put in all the lesser includeds that the state didn't want. Interesting strategy. All right, I'm not anxious. No, I'm not anxious. I normally have this knot in my stomach. Love the ending. I stuck it. Good job, Judy. All right, let me read you a quick text I got. Look at this. Hello, I am HR representative from Indeed. Already I doubt this. We recently reviewed your resume, which I don't have out publicly, and believe you are a great fit for a remote online job opportunity we have available. Oh, sounds promising. This is a flexible, remote, part-time, full-time, online... It's everything, apparently. This is a flexible, remote, part-time, full-time online job where the role involves assisting merchants with product reviews. The job is simple, and we provide comprehensive guidance to help you get started quickly. Work only 60 minutes a day. I did the math on that. That comes out to 1 hour. Daily pay ranges from $100 to $300, which would be $100 to $300 an hour, depending on your working hours. What? They said 60 minutes, like the line before, and now you can earn up to 300 depending on how much you work. Work from anywhere, anytime, although they said it was work from home, but it's all right. If you would like to join us, please contact us via WhatsApp. Here's a warning. It looks like Nambia is the country code, which I'm sure that's where Indeed is probably based out of, Nambia. Please note that the applicants must be at least 23 years old to be eligible for this role. I'm going to go ahead and reply with report junk. So, totally legit. Totally, that could have been my job, like my career. I get those all the time. It's spam. It's like, yeah, checks out. I'd click it. Sounds good. Why 23? Why 20? Is that like the international age for fraud, where if you agree to it, it's your own dang fault? Red says, oh man, we got a letter this week. I need to scan and send to you. It's a legal scam looking for a cut in a huge inheritance. It's hilarious. Oh my goodness. And they went so far as to write you a letter. They're all in. You know, you could take them for a ride. All reputable companies use WhatsApp, says Lara Fry. Good stuff. Maybe we'll have some prank calls today. Let's see. Get that set up. And let's get back to court while we're watching. Oh, I'm supposed to be getting you the timer on screen. Give me just 1 second. It's there, but it's not pretty. And I know you guys don't like the billionths of a second as they tick off. So I will adjust it and get rid of that. It's going to be in camera 2. Just 1 second here. Box 2, we'll make it bigger. We're going to also scoot it down. And we'll crop the corners off so you don't see the floating circle around it. There we go. Close enough. All right. We have to. Legally Blonde says, "Can I get a super chat over the top arm wave if the verdict comes in before 11? Legally Blonde, you must be like doing some legal work in the background. You're a little distracted in the typing. I'll be in class. Oh, that's what it is. But I'll have you muted on my phone. I'll excuse myself to watch the verdict. Okay. So, what's going to happen is it's going to be like this. I'm going to go like that, and then you'll be like, I'm like, it's happening now. I'll do that, okay? And then you can, make the excuse about the dog and diarrhea or whatever you have to do to get out of class to watch the verdict. Let's see. Circle cuts to the top corner still. It does, just a little bit. Is it enough that it bugs you? I can't see it. Bad eyes. Oh, yeah, it bugs me too now. Now that I see it, it's terrible. It's terrible. Oh, hey, something's happening. I heard, just briefly, I heard Mr. Brennan's voice. Do the verdict dance. And clipped. Thanks, Amber. I'm glad you're here for that. Let's see. We have something is happening in court.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
I have to stop the timer.
So I have to ask you those same questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their head. So, Mr. Foreman, with that, we're going to send you back out to deliberate. Okay.
All rise for the court, please. Follow me.
All right, so I guess Court TV didn't know what was going on. What we're going to do is I've got a timer going for 20 minutes since we kept that going for 20 minutes this morning. When the timer goes off, I'll restart the stopwatch, which will keep us accurate. But as of right now, 1 hour and about 50 minutes into deliberation. Let's see. Yeah, Mandy, a little bit of a panic there, a little false alarm.
Jury's exit the courtroom. Please be seated.
All right, so Mr. McDermott handed me something that I'm going to go read. All right, and we'll see you. Court officers will give you instructions on where to be and no more than 10 minutes away, okay?
Your Honor, with regard to the version that was sent to the court.
I don't, the version of whatever I have not yet read?
Correct.
Okay.
No, I want to flag for the court. We'd like to replace that. We noticed some errors. There were different versions that were circulating amongst our team, and we believe the incorrect version got filed. So we would, if you have 10 minutes, we can file the correct version.
Okay.
With the court.
Has the Commonwealth seen whatever it is that Mr. Iannetti's talking about?
I just received it in the courtroom. They may have sent it earlier. I just looked at it a couple minutes ago, so I need some time.
Okay.
We'll make sure he has the updated version as well.
Okay. All right. Thank you.
All right.
All right. So we gave you the wrong version, but we're going to update it in 10 minutes. Sounds like a jury verdict form again, which is interesting because I thought the judge was not inclined to change that to match what they had. All right, Mr. McDermott. Who's Mr. McDermott? She said to bring case law, so maybe they did. Maybe they have case law. That would be nice if they did. The verdict form is ridiculous. It is. It's terrible. Get on the record that they made a valid case law request. Man. Butch Jones, welcome to the gallery. Good to have you here, my friend. Look at that blue courthouse. Changes colors rapidly when you first join. Thank you. I don't think it's verdict. I think it's something else. I don't know what else would be applicable right now. As far as forms go, There's only one form to fill out, and it's got to be verdict. We are now in Verdict Watch. We have just, let's see, we've been going for 1 hour and 54 minutes. In 15 minutes, I'll be able to put it up on screen, but it just takes a minute to get everything synced up, right? Let me pin this one. Got to give a big shout out to Thomas, known as Weather Watch here on the channel. He recommended padded biking shorts. Where have these been all my life? Where have mine arrived over the weekend, and wow. It's like carrying around with you your own private seat cushion that you don't have to hold because you're wearing it. Oh, my goodness. I want to wear them to church and sit on the pew that way. At baseball games, stadiums. They're amazing. They're amazing. It's a big fan. Big fan. All right. Let me get this up here. Chat's going really fast. Just 1 second here. Josh, I see you sent us something. We're going to take a look. We are going to do some trial hopping while we are in Verdict Watch. After we get the timer going in the corner so everyone knows what's happening. I'm going to build a little view that will keep the fan in the corner so you can see that. OG Sean White says, I'm home. A week in Vegas is too long. Congratulations on your placing 70th in the tournament. That's impressive. We do have a verdict counter. It's going, but because we heard that it was starting 6 minutes ago. Well, we heard it was starting 14 minutes ago. Well, it was 20 minutes ago, and then we heard. Anyway, in 14 minutes, we'll restart it, and then we'll be on time. It'll be perfect. Judy, give me a minute. Let me get to those. Play the Vegas fake caller song. Oh, where is that? Did I save that? I know Mathis made it for us. Court has come in session. The jury has come in. They've been welcomed, asked if they did anything naughty over the weekend. Nobody told the judge they did, and so they continue to go deliberate. Back in the day, we used to call those butt pads. We put those on when we put on the knee pads and the elbow pads. These are worn underneath. These are on the tighties level. How in the world has the entire jury avoided media on this? Good question, Kelly. Good question. Unhyphenated said, I called a hung jury the first trial, and I believe it's highly likely again. When you have a small town, think on things, and everyone pretty much knows everyone, you will see half and half take on things. Possible. It's possible, very much. Let's see. Wiggle Styles says, good morning, friends. United filed a change to the verdict form. Just saw the minutes. Yes, the judge is going out to read them. Apparently there's some case law attached to it because the judge basically challenged and said, well, if you've got case law, then I'll hear it. But the judge didn't have really any case law on her side either. So hopefully she'll change it. All right, 12 minutes until we'll start the counter. Let me see what Josh found for us today as far as some entertainment. Let's see. Oh, it's Judge Boyd. First defendant on Judge Boyd. Okay, let's pull it in over here. Amber, thank you. Let me see if I can find that one first. We'll do the Vegas link first while we're trying to get everything set up. Okay. In honor of the week in Vegas, the 1 week in Vegas, we're going to play a little song while we get everything. Give us time to get some video set it up on our end, and the song is about why I cannot go back to Vegas, and it sounds like this right here.
How are you doing today? I'm pretty good. Good, so I see here that you have about 4 vacations worth of travel credit built up. Everything is paid for. The only thing that you would be responsible for is a one-time booking fee here today. The first vacation is a 5-day, 4-night stay in Las Vegas. Then you got a 5-day, 4-night stay in Orlando. Then you got an 8-day, 7-night flex cruise, Royal Caribbean, Norwegian, and or Carnival Cruise Line. And then last but not least, you would have a mini vacation at your disposal. 3 days, 2 nights, over 150 cities to choose from. And that, my friend, comes with a round-trip airfare for 2. And that also comes with the rental car. These are cruises? No, this is the whole package is yours. Okay? All you have to do is pay a one-time booking fee. Don't get the booking fee for the whole package. They used to do it for one trip. You would have to pay. They used to do it individually. But now that we're trying, COVID hit, and we're trying to, get people to start traveling again. So we have a package deal now. So once we're trying to, get the world back to where it used to be and get people to travel again. Oh my goodness. So this is good for the holiday. I've always wanted to go on a cruise. I'm like I've never been, and I've always wanted to go. Okay, so this whole package right here, you got the cruise, you would have the whole package for just a booking fee. The third and fourth traveler would travel, they would be on the initial insurance that you have. But I can't do Vegas because this is embarrassing. I have a warrant in Vegas that I haven't taken care of years ago. Oh, no. Believe me, buddy. Believe me, I've been in jail before. I'm not judging you, bro. No way, brother, I'm not judging you. And I heard in Vegas, bro, they're bad out there. Oh, my goodness, it's the cameras. I've seen it on the little show. Yeah, I've seen it on the little show. You know how they take people to jail. The cops like the shitty cops, yeah, it was crazy. Because I've never been to Vegas. I would love to go there though. Now I'm curious, what were you in for? I'm not sure if I want to tell you what I was in for. No, we were just fighting me and my girlfriend were arguing. They took me to jail, but all the charges were dropped and stuff. Yeah, it was just domestic, but it was dropped. Everything was dropped, it was cool. Mine may have involved a police chase. Oh shit, in Vegas, that was probably... It wasn't like in Vegas, but I was going through Vegas and I almost made it all the way into Utah up I-15. What was it like the movie Hangover and shit? I don't remember a lot of it. Oh my god, there's video from a helicopter. Yeah, that's why I'm so glad that I didn't go to Vegas when I was young. I'm older now, I'm 45 now, but I'm glad I didn't go to, to Vegas when I was young because I heard the cops were bad. Well, now I can't go.
This entire song, the lyrics for the song were made up from an actual prank phone call I received.
Well, now I can't go.
No, I can't go. Thank you, Mathis, for putting that call to music, commemorating why I can't go to Vegas. I told the guy that I had a warrant from a police chase. And anyway, so no Vegas for us. So we're not going to do a meetup there. But good morning all, one and all. We've got just about 7 minutes, and we'll have the countdown timer on the screen, or the count up timer as the jury is deliberating, and they've just passed the 2-hour mark. So we'll do that here. We also have a little thing that happened with Judge Stephanie Boyd, which as soon as we get the timer and everything going and I got the screen oriented the way I like it, we're going to do a little bit of court hopping while we wait for news out of the courtroom regarding this case, whether it be questions or verdict. And it's gonna be awesome. It's gonna be good. It's all gonna be fun today. I do hope we have a verdict today. I sincerely do, because I'm going camping tomorrow. So I will be gone pretty much half the day tomorrow, leaving. I've got to be like packed and out the door by noon. And then I'll be gone all the rest of that day, all night, until evening. I'll be out camping, which means that I have to take the Starlink and my studio with me, because I'm not going to miss this verdict if it doesn't come in today. So, Welks, happy birthday to my wife. Welks, happy birthday, wife. To Welks' wife, happy birthday. What was her name? Mrs. Welks, of course. That's her name. That is awesome. Whereabout are we going? I think Wilmington area. We are going to be camping in an area that has native carnivorous flora, like plants. Is it fauna, or which one's the flora and which one's the fauna? Anyway, plants that eat meat. That we're going camping there. It sounds like a bad idea. It sounds like a Rocky Horror Picture Show or something, but it basically is. That's where we're going. We're going to go, fauna is the animal, so it's going to be the flora, the plants that eat you. Yes, that's the one. Oh, man. The lobster call, thankfully, I don't think was ever put to music, right? Did I delete the lobster call? I think I deleted that one. Trying to recall how long they deliberated last time. Was it 3 days last time, Mandy? I think it was 3 days. Going to Oak Island, North Carolina in August. That's awesome. I'm taking a metal detector with me on this camp out. Stanley Redder Carnivorous Plant Garden. No, I'm just going in the forest where the plants natively roam, I guess. I guess they roam. If they eat meat, you've got to be able to catch it somehow, right? So the plants must be able to up and replant themselves. Land of the Lost? No. We have rented out a facility, and it's my daughter's first camping trip with her group. So camping has a different interpretation to everyone. Recovery Addict brings cables and an audience. John, yes. Okay, let me full disclosure. This camp, I am bringing battery backup, Starlink, my e-bike, all the cameras and everything, mics that I'll need for a live stream. And yeah, it's going to be probably a TV, a laptop, and I have air conditioning. So when I say camping, you might think of something different. But hopefully there are not a lot of bugs. Did I ever finish the bathroom? How can you leave when your bathroom is still not done? Red, where I'm at right now in the bathroom is all the drywall is up, floor and ceiling, walls, everything. Oh, there's no drywall on the floor, obviously. The shower pan is set. All the rough plumbing has been done. I have mudded everything but the ceiling and the corners. So all the seams, mud, tape, everything else. We probably have 2 more mud layers to do, and I probably have to do that tonight. What motion did defense file? I think they filed a motion to update the verdict form to something more current than the Salem witch trials. I think that was their motion. They're currently using the Salem witch trial verdict form, which is not a good one, if you remember from there. All right. 5 days according to NBC. It seemed like 3, but... see. Okay, we have 2 minutes. We'll start the timer, and then we can start watching some court hopping stuff. Also, my typing skills are about as good as Hank's interpersonal skills today. You're going to a cabin, not camping. I'm taking a hammock, okay? So it's basically camping. A hammock is like an upside-down tent, so technically I think it still qualifies. Defendant's motion to amend the verdict slip with Exhibit A attached. Says Eeyore, that's what it is. Judge is going to go read it. She might come back. Well, that's probably the first thing we're going to see is her come back within well, probably right about the time that we're ready to start court hopping, she'll come back and at least discuss it and say whether she's going to do something or not. With all the rain you've had here, you may want to stock up on bug spray. Mosquitoes and no-see-ums are terrible right now. Detect vids. Maybe we can have a quick frost. Is that too much to ask? Can we read it? Amber, do you have the doc? The docs were dropped by Amber. If you'd like to read them, please join on Discord. So Discord has them. Let's see if Amber would be kind enough. Oh, we're about to start the timer. We have 1 minute, so let me get that ready. So it's been 2 hours and 9 minutes in deliberation. Jackie Taylor. Can't miss your live stream, so watching on my laptop from my hospital bed. Jackie, I'm so sorry you're in the hospital. It's never a fun time when you're in the hospital. I mean, I will say rarely. Some of the meds they have are unbelievable, but rarely is it a fun time in the hospital. Thinking of you, hope everything goes well, and get out and about here very, very soon, Jackie. Thanks for taking us with you, though. Thank you, Jackie. All right, so, I've got to watch 12 seconds. I think Amber just sent us the doc. We can review that really quickly. Okay. There's the duck sound. The timer has started. We're showing the timer now. All right. There's our deliberation timer. Now we can start. First, let's read the document that dropped. I think Amber just barely dropped it for us. Defense motion. It's only 3 pages. It's not a very big one. Barb says, "Are you going to kill your meals?" No, but I'm going to dive in the lake and look for lost jewelry. Defendant's motion to amend verdict slip. This comes from the defense, obviously. Now comes the defendant, Karen Reed, to request that the court modify its jury verdict slip from its current form. Ms. Reed submits that the proposed amended verdict slip improves clarity for the jury in understanding its task and reporting its verdict. The current verdict slip, particularly the slip for count 2, confusing the jury and thus causing errors. Respectfully, the present verdict slip is unclear and otherwise confusing. This lack of clarity is a resultant risk of confusion. And resultant risk of confusion error can easily be minimized by tailoring and clarifying the verdict slip to better aid the jury in memorializing its verdict. Indeed, there is no compelling reason not to do so. Specifically, Ms. Reed proposes that the court use the verdict slip attached as Exhibit A, which presents formatting changes, not substantive changes, to the court's verdict slip. That the jury has started deliberation does not preclude amendment. See Commonwealth v. Leocardi, affirming a verdict slip provision during jury deliberations. Indeed, the court amended the jury verdict slip in Ms. Reed's first trial while the jury was deliberating. A verdict slip is a tool designed to aid the jury, recognize means of reducing errors in the rendering of announcing of verdicts, Commonwealth v. Powers, and then it's cleaned up. It is well established that the verdict clips are of no binding legal significance. There's the Reed v. Commonwealth. They cited their own case. A verdict, as a matter of law, requires a public announcement in open court. No verdict exists if none was announced. Because verdict slips are tools to aid the jury, their primary goal, in addition to ensuring the defendant's rights, should be clarity for the jury in both understanding its charge and reporting its verdict. That's Commonwealth v. Clark. Crucially, finding that verdict slips only serve to confuse the jury. The current verdict slip has the real potential to confuse the jury and cause errors, particularly with respect to count 2, manslaughter while operating a motor vehicle, under the influence of liquor, and its lesser included charges. The form does not explain the process the jury should follow while completing it. Although the court instructed the jury that the form should be completed from the top down, the form itself does not provide instructions to stop after the jury has selected a given box. Moreover, the form presents the jury with only a single not guilty option, applicable to count 2 in its entirety, juxtaposed with 4 guilty options, one for each charge. This imbalanced presentation visually favors the guilty options and risks creating bias towards a guilty verdict in degradation of Miss Reed's rights, in addition to creating the risks of confusion and errors. In furtherance of the salutary goals, I think it's salutary goals, of maximizing, that's a new word for me, Red, you'll have to explain that, SALUTARY, of maximizing clarity and avoiding error. I think it should be the singularity. I don't know. I guess maybe not. Miss Reed proposed the verdict slip attached as Exhibit A. The proposed verdict slip has several benefits. First, the form includes clear, step-by-step instructions explaining the jury whether they should stop or continue based on their findings for a given charge. Although Massachusetts law does not dictate how or in what order the jury must deliberate, the jury must return a verdict of the highest crime that has been proved beyond a reasonable doubt. The proposed verdict slip's clear instructions aid the jury in complying with that mandate. What's crazy is the judge has gone her whole career using confusing verdict slips, apparently. Additionally, the proposed verdict slip makes clear the jury's choice between guilty and not guilty for each separate charge, instead of presenting only a single not guilty option encompassing each and every charge that is part of count 2. This balanced presentation gives equal weight to both possible outcomes for each charge and avoids any implicit bias towards a guilty verdict. Providing the jury with clear choice between guilty or not guilty for each charge while following step-by-step instructions also minimizes the risk of confusion for the jury. It is beyond cavil. There's another new word, C-A-V-I-L. That the proposed verdict slip is clearer than the current jury verdict slip. Conclusion, Ms. Reed respectfully requests that the court now substitute the attached verdict slip for the court's existing verdict slip for use in this case. And then we have the jury verdict form. And it has page 1. In the above entitled case, we, the jury, now say the defendant is 1, not guilty, or 2, guilty of the offense as charged in murder in the second degree. And this is the unanimous decision of all 21 members. That's page 1. Page 2, manslaughter while operating a motor vehicle under the influence of liquor. In the above entitled case, we, the jury, say the defendant is 1, not guilty of the offense charged or any lesser included offense, or 2, guilty of the offense as charged, or 3, guilty of lesser offense of manslaughter, or guilty of lesser included motor vehicle homicide, or guilty of lesser included offense operating under the influence of liquor. This unanimous decision. So that has all the lesser includeds. And then, of course, you've got the last verdict slip, leaving the scene of an accident resulting in death. In the above titled case, we, the jury, say the defendant is 1, not guilty, or 2, guilty of offense as charged, leaving the scene of an accident resulting in a death. So that's, I think it's very clear. I don't know why the judge would object to it, other than she's just being a stick in the mud. Let's see. It means remedial. In Charlotte's Web, salutations was a big word she wove into the web. That's some pig. Well, okay, tell me this. Charlotte's Web, it was the spider that did all the work, right? And then the spider dies, and the little babies all float away except for one. But the pig gets all the credit. I'm sorry to spoil it for somebody who hasn't read it, but that one, I didn't like that book. They should have said, that's some spider. It's nuts to me that she insists upon case law to use a clearer verdict form. If there's opportunity to make it clear, make it clear. If you must have a reason, research is better than case law. Are Lexus SUVs good cars? I would say yes. Toyota's a good brand. Lexus is a Toyota. It's not like a Bentley, right? So, you adjust your expectations accordingly. Sorry, I'm out there with the spoilers. I figured the book's been out long enough, I can spoil it now, and it'll be all right. Thursday's a holiday. That's right, it's June 19th. Lexus is short for luxury export to U.S. Spider was the pig's lawyer fighting to save his life. Yeah, but the pig did nothing but wallow in the mud and shine and just sit there and smile. What happened at the end of Usual Suspects? I don't know. I can't spoil that one for you. I had a Toyota once. I had a Toyota pickup. The last year they made the pickup before they changed it. It was like the SR5 transition. So I had the old style, chrome bumpers, roll cage, boom and stereo, turbocharged, everything. It was an amazing. I bought it from somebody who literally was leaving the country and had to sell it. He could not sit, and he waited too long to sell it and just didn't. I knew that he was in a tight spot, so I got it for I think $4,500, which he probably felt was a scam. But he was just going to have to just abandon it because he was gone. He needed the money, and it was amazing. Until I was going through a green light and a lady went through a red light, and I had to total her car and mine. Messed up my shoulder too. Dang, we're in a tight spot. Amber, Michelle, sorry. I love that movie. I'm a Dapper Dan man myself. Lucky 13, I started reading the book called A History of Glue. Can't put it down. Can't put it down. Just sticks to you. Yeah. Had the lift kit. And the yeah, it was nice. 4-wheel drive, locking differentials. All right. Well, we wait for the judge to come back. I think we're going to pop on over to Judge Boyd's courtroom from last week. We just missed this towards the end of the week. Where's my mouse? There it is. Shrink that down, bring this over. We have one defendant to watch in the Judge Boyd court. So let me get, I told you I was going to get the courtroom ready. We have to be able to keep the OnlyFan on screen while we watch. If a turtle loses its shell, is it homeless or is it naked? Asking for a friend. I sadly have seen a turtle get hit by a car, and I can just tell you that it was incredible how similar the turtle shell reacted to the turtles in Super Mario Brothers. It went shooting out. Hope the turtle was all right. The turtles have strong shells, but this one was just clipped a little bit. Let's see. Where's my camera one? Box one is going to be camera two. Box one is 2, box 2 is 3, box 3, or box 4 is 7. And then we turn on box 1. How about that? Well, works better if we shrink it down and uncrop. We need the fan in the corner so we can see that it's still going on. That's it. All right. We're jumping down to Judge Stephanie Boyd's court just briefly while we keep the timer going, and we're still listening with what's happening here. But let's give it a listen and see what's happening. with Judge Boyd, or what happened the other day. Apparently, this first defendant was interesting.
Yes.
That reminds me of my niece. All right. The court, I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, I'll wait for the Arlene Gay is the defendant.
All right. And are you Mr. Beltran?
Yes, Your Honor.
All right. In defense, you said you've adopted his motions?
Yes, Your Honor.
All right. So the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right. Is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right. So, Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? Mm-hmm. All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right. Thank you. And then we have.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling? Okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what I,
State does
and if
not
I'm
want to
interpreting
address
this
these.
incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So do you understand? You gonna have any questions about the court's ruling?
Yeah.
All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like, for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right. Do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction. And the fact that he was brought into this case. Tumbling. I believe that's it. Is that it? Okay.
All right. State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay.
Yes.
That is for civil suits. We are in a criminal court, and so I would argue
sir, this is a Wendy's?
Apply here.
Mm-hmm. All right. So the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No.
All right.
This
So then
defendant just printed them off the
other
internet.
one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841.
He's
This
regretting
court
his
now under
decisions.
federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I just printed this off the internet. Said, get out of jail free, print here.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're one of a third party.
Okay.
And I'm not, I don't, third party, I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that, I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bexar. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand?
I understand.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points? Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls. Okay. So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together because that's the way it was received.
Yes.
There is the next one, which is exhausting administrative relief.
Mm-hmm.
My client is not wanting to have that heard. Right. It deals with ineffective assistance of counsel.
Mm-hmm.
Right, Mr. Beltran, that's not to be heard right now. Okay.
All right. And let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understand.
And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mm-hmm.
And that addresses antitrust violations, brought upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization, are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right. So with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Do you know?
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right. So they're not going to be trying you.
Yes, sir.
All right. The next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right. So do you want that heard or no? All right. And then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third-party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge. There has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this offense.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases? No, Judge. All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, sir.
All right. Does that address that issue?
Yes, sir.
I think the other issues deal on the second page, deal with State Bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And
you threw everything in this.
defendant being sued.
Oh, who's being sued?
The defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's, again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
I'm guessing they won't settle any of those three.
All right. Is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that were raised? that we have not talked about and the judge has already ruled anything other than.
The level of patience being shown here is unbelievable.
No.
All right. Is there anything that you don't understand about the jury trial process? All right. So I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right. So if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right. So, counsel, you're still requesting a jury trial? All right. Norma, if you can put them on the jury trial, please. And Ms. Galloway, if you'll confer with the defense on a jury trial date. So they're going to get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome. And who's the attorney on Edward Rodriguez?
Here, Judge.
Okay.
All right, we're going to swap these out and
all right, if you all will come up.
Sure.
and lose the judge here real quickly. There we go. That did not go as well as he planned it would go, I'm pretty sure. I mean, it was a slow burn for sure, but the dismantling of every single piece of internet propaganda that he printed off was quite painful. He didn't even understand his own arguments in a little bit. He was sure that would be the get out of jail free card. The fact that his lawyer's like, yeah, I'll present them to the judge for you, was unbelievable. Just want to hear a jury question. Do we have a jury question? I haven't seen anything indicating that. So let's see. Sue O'Connell does indicate that the jurors were dressed normally, meaning they're dressed pretty much the same as they were every day during court for the last month worth of trial days. T-shirts, workout shorts, business casual, the full gamut. Apparently the jury is getting comfy, but no dress up. All right. T-shirts and workout shorts, I think. In court. Yep. It is a younger jury. There's your sign for sure. So I don't see them dressing up for verdict day necessarily. No one told them it was fancy dress day. Laura, you sent a text. Let me check. Got a lot of happy Father's Day wishes, by the way. Thank you for all those. Appreciate that. Oh, no. The pickle flavored cotton candy I tried, and I was not a fan. It was not good. Holy cow. Laura sent me the pictures of peacocks. Wild peacocks. 13 adults and 3 sets of babies. That is a ton of peacocks. My neighbor, I say neighbor, but it's a friend of mine who lives a couple miles away, has a peacock, a single peacock. And those things can scream. They can yell. They've got some pipes on them, and they are, for being a bird that has a massively long tail, they can fly pretty well, and get up on tall things like the top of houses and then just yodel to their heart's content. Let's see. Aldi has pickle scented candles this week. Man, not sure. Make bacon cotton candy. Just bacon. I'm good with just the bacon. Thank you, Ari, and all those who gifted memberships. Blessings to our Ari fam cast. Congratulations. 22 months. Peacocks. I thought you said detox. Peacocks they are loud. They're amazing, beautiful birds. I used to live in northern Utah, in Logan area as a child. Like, I don't know, I was probably 5 when I moved away. But I can remember going to the Logan Zoo, which is basically a park with a few animals in it. And they have a lot of birds, and they had a peacock. And they also had some golden pheasants, which are just beautiful, beautiful birds, both of them. And then they had some mountain lions or bobcats and bears as well. Just a few deadly animals kept in a little cage there on the other side of the river, and you could just walk around the park, and it's like, oh, we'll go look at the bear. It's like, think of like a city park, but it has a bear as well. It's like that. You just didn't have the right pickle cotton candy. I love it, and I got customers to buy and eat it. Really? A better mix? Have pheasants in my garden. House backs up to a wood on a stream. That love pheasants. Jamie's asking where we think on guilty or not guilty. Most of the group that's here is leaning to the not guilty side. By most of it, say over 90%. But we have people on both sides here. The motion has been denied by the judge without a hearing, according to Reed. What? Denied without a hearing. Form stays as it is. What motion? The motion was to change the verdict form to something that makes a little more sense. I don't think most motions should have speaking portions. The lawyers just say what they wrote for the most part. I don't know. I think really long, lengthy motions are very repetitive. And it helps me to hear the argument if they're boiling it down. But if it's a short motion with an argument, then it just makes it longer. We read the motion just before we watched the little distraction court with Judge Boyd. We read it together. So if you just rewind, we've got the whole thing there. I think to have only one option of not guilty and the rest all guilty seems very unfair and confusing. But the not guilty is at the top, right? That helps. That's where it should be. And once they mark not guilty, they're supposed to stop. They start at the top and stop, and they're going down. Why do you think she's dug in and won't change the form? Probably out of habit. And it's basically... it comes with it an insinuation that every other trial she's ever done with this same form has been confusing for the jury and questions the verdict. Thank you, Amber. We looked over the forms and read those. Appreciate those. Personally, I don't think it's confusing. I think she said this form has survived appeals court before. It has. What if they get to 5 and can't come to a unanimous decision? Then there's no option to acquit on 1 through 4. Then it's a hung jury if they can't come to a unanimous. The only conclusion is that she wants the confusion. The juror from the last trial specifically said they were confused on this exact issue. What's the longest they'll deliberate? Probably until 4. So that was, they've been going for about an hour and 10 minutes today, which means they started at 9. So 9 to 4. They have the choice whether they want to deliberate through lunch break or not. That's up to them. Midlife Mania, we're on verdict watch right now, so we're just sort of watching the OnlyFan, waiting for any word or movement in court that would indicate that the jury has reached a conclusion or has a question. I'm keeping an eye on Twitter, so if I look distracted, that's why. Victoria George from trial one, was a juror on trial 1 who joined the defense team as part of the motion because of the confusion about the form. Nikki's a member for 18 months says if they hang on a lesser included, there's no way to indicate not guilty on the main charge. If they hang on OUI, they would be able to retry the whole charge. It definitely does favor the prosecution that way. There's only... It doesn't allow a partial, and I think it would then require the judge to inquire, which she doesn't like doing, to see where they did find the commonality, where they did have unanimity, unanimousness. That word is escaping me today. If they all came together on some of it, there's no way to indicate if they hang later on. I see what you say there, and that's where it seems very unfair. The parties left the courtroom and drove off. They have to be within 10 minutes of the courthouse. Mr. Yanetti's office was 10 minutes away, so they're just going to be ready to go as soon as they get the word. OnlyFan is a star for the day. I think so. Lady Draconis, I wish there was, but so far nothing. We've had one motion by the defense asking the judge to use a different jury verdict form that's a little more clear, that allows for a not guilty selection in relation to each of the charges, instead of just one not guilty and then a whole bunch of lesser includeds where they could hang. And the judge said no. Denied. This case has my brain in a chokehold. The form they have is the standard from Massachusetts, apparently. I'm confused as to why the defense would want lesser includeds. If somebody knows, or somebody has a sound reasoning as to why they want those extra, unless they thought they'd be better off with. If they were nervous that they weren't going to win, I can see doing a lesser included, because then a holdout might say, I won't go for the max, but I'll go for a lesser. But I just don't know why they did it. Do you want to start a new trial today? Because I found with opening statement starting in 15 minutes. Josh, is that the one you just gave me with the judge? Is that the one you sent just a minute ago? Warren County. Do you know anything about the charges? I don't want to jump in and find out that it's, the Diddy trial reincarnate. I'll keep my eye peeled for it. But you guys talked about the excitement here in Minnesota over the weekend. Well, most of the excitement was that all the Minnesotans stayed indoors and didn't go to mass gatherings because there was a wacko on the loose, crazy individual with a gun and an agenda. Was caught over the weekend. Last night, I believe he was caught late last night with hiding out near his farm. But he had shot 2 different Minnesota lawmakers and their spouses. One of the victims and the spouse passed away, and the other two victims are in recovery. Not true. Lots of people out in mass gatherings in Minnesota. I know there was just an order that went out, Libby. I'm not saying that nobody went out. I mean, in the live streams I saw, Brian Enton even drove up there and was doing a live stream, and people are still out and about, walking on the streets and doing their thing. But it was good to see him caught. He had his wife was caught with guns and money and passport stuff and was let go just hours after the shooting. What's with that? There's got to be charges against her too. It sounds like she might have known. Yeah, the little sketch. Guns, money, and passports aren't illegal. I think they might have a circumstantial case to argue collusion or aiding and abetting. He's only charged with second degree. I bet, Donna, they up those charges. I bet those are going to go up. I know there was a protest in Utah and Salt Lake that had a shooting as well. Lots of civil unrest out and about for pickle reasons. Yeah, these are the holding charges. They'll upgrade. Okay. Pete Turner, former prosecutor, says lessers allow defense to bring case to end instead of hung jury for jurors who just have to convict for something. But, I mean, I see it would resolve the case with a less than the worst possible scenario outcome. But if you didn't do it, it would be like being innocent and taking a plea deal because there's a chance you could be found guilty of the maximum. I don't like that part. I want to get to the truth of it. You forgot to underline often. 2 teens unalived in Phoenix. Oh man. Shooting at a carnival last night in Utah? Why? I mean, unless it's like the BB gun at the little star on the paper, there's no reason for a shooting there. You need a grand jury to get to first-degree murder here. So there may be a grand jury indictment and then the first-degree charge after that. Pickles can be surprisingly divisive. Massachusetts has a 2.5-year maximum penalty for DUI. And they call it OUI, right? Operating under the influence. For Minnesota, there's a possibility of federal death penalty charges too, even though we're not a death penalty state. I'm surprised he didn't make it into Canada. Surprised he didn't get out. I was watching some of the air traffic and listening to the police scanner and stuff. There wasn't a lot that we could listen in on, but was listening over the weekend. That's why Luigi was federally charged. Oi, also pronounced we. Yes, oui, French, right? Got 4 inches of rain less than an hour. I'm on a hill and barely got any. A mile away is devastated with 5 dead and more missing. Houses washed away. Warning came too late. West. Oh my goodness. That's nearly. I mean, that's a mini hurricane. 4 inches of rain in less than an hour. Wow. Well, it took about 4 hours for the jury to decide Alec Mardaw is guilty, as far as I remember. They were quick. This one, not so sure. We're going to keep getting updated from court to see if anything happens. Christine E. says, Ari, do you have a recommendation for basic civilian ability to listen to police scanner? Grandma had a bear cat, and I missed that background sound. Christine, if you're looking for local... well, first of all, this is conditional on which state you're in, because some states it's against the law to have a police scanner. Some it's against the law to have one in your vehicle. There's varying laws, and I'm not saying this is blanket for the United States, but police scanners nowadays, most of them are trunked and they're digital. What that means is you used to be able to go out and buy literally a little crystal chip, and it would say, 155.70 megahertz, and you plug that in your scanner and you could listen to that frequency. It would be like tuning to that frequency on the dial, and you could hear the police talk back and forth. Nowadays, there are no crystals; it's all digital tuners. But the system, in order to lower the cost, the amount of the expense for the infrastructure, they combine a whole bunch of different services on the same system and use sub-audible carrier tones to differentiate between who's talking to who. So Parks and Recreation doesn't talk to police, but they're all on the same frequencies, and they have like 12 different frequencies they hop back and forth through, and one control frequency that tells everyone how to hop and where to go. It's a little confusing, and a scanner has to have a trunking capability, and there are different levels of trunking as well. But if you have the money, I'd recommend a trunking scanner that's programmed to your area, because you'll be able to hear everybody, whether it's the trains, whether it's the highway patrol, the police, the sheriff, local town law enforcement, as well as you can tune in your parks and anything that happens in your area on the airwaves. You can tune in. If you just want to do it for cheap and easy, there's scanner radio apps on the phone that you can get that are better, but you just have very limited listening ability. And if you live in a rural area, that's not by a big city, there's a good chance there's just nobody out there with a scanner that's linking it to the internet, so you won't be able to hear that. It's not that it's not available, it's that somebody has to have a scanner and plug it into the internet so you can listen on it. I do use a police scanner app on the phone called Scanner Radio, and it looks, I could be able to see this one. It's just an orange and gray logo on the App Store for me called Scanner Radio. It has one ad at the beginning, and then once you listen to the ad, you can listen to the traffic. I think that one's free. I wouldn't pay for any out there. It's just they're not that good, and they all use the same source. If you have a computer, you can go to there's some police scanner web pages that have all the same sources that these apps use, and it's really easy to hang on. Safe travel, Samantha. There's Broadcastify, thank you, is the website that has all the different channels that you can find on any of the apps, but that requires a computer. It's pretty good. Or a tablet or something. You can do it with a phone, I guess, but it's a little more complicated. If you have a police scanner and you're in an area that does not have your local scanner feed on the air, there are ways, it takes a little more tech, but there are ways where you can be the source for Broadcastify for your area, and they will actually pay you if something happens and a lot of people listen. They pay you for the time that people spend on there, and you can win, earn enough money to pay for scanners and a bunch of other things. It's pretty cool. We need a loud siren to go off when it's announced there's a verdict. With the police scanner, though, let me just, this is not legal advice, but let me just tell you that in some states, even though it's legal to listen to the police scanner, if you have a police scanner with you and you're doing something that could be considered a crime, even as simple as speeding, it could elevate your charges to a felony level or something extremely serious. So please check your laws on police scanner usage before you do it. And in some states, it's against the law to take the information and turn around and share it again. So just be really, really careful. We have verdict music. It's basically like a announcement. It's ready to go in a moment's notice. The button's all prepped. I feel like it's going to be a long day. I'm hoping it's today, though. I really am, because it'll be a little bit difficult, and I'm not sure how to do the verdict music if we're on the road when the verdict comes in. It's only a couple-hour drive, but let's see. Thanks for all the kind words on Twitter. Somebody's talking about us. Everyone's chiming in saying nice things about the channel. You guys are amazing. Still no updates, no words. Josh, did you see what the case was that you sent me? Do we have any idea on what it is? It's It's working. That's awesome. Judy, did I miss something? I was rambling. What? Do you have a question? Oh no. You'll hear verdict music if there's a verdict. Let me get it ready, Josh, just so if it's something we want to jump to, just to keep ourselves entertained while we wait and chew our fingernails. No, we're not chewing our fingernails, but just we're nervous. This case made me download Twitter on Friday. I've got Sue now. It's wonderful when you just download Twitter and you don't have anything else. Your timeline's really, really clean, and you only get the stuff you want. It has been a long time since we've had verdict music. Very long time. Sean White, Ted Daniel on X says judge denied defense motion. She did, with no hearing. I mean, beyond what Mr. Yannetti briefly said this morning, saying we've got a new form for you. See if we can get this other video pulled up. Which one's live? This one? Is it 4? Three. I think we're gonna jump to this little court when we get a minute. There's a little court that's about to begin. It's a jury trial. We have no information about it, like zero. But it will give us, we'll be watching the fan in the corner. We'll have the audio. We'll cut away from this new trial the second something happens, but it will give us just something to, let's see. Let's turn on the audio first.
Yes, Ron.
Video going, just 1 second. There's our only fan.
Ready to go.
So this little court is Warren County. Let's see this. What state is this in? Ohio. Warren County, Ohio. It's on the map there, on the logo there. Looks like we have some good cameras. Audio seems to be decent. Judge Donald E. Oda II. If it happens to be a case that we need to bail on, we will. But we're taking a chance here. Rolling the dice. Clarity of the video is incredible. It's pretty nice. Let me make sure we're in 4K.
All right, you may be seated. Print 1080, 720.
Ladies and gentlemen, is everybody able to follow my instructions over our break? We are now going to hear the opening statements of the attorneys. Remember what I told you, the opening statements are not evidence. We've agreed in advance that each side will have up to 10 minutes for their opening statement. Mr. View, you may proceed.
Thank you, Your Honor. On December the 23rd of 2024, Corrections Officer Donald Hopper was working his regular shift at Warren Correctional Institutions. As I told you during jury selection, Warren Correctional is one of the two state detention facilities here in Warren County. And Corrections Officer Hopper was working the afternoon shift. Just about 10 minutes before 2 o'clock, he was working his regular assignment at the mental health unit. You're going to hear from him that the mental health unit is not a housing area. It's where he works. The mental health unit is a place for mental health services. It's where medication gets dispensed and other services like that. You're going to see he was wearing his issue body-worn camera that's going to capture really about the 5 minutes or so before his interactions with Mr. Snyder, and then the aftermath and medical treatment that he received, sort of emergency first aid that he received. So you'll be able to watch the entire thing on the body-worn camera. It includes video and audio. And what you're going to hear is that just before, sir, do you need the hearing? You look like you're struggling to hear me. I just want to make sure you can hear me. Okay. You're going to hear on that body-worn camera that about 50 seconds or so before he interacts with Mr. Snyder, he gets a notification from corrections officers that have surveillance on the outside area that one of the inmates, Jason Snyder, was making his way towards the mental health unit, and that he had been picking up some items in the yard. This is a security concern. Mr. Snyder's coming to the mental health unit on a pass. He's allowed to be coming there, but it looks like he's picking up items. Maybe he's bringing something into the unit that he would not be permitted to. So Corrections Officer Hopper goes to meet him at the door. And you're going to watch the video, the interaction that they have at the door. Officer Hopper asks him what he's got in his hands, and you're going to see he's got kind of a series of cups and some items that he had put into these cups. And there's a discussion between them. What is this? Why do you have this? And Mr. Snyder asks if he can keep them, and Corrections Officer Hopper tells him no, and then as he's permitted to in a prison, going to search, make sure he didn't pick up and put some other things in his uniform. And when Corrections Officer Hopper begins to do that, Mr. Snyder hits him straight, like a sucker punches him right in the face, right in the nose. You'll be able to see both on the body-worn camera and on the prison surveillance outside the unit that he strikes Officer Hopper, knocks him back through the doorway. Corrections Officer Hopper tries to cover up and protect himself, kind of tries to push him away. Mr. Snyder continues to throw punches at him until other officers arrive and subdue Mr. Snyder. You're going to hear the entire interaction verbally between them. There's no provocation, there's no threats. Corrections Officer Hopper takes no use of force against him. Unprovoked, Jason Snyder struck the corrections officer in the face at least once, if not more than once. You'll be able to watch.
Sounds like assault on a peace officer type.
Mr. Hopper is wearing glasses. Those are essentially shoved into his nasal area. Blood is pouring out. You're going to see that on the video as well. Blood's coming out. It's all over his uniform and his arms. Immediately, the responding officers and medical staff at the prison take him back to try to wash and kind of give him emergency medical care. You're going to see him, from his body-worn camera. It's the perspective of right here. It's him wiping blood off of himself. And it's pretty clear he's going to need some other medical attention than the kind of first aid that they offer at the prison. So ultimately, Corrections Officer Hopper ends up, well, one, the prison notifies the State Highway Patrol, right, that we have an assault on a corrections officer crime that's occurred. So Trooper Creech responds along with his partner, Trooper Plantz, to begin gathering evidence. They interview witnesses at the scene. They get the video that shows the assault as evident. But Officer Hopper then goes to the Atrium Medical Center, if you know where that is. In Middletown, it's essentially the closest place to Warren Correctional for services. You're going to see those medical records. And what they show is a nasal fracture, displaced nasal fracture, broke his nose.
Broke his nose,
up
wow.
here. You're going to see the pictures. I mean, his nose kind of has a pretty good crescent arc to it. There is a large laceration across his nose that required stitches.
Or across.
He has a laceration on his temple cheek area here that required stitches, and then a laceration cut on his forehead that was ultimately glued and sealed together. The result of that is that he does have facial scarring. It's not severe, but it is present. And you know, within a week, he had to have the nasal surgery to correct his nasal, the fractures to his nose. And then about a week after that, he realized sort of after they dealt with all the stuff in his face that he was having difficulty breathing. Further x-rays showed that he actually had 2 rib fractures that were not previously treated. So he had to receive medical treatment for that as well. He ended up missing several months of work before he was able to return due to the assault and the treatment following the assault. Based upon the testimony of Officer Hopper, the investigation of Trooper Creech, that's going to include that body-worn camera, the surveillance video, and those medical records and the photographs you're going to see of those injuries, the state's going to ask you to find Mr. Snyder guilty of what we call felonious assault. That he engaged,
Felonious assault is the charge.
Or attempted to cause, but in this case he caused a serious physical injury to Officer Hopper. The judge is going to explain to you what a serious physical injury is. One, it's any injury that results in protracted pain. You're going to hear from Officer Hopper. He essentially had to take prescription pain medications for several weeks. Ultimately had to continue to manage his pain for his difficulty breathing. Where you have any kind of sort
It's
of
like a lot of law
long-term
students
medical
watching this one.
debility, even if it's not like serious, but if he has difficulty breathing from his nose, those are the kinds of things, right? And where you've had a significant medical intervention like surgery, that's what we would call serious physical injury. Concurrent to that, right, there's more than one way to look at the same assault. The state's going to ask you to find Mr. Snyder guilty of assault on a corrections officer. He can be found guilty of both. The same criminal act, right? Same act can violate more than one criminal section, and that is that at the time of the assault, Mr. Snyder was detained at the prison. He was an inmate. That it happened on the grounds of a state detention facility, that's Warren Correctional Institution, and that the victim
We're in
of the
Ohio.
offense was an employee of the Ohio Department of Corrections. So again, I don't have to show the seriousness of the injury. You're going to be able to see what qualifies as a physical injury, absent any other medical intervention, just in the cuts to the face and everything. So again, based on the testimony of Officer Hopper, the investigation by Trooper Creech, we are going to ask you to find Mr. Snyder guilty of felonious assault and assault on a corrections officer. Thank you.
Defense?
Mr. McKinnon?
Thank you, ladies and gentlemen.
This camera white balance is way off.
We, as the defense, do not obviously have to prove the case. The burden is on the state. So I as a defendant, as a defense attorney, you don't have as much to say in opening statements because it's the state's case. We would simply ask that you pay attention to the case and listen to all the evidence presented, and in particular pay attention to what do you actually see on these videos, what actually happened. Was it really the more serious offense or was it the less serious offense? So please listen to that as you watch the trial.
They're going for it.
And we'll talk again in closing arguments.
They're almost going to give away the lesser.
Mr. View, call your first
This
witness.
might be a quick one.
The state calls Corrections Officer Donald Hopper.
This might be a very quick trial. It is a jury trial. There's the officer.
Yes.
Sworn in.
Good morning, sir.
Good morning.
If you could please say your name, spell it for the court reporter, please.
Donald S. Hopper.
And we're going to talk about some events that happened back in December 23rd of 2024. At that time, what was your occupation?
Correction officer at Warren Correctional Institution.
And just so we're clear, you're not here in uniform today. Are you still a correctional officer? You're retired now?
I could have, but I'm still working.
Okay, so still currently, and as a corrections officer, you are an employee of the Ohio Department of Rehabilitation and Correction?
Yes.
Okay. And how long have you worked as a corrections officer?
Now it's over 31 years.
And I know sometimes people have a picture in their mind sort of what life is like inside the prison or what corrections officers do. Your responsibility as a corrections officer, what are your duties and responsibilities in that position?
I have a lot of duties. The responsibilities are pretty much to keep everyone that's in there safe, the inmates safe from each other, the public from getting out, keep them safe. My specific job is in the mental health department. My duties consist of checking anyone that comes in the area, making sure they're not out of place, make sure they have a pass. We also have the vault in the area which holds the property for inmates that are in a TPU unit, which is like what they call segregation, used to call it. So I'm dealing with a lot of different caliber, different types of inmates, some with mental health issues, some that are just troublemakers.
Now, you said that you worked at Warren Correctional Institution. Is that the only detention facility you worked at during your time as a corrections officer?
No, I started at CMC, which is the medical center in Columbus, which also consisted of satellite rooms at OSU and central office security.
Okay. And how long have you been at Warren?
Been at Warren for 30 years.
And the Warren Correctional Institution, that's a state detention facility?
Yes, sir.
And it's operated by the Ohio Department of Rehabilitation and Correction?
Yes.
And is it located here in Warren County in the state of Ohio?
Yes, in Lebanon, yes.
I mean, it's in the name, right? Warren
Yes.
Correctional Institution.
Right.
Now, I want to talk specifically about December the 23rd of 2024. Actually, before I get to that, you said that you worked in the mental health unit. And how long has that been your assignment?
10.5 years, almost 11 years.
Okay. Now, the mental health unit at Warren Correctional Institution, can you describe what is the unit? What is it?
Well, the mental health area that I work is for the incarcerated people to come up and talk to professional psychiatrists, psychologists, to talk them through, do their medications, things of that nature. So I'm constantly moving around, unless I'm monitoring the doors at the time, to check on the staff, make sure they're safe in their offices, make sure nobody else is coming in or just roaming around that shouldn't be there. Like I said, it's just there's a lot to do.
So, just so we're clear, is the mental health unit at Warren Correctional, is it a housing unit area where severely mentally ill?
This is a service area where we provide those mental health services.
Okay.
Like I said, the vault is also located at the back. We do have 2 specialty housing units up there for the mentally ill, which is RTU unit, which is a residential treatment unit. They house a variety of inmates, high security levels, death row even. Then we have the other side, which is a little bit calmer. The guys are a little more functioning. I guess they take care of themselves better, hygiene-wise, just things of that nature. They're getting closer to getting back into population.
Okay. So just so we're clear, the area where you work, or where you were working on December the 23rd of 24, the mental health unit, that is not RTU, it's not a housing area,
Correct.
right? It's a service area, it's where inmates come for services.
Right.
But separate from that, it still is a secure area of the prison, right? You have to, inmates just can't walk in from the yard to the mental health unit, right?
Correct. Usually if they come in off the yard, they've broken off from a line going to chow, going to commissary. They may have a pass for another area, and if they derive off of that area, they're considered out of place.
Okay.
So
that's
they
what
have to have a pass to come into my area.
So that's what we're going to talk a little bit about. You mentioned this being out of place. Can you explain that for the jurors? What does that mean within a correctional facility?
Well, they can't just walk into the warden's office, for one. That's definitely out of place. If they walk into another housing unit that they don't live in, it's out of place. They walk up to commissary, the area, then it's not their commissary day or their time, they're considered out of place. So they know where they're supposed to be, they know where they're not allowed to be. That's just they know this. They get orientation when they come in the institution.
That answered my question. When inmates come into the facility, they are informed about what is a proper place they can and can't be in.
Correct.
And if they need to be someplace, commissary or places like that, the process for getting a pass to go there. Is that right?
Yes.
Okay. All right, let's talk about the actual day of the assault, December the 23rd, 2024. Were you working at the mental health unit on that day?
Yes, sir.
No
and
objections.
Do you have a shift assignment?
Okay. Well, there's 3 shifts and there's a 4th one. The 4th shift is for different hours for operations. It gets assigned different days off, perks, other things just that other shifts don't get. I've been on special duty now for 15, 20 years, somewhere in there, 17 maybe. So I'm considered what they call 4th shift. I'm 7:30 to 3:30, which is different from your other 3 shifts. So that's why they call it 4th shift.
Okay. And were you working that 7:30 to 3:30 shift on December the 23rd?
7:30 p.m.
All right. I want to talk about the time frame about 11:45 to 2 o'clock or so. Where were you at that time?
All over the building.
Well, were you in the mental health unit at
Yes,
Warren
I was in
Correctional?
the unit,
Okay.
the service area for the mental health patients, yes.
And at that time, near that time, 1:45, did you come in contact with an inmate named Jason Snyder?
Yes.
And just so that we're clear for the record, the Jason Snyder we're talking about today, he was, at least on that day, an inmate at the correctional facility, right?
Yes.
He was not an employee, food service contractor, visitor, anything like that.
No.
And before that day of December the 23rd, 2024, to your recollection, to your knowledge, had you ever interacted with Jason Snyder before?
If I did, it's not memorable. It wasn't a memorable moment. I'm sure he came in for his detailed mental health screening when he got there. If he ever went to segregation, whatever, he would have come up and got his property. I may have had a few words with him on instructions of what to do, where to have a seat at until the yard opened or if it was closed or whatever. That would have been the only interaction I could think of that I may have had with him, unless he came up there before and I warned him about coming up there.
He was not a regular user of the mental health unit services? No. You did not recognize him as I mean, there are inmates who regularly come for services, right?
Correct.
And based upon the time that you were there, he was not one of those, right?
No, he was not.
And the individual we're talking about today, Jason Snyder, is he present in the courtroom today?
Yes, sir.
And can you identify and point him out for the
Yes, sir. He's right there, sitting right there.
individual in the blue checked shirt seated here at the defense table?
Yes.
Let the record reflect he's identified the defendant, Jason Snyder.
Noted.
All right, so around 1:45 p.m., or shortly after that, just explain for the jurors, if you can, how it was that you're working in the mental health unit services, How did you come in contact with Mr. Snyder?
Well, I received a radio traffic on my radio as I was rinsing my dishes real quick in the kitchen, and they radioed me that an inmate was down in the maintenance trash, which is considered somewhat hot trash. They're not allowed to be in it. They know this. It was walking up to my area, so I immediately stopped what I was doing and went to confront who was coming in my area, which I didn't know who it was. And when I confronted Mr. Snyder there, that
Hold on for a second. Before we get to that, I just
Okay.
want to talk about what was going on leading up to that. Okay, so you were notified. Who did the notice come from?
one of the yard officers that was running food service in the small chow hall.
Okay, and how was notice given to you? How were you made aware of?
Over the radio.
Okay, and so the information you had was that there was an inmate that was in the trash or doing something out of the ordinary.
Mm-hmm.
Is that right?
Yes.
So in your 30 years experience as a corrections officer, why is that concerning? Why would another officer even notify you that an inmate was digging in the trash or doing something?
Well, there's considered what they call major contraband and minor contraband. Minor contraband would be something that they are allowed to have, but it may have been someone else's. Major contraband would be a piece of metal that they can make a weapon out of. Heavy rocks or something that could be put into a sock to be also made as a weapon. Those sort of things that are definitely big violators. Now if they had like pencils or pens or whatever and they were sharpened, that could also be considered borderline major minor, because it's a pencil, it's minor, but since he sharpened it real good and had several of them, that makes it major. So we are instructed as employees to do our job and take major contraband.
Okay, so when you were notified that an inmate was doing something, right, they were doing something out of the ordinary, was that your concern at the time? This inmate was coming to mental health unit and may have contraband in their possession?
My concern was what kind of contraband.
Okay. And if an inmate is suspected of having contraband, what's the procedure? How do corrections officers respond to that?
Okay, so there's a lot of different ways you can approach a guy. The job has been uneventful for the most part for 30 years until now. IPC skills, which are what they call your personable communication skills, to talk to them fairly reasonable, respectful, and just try and get things worked out without being forceful or using force or whatever, put your hands on them or anything like that. That's the last thing we want to do. And ask them, just straight up, what did you get, and hand it over, was my first response to him, to see if he was just going to comply. And he acted like he didn't have anything and hadn't done anything. So that raised it right there.
All right, we're kind of getting to the actual contact. I just want to make sure the jurors understand the context of what was leading up to your contact with Mr. Snyder. So, also, I just want to make sure that we're sort of clear on this too. As a corrections officer, do you have personal defense weapons that you carry with you?
We have a radio. We have pepper spray. Anything can be used as a weapon. We have a man-down alarm, which is, if it's tilted for so long, more than 5 seconds, it will set off an alarm in control center and they activate people to come to your area. It has a ripcord. You can pull that, which automatically activates it. Several ways to activate it, but if it's tilted too long, then it automatically sets it off.
So other than, I know so you don't carry firearms. You don't carry like baton, pieces of right, tasers.
No.
Right. So in terms of sort of compliance items that you have on you, the primary one is
your voice,
pepper spray.
Yes.
Right. And then if there is a confrontation with inmates, you're really using that radio to call for assistance.
Yes.
Okay. Now, on this day, were you wearing a body-worn camera?
Yes.
Okay, and is the body-worn camera record audio and video?
Yes.
And
we'll get to
at
see
the
it.
time of your interaction leading up to and contacting Mr. Snyder, was your camera active? Was it actively recording?
Yes.
All right. Let's, if you can, I know we started to get to this. I apologize. I know you want to get to they probably want to get to the important stuff too, guys.
I don't care to even get to it.
So, after you got the notice that an inmate was coming and that they had been doing something I don't want to say out of place necessarily, but is it out of place to be at the hot trash?
If they're going to chow, they walk by it. So he's just walking by it, or they're walking by it. It's, as long as they don't get in it, they're fine.
Okay, but the information you had is that they got,
Correct.
Mr. Snyder had gotten into it. All right. So tell the jury what happened when you encountered, first of all, where did you encounter Mr. Snyder?
He was between the two doors of the outer of the building and then the door, it's kind of like what they call a sally port area. There's two doors to enter the building, and he was between them, just roaming around in there for the moment.
Is that outer door to get into the sally port from the yard, is it locked?
No.
Okay, so the door that you met him at that goes from the sally port into the facility, into the unit, is that locked?
It's not locked, no.
Okay. So you encountered him then at that second door from the sally port into the
coming into the area, yes.
Tell the jurors what happened when you encountered Mr. Snyder.
Well, when I encountered Mr. Snyder, I asked him what he was doing up in the area first, and then what he had on him that he had gotten from the trash.
And what was his reaction when you asked him about this?
He just responded, no, I didn't. I didn't get anything. So the officer, when he told it, he also reported that he had put it in his left shirt pocket area. That's the area that he saw him put something in.
Okay, and did he have anything in his hands at the time you encountered him?
I didn't see anything in his hands, but he did have 4 to 6 styrofoam cups in his shirt pocket. So I had him remove those, and I started looking between the cups. There was like a trimmer blade in between one of them. There was like 3 little pebbles between another one. And that's about as far as I got. As far as looking through, the rest of them were kind of clear. I didn't see anything in there. And I noticed he had something else in his shirt pocket, which I asked him for, and that's when he started swinging.
At the time you encountered Mr. Snyder, were you wearing the uniform of a corrections officer?
Yes.
Did you identify yourself as a corrections officer other than that?
Shouldn't have. No, I didn't identify that I'm dressed that way.
So when you asked him about the other item that was in his shirt, what happened?
He said something to the effect of, "You're not taken," and just hit me. I just reacted by going backwards and getting something in between us, which would be the door that I had my foot against as I came in, and he ended up following me and continued to assault.
Okay. When you say he hit you, what did he hit you with?
His fist.
And where on your body did he hit you?
The left eye was first. Got 2 stitches. Well, I got a big shiner.
Okay. So you got hit in the face?
Yes.
And you were pointing, just for the record, on the left side of your face? Yes. Okay. And did you use any force against him before he hit you?
Not then, no. I was trying to protect myself.
Okay. Did you threaten him in any way before he hit you?
No. I don't even know why he think I was taking his stuff. It was just, unless it was major, he wasn't in violation of anything besides being out of place.
And this is kind of a serious, I know, so sometimes I have to ask dumb questions, but so Ms. Gilmore can write it down. The strike to your face, to the left side of your face, did that cause you pain?
Well, yeah.
I told you it was a dumb question. Okay. Now
That's
you said
an
he
element of
hit
charge.
you once and then you went kind of back through the doorway. Did he continue to throw punches at you?
Yes.
Did he strike any other part of your body?
If he did, it wasn't as hard as that hit. I know there was another hit to the chest up here that fractured 2 ribs. And I'm sure there was some small ones, but those were the 2 major ones.
Okay. Now, you said that you had some sort of alarm or ability to notify other staff of a situation.
We just missed him. He's sitting next to the
Something
attorney with
to
a
alert
striped
other
tie.
staff of this assault?
The noise is what alerted several staff. I was keeping my hands above my head to keep from being assaulted up in the head area anymore, to put them down on my waist to activate the alarm. So no, in that short amount of time, I did not activate the man down alarm.
Okay. But did other staff respond when this happened?
Yes.
And what happened when other staff responded?
The other staff, Mr. Bolin was the first one to respond. He took him to the ground. I immediately helped him with trying to get him secured in hand restraints. Several other staff started showing up, trying to get him to comply with getting the restraints put on his hands, and he kept resisting. So we delivered body strikes to get the compliance done. Pepper spray was not used. I don't know why. It wasn't my call. I was instructed by another staff member that I was bleeding and to disengage. So I did, and the rest of the staff took care of the incident.
Is it fair to say, Officer Hopper, that this was a surprise to you that it happened?
Yes, because 30 years never had anything like that happen.
Fair to say that you were pretty, in terms of your reaction, your adrenaline's elevated, all of that?
Yes.
So before another staff member informed you that you were bleeding, were you aware that you had been injured?
I saw a couple drops drip from me as I was getting to help the other staff get restraints on him. So yeah, I knew I was bleeding, so I just didn't know how bad.
Okay. So other officers told you you're bleeding, disengage.
Mm-hmm.
At that time, what did you see? What did you perceive in terms of your injuries?
I wasn't sure. I didn't see anything yet besides some blood.
Okay. Describe what did you see in terms of the blood?
Well, it was all over my hands because I had put my hands up, of course, to block my head. It was on my uniform, running down my arms. It was running down my nose, running down the side of my face. It was a mess.
So, describe for the jurors what injuries that what happened after they told you to disengage? What'd you do then?
The nurse took me to the exam room back in the RTE unit. There's a nursing station back there. She got me cleaned up a little bit and said, "You got your nose broke. You're probably going to need some stitches." And said, you probably should go to the emergency room, whatever, have somebody take you there or whatever. And I was like, "I'll be fine."
Okay. Well, why was that?
Fine, let me finish the shift.
Just the job location, I guess. Of not. I was just more angry than anything else.
Just so we're clear, because we have to make the record for the jurors about what your injuries were. So, were you fine? Was there no injuries?
Oh, there was injuries. My nose was definitely crooked. After I went to the bathroom to go out and rinse myself off, my nose was crooked. I had a laceration here, and another laceration on my forehead.
Okay. So, again, Ms. Kilgore's got to write all this down. You pointed to a couple of places.
Okay.
It's all right. So, you said here. Where's that?
It's right on the side of my nose right here, on the inside, to the outside of my eye here.
Left side of your upper nose?
Yes.
Okay.
And then up on just above my eye on my forehead.
All right. So just make sure that
Okay.
you also pointed at your left sort of temple area, cheek
Yes.
area?
To the outer part of the eye, yes.
Okay. And then one that's laceration, a cut that was sort of the center of or to the side of your forehead?
Just above my eye, yes.
Okay. All right. You said that you did receive some medical attention from the medical staff that was on the unit at the time.
Yes.
Okay. And so what medical services did you receive from them?
They got me cleaned up. They wiped it down with some sterile water. Let's see, she gave me an ice pack to put on my eye and my nose. Basically just told me to keep the ice on it, 10 on, 10 off, 10 on, 20 off, or whatever it was. I can't remember that at this point. And I was pretty much relieved of duty that day and had to go fill out a lot of paperwork.
Okay. Was the medical opinion that you were given that time that you needed further medical attention than what they could provide on the unit.
Yes, they did say I need to go to either
Hold on just a
ER.
second. Ladies and gentlemen, I'm going to allow this testimony for the limited purpose of explaining why this witness did what he did next, not necessarily for whether that statement was true or that he needed medical attention or not. So why don't you go ahead and finish your answer if you remember the question.
Okay. Yes, they did recommend that I go get at least my nose checked and any other problems that I may have. So I took that advice with.
I'm going to show you what's been marked as State's Exhibits 4 and 5.
Here's the defendant.
Officer Hopper, I'm going to show you States 4 and 5 so you can take a look at those. First, if you could tell the jury, what is State's Exhibit number 4?
It's a picture of me, head on, showing the 3 marks and my nose being crooked.
And what is State's Exhibit number 5?
That is a side view of the lacerations in my eye.
And those photographs were taken on December the 23rd, 2024, before you went for further medical care, is that right?
Yes.
And do the pictures fairly and accurately reflect what the injuries looked at that time?
Yes.
I'm going to show you now States 4. And in front of you,
Come on, can we see this?
Oh, it doesn't work on there, does it?
Well, he should be able to draw it.
So you should see here, right? Just like kind of John Madden, you can touch, just don't touch the corners.
Like John Madden.
But if you could, you said that your nose was broken. Is that indicated on this photograph?
Yeah, you just need to take it.
Can you draw us a line of where the injury to your nose is?
From how I know my nose looked before, yes, it's broke.
Okay. Can you draw us a? To me, when I can't test.
Okay.
Right? So if you look at that, how can you tell that your nose is broken, Officer?
It goes like this.
Well, there's swelling here. It's crooked here. And there's swelling here even, down in this area.
Okay. Now, Officer Hopper, can you point out for the jurors, just you can draw circles, where are the lacerations that you, on this photograph that you had identified previously?
What is it drawing?
Okay, so there's a laceration here, a laceration here, and a laceration here.
And it looks like there's an area of redness sort of around your left cheek area as well. Can you describe what that is?
It looks like dried blood.
Okay, that's not swelling or
Well, it's
bruising or
swelling,
anything
but
like
it's
that?
dried blood's the color.
Sorry, we can't both talk at the same time because Ms. Kilgore's got to write it down. So, was there swelling or bruising or anything to that cheek area?
Yes, there was swelling and bruising.
Just so we're clear
probably
again,
laughing
these
like
injuries
crazy right
resulted in pain to you?
Yes,
You were feeling pain at the time that before you went to get medical treatment at the hospital?
yes.
Can we clear that?
This doesn't
Somebody-
open down here, right?
Can we clear it?
It's like a full-
We think they broke it at our last trial.
Okay.
They broke it.
There we go. All right, I'm going to show you now State's Exhibit number 5.
Thank you.
Officer Hopper.
Thank you. Wow.
This is what you identified as the side view. And does this photograph fairly reflect the injuries that you had identified on States 4, just from the opposite angle?
Yes.
Now, Officer Hopper, you indicated that you were wearing a body-worn camera during the time that you interacted with Mr. Snyder.
Yes.
I'm showing you what's been marked as State's Exhibit number 1. Have you had an opportunity to review the body-worn camera from your interactions approximately 1:45 p.m. until 2 o'clock p.m. On December the 23rd, 2024?
Yes.
And does this video accurately record your interactions and your actions during that time?
Yes.
Your Honor, at this time I would offer States 1 to the jury.
You may proceed.
They've announced the intention to upgrade the shooter's charges to first-degree murder up in the Vance Bolter case. Putting it in the player. Here we go. 4 hours of deliberation so far. OnlyFans spin in the corner. We're keeping you up to date. As soon as we hear something from the jury, we will let you know. This is going to be body camera footage, so there may be some language here. Just warning.
You're what? I'm sure exactly what all is in here.
I'm sorry, that fridge needs to be cleaned out.
I didn't see it last hardly.
Get some potato chips, something. Yeah, fried chips.
There's no potato chips. These are potato skins, and those are like Tostitos.
I'm cool on the pie.
You what? You cool on the pie?
Yeah, look a little bit rough, man.
Yeah. Make work of them things then, I guess. I'm gonna get this thing rinsed, that washed out cherry. I don't think they ever even opened either one of these. Yeah, neither one of these even got opened.
Alright, even better.
Say what? Oh, goodness. That goes to the closet, huh?
Are we going to watch this whole shift? You can wash your dishes and do a quick eye test in the same place. We're watching this whole shift. You ever wonder what it's like to have a career in corrections? Here it is. No soap, just doing a quick rinse. Five paper towels.
Good.
There you go. Just your lights and stuff. There's stuff on the ground. You're what? Stuff on the ground. Can't be picking stuff off of. Man, what's wrong with you? Oh. No. Can I have it? No. What else you got? Stuff I have, man. Hey, what? Just rocks and stuff, man. I collect rocks, man. Why are you taking my stuff from me? What? You're getting caught out on the road. Oh, you motherfucker! Go! Right there! You motherfucker! What the fuck is wrong with you? Get here, motherfucker! Everybody back! Everybody back! Come on! Get him up, bitch! Put your hands behind your back, motherfucker! I got him! Let go! Up off! Stop! Back off, Finley.
Why is Santa Claus there? Can someone... Santa Claus responded.
You get it fixed?
Motherfucker.
Right here? Yep.
So we wash dishes here.
Okay.
Let's get that clean. When was your last tetanus shot?
3-4 years ago, maybe. Oh, it's my glasses got me again.
What hit your head?
Say what?
What hit your head?
Where at? I don't know what you're talking about.
The wound on your head.
Oh, these glasses. Oh, my glasses.
All right. Do you know when your last tetanus shot was?
No. Where the fuck am I bleeding from?
Okay. Let's take a look at it.
You good?
All right.
Where am I bleeding from? My nose?
You've got, you're up on the left side of your nose and then the left side of your eye, okay?
Is that vegetable oil she's spraying on?
It looks like you're gonna need some.
Looks like your nose is again. It's pushed.
Yeah.
Motherfucker.
Yeah.
I'm doing beautiful, bud. There you go.
So it's just saline, okay?
This is a little Pam. We're going to put a little Pam on it. Rub some bacon on it. Our new mom thinks. That was amazing. I'm sorry. That was amazing. Oh, wow.
Now, Officer Hopper, I think you made a statement on that after the assault where you made reference. You said, "Looks like my glasses got me again." What was that in reference to?
I was also assaulted last June.
Okay, so the fact that you had recently to this been assaulted, did that play into sort of your reaction to this assault?
They were pretty much totally different. The circumstances under the first one, I'm not sure what his issue was, but in my opinion, I was doing my job on both of them, and they just took it personal.
Okay. Was the fact that there was a second, I mean, you've been working there for 30 years now. In the previous 30 years, have you ever been assaulted by an inmate?
No.
Okay. So twice in 1 year, you get assaulted in a similar kind of injury. Is that fair to say?
Similar, yeah.
Okay. So did your reaction, obviously, very angry. I think you said that before, after Mr. Snyder struck you. Did the fact that this was the second time within a year of being assaulted in this, did that play into your reaction in terms of that anger?
I'm sure it did. Actually, the assaults were 6 months apart, but yeah, within the past year, it's happened twice.
Okay. Now, you said, so I think we saw some first aid treatment that was given to you there in
Both times he broke his
by
nose?
medical staff at the prison, and you said there was a recommendation to go and get some other care. Did you go and get, that day, did you go and get other medical care?
Yes, after I got done doing my paperwork and the things necessary to be able to take leave, I drove myself to Atrium ER where they took a x-ray of my nose and head x-ray and did 4 stitches and glued my forehead.
Okay, so let's talk a little bit about that. So let's, first of all, you said you got 4 stitches. Where were the 4 stitches?
2 were on the nose and 2 were to the outside of the eye.
Okay, so the 2 injuries that you had previously indicated there, on states 4. Two stitches in the left temple area, left of your eye, and 2 stitches here on the inside left side of your upper.
Don't draw where the stitches were this time.
You said that also they glued a laceration, is that right?
Yes, the laceration on my forehead they glued.
Okay, and that's the one again, sort of just above to the left side above your eyebrow there.
Yes.
In addition to the stitches and glue repair, did you receive any other medical diagnosis on that day?
On that day, no. After the pain went down from then, just after I...
Hold on for a second.
Okay.
We have medical records from Atrium from that day, and it says in addition to these injuries, you had another injury. Did you receive any fractures? Or?
Well, I hadn't realized it at the point, but yes, there was 2 in the 2 fractured ribs, ribs 7 and 8. Those were actually diagnosed later.
Officer Hopper?
Yes.
Did you receive any fractures to your face?
Oh, my nose.
Okay.
Yeah, my nose was definitely fractured on the x-ray.
I know you had other injuries later, but I want to make sure the things that were diagnosed on that day, 3 lacerations with repair on that day, and then a fracture to your nasal bone, right?
Yes.
Okay. In addition to the medical services you received on that day for the laceration care, did you have to have some additional follow-up medical care for that nose fracture?
Yes, I made an appointment with the ENTs in Troy for Premier. They made an appointment to fix my nose, which was pretty quick. They wanted to do it within 10 days, so I believe I had it done in 7. So it was the 30th, I believe, of December, to where they repaired my nose and straightened it back up.
Okay. At the time you were discharged from Atrium Medical Center, were you given pain medication?
Yes.
And what was that?
Hydrocodone, Vicodin.
Okay. And do you remember how much Vicodin they gave you upon your release?
I mean, hydrocodone?
Kind of disappointed, but they only gave me 7 days worth, which I think is 14 pills.
Okay.
I was hoping for more.
Did you take the full course of Vicodin then for 7 days?
Yes.
Did you continue to experience pain from these injuries for those 7 days?
Yes.
Okay. Now, you said on December the 30th you had services at Premier Health in Troy related to the nasal fractures. And what was that? What did they do for you on that day?
Well, re-broke my nose, of course, and straightened it. About all they did, really, and gave me some more Vicodin when I left.
Okay. Was this an inpatient or outpatient service?
I was an outpatient service.
Okay. And how long were you at the hospital on December the 30th?
About 6 hours.
Between December the 23rd and December the 30th, did you return to work?
No.
During that time, you were taking pain medication. Did you have any other medical difficulties related to the injuries to your face during that intervening 7 days?
Well, I wear a CPAP at night. And when you have a broken nose, everything kind of swells, and your CPAP doesn't work too well. So, difficulty sleeping, for the breathing, not to mention the nightmares and everything else of what else I could have done and all that running through my head.
Your Honor, I previously referred to State's Exhibit number 3. Those are the Atrium medical records for the victim's treatment on December the 23rd of 2024. Those have been stipulated by the defense.
Noted.
Now, so a week of pain medication, an additional outpatient procedure. You said they gave you Vicodin on that day as well, prescription pain medication. How long, what amount of Vicodin did you receive following the service on December the 30th?
I received 2 weeks this time, but it was for also twice a day, so it was about 28 pills. Those went through in a couple weeks also.
Okay. Did you take the entire course of 14 days of pain medication?
Yes.
Did you continue to experience pain related to the injuries to your nose and your face for those 14 days?
Yes.
So now we're 3 weeks out
Judge
from the
looks
date
stern.
of the assault, and you are still experiencing pain related to this that requires prescription pain medication.
Yes.
The extended period of pain is one of the elements of the charge.
You mentioned that in those intervening 7 days before the outpatient surgery that you had difficulty breathing and difficulty sleeping related to your, breathing related to the CPAP. Did that continue even after your outpatient surgery?
Yes, it started, this started to clear up a little bit better, and then when I could breathe deeper, I started noticing chest pains up here when I breathe deep. So I called the Bureau of Workmen's Comp and got an appointment to see another doctor about that.
And so I think you testified, was there some other additional injury related to the December 23rd assault that you had not previously received medical care for?
Yes, so apparently on the Vicodin, since it's a pain reliever, kind of masked up and I wasn't able to breathe deep either with a nasal injury. Once I could start breathing deeper, that's when that started hurting. So I had a chest x-ray done, and then a CAT scan, and then an MRI, which all had to be later and put out because I had authorization through BWC.
Okay, and the examination, x-ray, CAT scan, what did it reveal in terms of the injuries to your chest?
Fractures to ribs 7 and 8.
And did you receive medical care related to that injury, other than the examinations?
Basically, there is no treatment they can do for it. It's just to stay inactive and try and get those to heal up, just give them time to heal. So it's time off of work still.
So in terms of rib fracture, you just essentially have to wait it out. During the time that you were waiting it out to heal, did you continue to experience pain related to that?
Only when I breathed.
Only when I breathed.
Okay.
The days I didn't breathe, I was good.
In addition, did it interfere with your ability to breathe?
Yes.
Now, you left work on December the 23rd related to the injuries from your assault. How long was it before you returned to work at Warren Correctional Institution?
I believe I didn't return to work till around March 12th.
March 12, 2025?
Yes.
Okay. So in total, about 3 months total that you missed in terms of work related to these injuries.
Yes.
Those are all the questions I have for you.
Intern's falling asleep.
Mr. McKenna, you may inquire.
Cross-examination. Defense is hoping for just a lesser conviction. We're not saying we didn't do this. Obviously.
Sir, you've been working at the corrections facility for 31 years, you indicated?
Yes.
Okay. And when you work there, you have a pepper spray?
Yes.
Okay. And you wear a uniform, as we saw, correct?
Yes.
And you carry keys?
Yes.
Because it's a lockdown facility, correct?
Mm-hmm.
Okay. So would you agree with me that your job does entail some risk?
There's always a risk at any job.
Okay.
Yes.
But in your particular situation, the fact that you have to carry pepper spray would seem to indicate you might have a heightened potential of being harmed in your job. Would that be true?
Or to control situations, yes.
Okay. And you were working that day in the service area of the mental health part of the prison, correct?
Yes.
Okay, and the service area is where people come in with some sort of treatment that they need. Would that be accurate?
They can't just, they're not supposed to just walk in.
Okay, okay. But you need a pass to get in, correct?
Yes.
Okay. Are you aware if Mr. Snyder had a pass or not?
Yes, I am aware he did not have a pass.
He did not have
showed
one.
me a pass, but it was not for that area.
Okay. And you met him at the door, correct?
Yes.
All right. And then it looked like on the video, he had some styrofoam cups, correct?
Yes.
Are you allowed to have styrofoam cups?
Yes.
Okay. And styrofoam cups are not a weapon or anything like that, obviously.
They're not what, please?
They're not a weapon.
No.
Okay. And he had some pebbles?
There was a few little rocks between a couple of the cups.
Okay, when you say, I mean, they weren't like a baseball-sized rock.
No, they were
small.
pebbles.
Okay. And then there was something else he had in the cup. What was that? I couldn't see.
Well,
it.
there was a little adapter thing, piece for headphones, and there was a trimmer blade between another cup.
Like what's a trimmer blade?
Trimmer where they like do beard trimmings to cut hair with and stuff of that nature. Trimmers.
Was it small?
Yes.
Okay. It wasn't a knife or anything like
No.
that? Okay.
They're allowed
Not a
to have
shank
those.
or anything?
Nope, they're allowed to have those.
A trimmer blade.
You said they're allowed to have it? Yeah, okay. All right, and then it appeared, well, let me backtrack. You indicated you had no memorable interaction with him, correct?
Correct.
If you did, it would have just been in passing, wasn't anything where you had some sort of argument or anything like that?
Correct.
Okay. And then we saw in the video, it appeared you were asking questions about the items he was carrying. Would that be true?
I didn't have questions about him. I was questioning what else he had.
Okay. And then at some point, it sounded like you started asking about what was in his pocket?
Correct.
Was that his shirt pocket?
Yes.
Okay. Did you see something in there, or were you just asking?
Yes, it was bulging. It was
Okay.
something round.
Okay. All right, and then it looked on the video, then at that point you got hit?
Yes.
Okay. How many times did you get hit in the face? Was it one punch?
One that I know of.
Okay. It looked like it was one in the video. Okay, and then, would you agree with me there? You came back and hit
As
you
far
right.
as that video goes, yes.
Okay. And then, you stumbled backwards, correct?
Correct.
Okay, and then there was would it be fair to say that was a scuffle between you two then at that point?
Yes.
Okay. All right, and then we saw that other people then arrived and assisted you?
Yes.
Okay. Now, after that occurred, you said you had to stay there and do some paperwork, right?
Yes.
How long did that take?
Hour and a half, probably.
Okay.
Talking to OSP and doing the paperwork, yes.
Okay. And then you drove yourself to the hospital?
Yes.
Okay. Was it in the car that you went to work in that day?
Yes.
All right. You had mentioned that you were on used a CPAP?
Yes.
Is that to help you breathe at night?
Yes.
Okay, so that was something that you were using prior to this incident, correct?
Yes.
So you were having difficulty breathing before this?
No, not breathing. Sleeping.
Sleeping, okay. But that's something that you were using prior to this, though, correct?
Yes.
Okay. You also indicated on direct that you had been assaulted, you were asked about being assaulted 6 months earlier.
Yes.
You remember that? Were you injured in that?
Yes.
What were your injuries?
Had a contusion to the left side of my head and black eye on the left side and a broken nose.
Okay.
Broken
Thank you.
nose
No further
twice.
Anything else for this witness?
Nothing on redirect, Your Honor. Thank you.
Thank you, sir. You can step down. You're free to go, or you can stay if you want. Next witness?
State calls Trooper Mr.
Might get another body cam. I was amazed that Santa Claus was there, but that Santa Claus joined in immediately. I thought he just kept a list, and he's like, oh, bad, naughty, check. No, he's willing to throw, he'll throw down. He'll be like, let's go, let's do this right here.
Morning, sir. If you could state your name, spell your first and last name for the court reporter.
It's Christopher Creech. It's spelled Christopher, last name is C-R-E-C-H.
And how are you employed?
I am a trooper with the Ohio State Highway Patrol.
And how long have you been with the patrol?
A little over 19 years.
And what training and experience do you have that qualifies you to be a law enforcement officer in the state of Ohio?
All troopers entered the Highway Patrol Academy. You have to graduate when I went through, it was 31-week training course, learning criminal enforcement, traffic enforcement, criminal investigation, traffic crash investigations, anything that's involving anything to deal with state property or owned or leased property.
Now, most people's interaction with the State Highway Patrol is probably traffic related, right?
Yes.
Is that the kind of work that you do?
No.
And what's your assignment?
My assignment is we're our Office of Criminal Investigation, so we are involved in investigating anything involving felony crimes on state property or involving investigations with road troopers that lead to more in-depth investigation.
Okay. And so what, do you have I called you trooper, but is that your title?
It's actually investigator.
Okay. So, and how long have you been in the criminal investigation unit?
About 3 years.
Now, were you on duty on the afternoon of December the 23rd of 2024?
I was.
And were you did you respond to the report of an assault at Warren Correctional Institution?
I did.
And how did you become aware of this report?
So the prison has also their own internal investigators, which we work hand in hand with. They're essentially like our liaisons for the prison. Investigator Jason Hall reached out to me and contacted me that they had an assault involving a CO and an inmate.
Okay. And so what did you get this information from Investigator Hall at the prison? He contacted you by phone?
Yes.
By phone?
Yes.
Okay. So what was the initial information that you had?
Correctional Officer Hopper was working the mental health unit and that he had stopped an inmate that was entering the health unit and that he was assaulted by that inmate.
Okay. And the location where this occurred, the Warren Correctional Institution, you said you investigate crimes on state property. Is Warren Correctional a state detention facility?
It is.
And it's located here in Warren County, Ohio?
It is.
And did you receive information about the suspect, the inmate that had done the assault?
Yes, I've received that he was an inmate that was housed there at Warren Correctional Institution and that he was being held at the facility for a crime they commit in the past.
Okay, so just so we're clear, kind of one of the things we have to prove, he was under detention at the facility, right?
That is correct.
He was an inmate, not an employee or a contractor or visitor or whatever?
No.
Okay. And you confirmed his detention status at the time of your investigation?
That is correct.
Okay. And what did you do when you arrived at Warren Correctional?
So myself and Trooper Clance, who was my partner for the day, we arrived there. We interviewed Mr. Hopper and also Mr. Snyder. I interviewed Mr. Hopper while Trooper Clance interviewed Mr. Snyder. Some photos were taken of Mr. Hopper, and we reviewed some video footage while we were there also.
Okay, so what we have seen as states 4 and 5, those were photographs that you took on that day to document.
That is correct.
Those photographs, states 4 and 5, they accurately reflect the injuries that you observed to Corrections Officer Hopper on that day.
They do.
Now, you said that there was some video that you had reviewed. What is that? The body camera video that we just watched?
Body camera and also cell block footage or surveillance footage.
Okay, so I have what's in front of me marked as State's Exhibit number 2. It's a little USB stick that contains cell block video of this incident. Have you had an opportunity to review this?
I have.
You confirm this is the cell block video that you received or that you reviewed and received from the prison on that day?
That is correct.
And just for the record, Your Honor, defense counsel has stipulated a foundation from this.
Noted.
Okay, abbreviated foundation. Looks like we're going to be
This
more
time,
video.
Your Honor, I would offer State's Exhibit number 2, the cell block video for the jury.
Yeah, I'm impressed.
About how long is it?
It's a much shorter, maybe not more than 4 minutes, I think. It only covers the stuff that happens at the doorway.
We don't get the whole giving chips to inmates part. Okay. Watch for Santa Claus. Watch if Santa Claus throws any punches.
And this is only video recording, is that right, Trooper Creech?
I'm sorry?
It's only video recording, it does not include audio.
That is correct.
X-Protect? What app is this? This looks like a proprietary security system. Oh, wow, we get to see it through like the... I'm going to turn me off here.
So there are 3 videos indicated there, identified as WCI Building 5 Outpatient Officer, WCI Mental Health Entrance Foyer, and WCI Mental Health Officer Front Hallway. These videos, am I correct, they all run sort of concurrently at the same time?
They do.
We're going to review them sort of individually, beginning with Mental Health Entrance Foyer.
I'll be over here. Oh, I guess I'm okay right here where I was. Watch him shift his weight. And goes back. Boom. Yeah, it caught him off guard. For sure.
Is there anything else you want to see on this video? Your Honor, just for the record, I'm going to stop the entrance foyer video at 150.
Noted.
Okay, which one are we going to next?
Now referring to the video marked WCI Mental Health Officer Front Hallway.
See where Santa comes from, if he just materializes. Gave him your back. Whoa. That guy just like landed on his head. Dove and landed on his head. And there's Santa. Getting a few blows in. Yep, immediately starts swinging. Santa's still punching. Both hands now. Everyone else has stopped. Santa's still throwing.
Mr. McKenna, is there anything else you want to show for this video?
Not so
Your Honor, for the record, I'll stop the video at 150:30.
Noted. Ladies and gentlemen, just so you know, you're going to have these videos with you in the jury room when you deliberate. So you're going to have a computer, doesn't have internet access, but you're going to be able to look at these and run them back or watch more or whatever you want to do, because the attorneys have stipulated that the entire video is going to go into evidence. Go ahead, Mr. Bean.
Just wait for Mr. Roca to switch us back.
Here comes Santa Claus. Here comes Santa Claus. All right, one more view. This is we get to see Santa around the corner. I just want to see the look on his face.
And finally, WCI Building 5 Outpatient Officer.
You can see in the reflective mirror the altercation happening in the door, in the little dome mirror. Okay, 28-second mark. That's when the attack started. 28 seconds. Took less than 10 seconds for the first person to show up. Santa's elf comes around the corner. Boom! Santa rounds the corner, almost checks the wall, goes right in. Wow. The elf's holding back. It's like, nah, I'll let you guys do this one. Then the real Santa, in disguise, waits by the exit.
And again, Your Honor, I will pause the video at 1:50:27. Mr. McKenna, anything else?
Noted. Investigator Troop, in addition to the video that we just reviewed, the cell block video, did you also receive then what's been marked as State's Exhibit number 1, the body-worn camera as part of your investigation?
That is correct.
And you also gathered medical records that we've seen as marked as State's Exhibit number 3.
Yes.
And then you submitted the investigation to the prosecutor's office for prosecution.
That's correct.
No further questions for the witness. Thank you, Judge.
Mr. McKenna, you may inquire.
Good morning, Investigator Creech.
Good morning, sir.
Sir, you work with the State Highway Patrol, correct?
That's correct.
The past 3 years, you've been an investigator.
That's correct.
And you describe that as you go in particular into state prison systems and investigate allegations, correct?
That's correct.
And you did that in this case, correct?
That's correct.
You did the job you're supposed to do, correct?
That's correct.
You did not actually see the event occur, though, correct?
No.
Okay. So you have no personal knowledge of what actually happened?
No, sir.
Thank
or
you.
even if it happened.
Nothing on redirect, Your Honor.
All right, thank you. You can step down.
Those
At this
questions.
time, the state rests. We would move
state
to admit
rests.
State's Exhibits 1 through 5 at this time.
We might get some.
Ladies and gentlemen, it probably makes sense to go ahead and break for lunch at this point. So what I'm going to do is we're going to break until I have some stuff on the docket. So let's plan on being back here at about 1:15. Remember what I previously told you, don't do any research about the case on the internet. Don't think that you can be in a position to start deciding the case, talking about amongst yourselves. There's that very dangerous period where you come back from lunch, maybe filter in. You don't really have anything to talk about other than your one common experience, which is here today. Don't talk about that. Talk about the other things that have been going on. Because you don't know enough about this case yet to decide how it should come out. And we will plan on being back here at 1:15.
Defense files. Makes a JOA motion. What? The interns think that they get to leave, but they can't yet. It's not time yet.
Ms. Burns, would it help you next time if we moved you to the end so you're closer to the walker? All right, we'll make that adjustment when we come back.
Just doxed one of the jurors. Thanks, Judge. Miss Burns. Let's make her an alternate.
You may be seated.
All right, defense.
We are on the record outside the
JOA.
presence of the jury. Any objections to 1 through 7? No, 1 through 5.
Oh, this is straight into charge conference.
All right, 1 through 5 will be admitted.
We would make a Rule 29 and submit.
All right, court does find the evidence, when viewed in light most favorable to the state, is sufficient to sustain a conviction. So I am going to overrule the Rule 29 motion.
That was the judgment of acquittal. That was the
Just
whole
for planning
argument of
purposes,
motion.
Mr. McKenna, have we made a decision as to whether or not Mr. Snyder is going to testify after lunch?
He's not, Judge.
Okay,
We
so
would rest.
I'll go ahead and make that adjustment to the jury instructions. I did take out expert witnesses because I don't think we have any expert witnesses. Other than that, I have not strayed too far from the OJI. Mr. View, I am not going to grant the state's request for the additional jury instruction. In theory, it's an accurate statement of the law, but I don't want to have the jury influenced by the decision to seek medical treatment. Based on the facts in this case, I'm not going to permit that additional instruction. So let's plan on being back at 1 o'clock so that we can talk about any issues that we have in the instructions and the verdict forms. And we'll see everybody back here then.
Thank you, Judge.
Thank you, Judge.
The judge squints at people.
All right, we're in recess.
Recess.
I have to be here at 1 for another. You said 1 o'clock or 1?
What time did you say?
1 o'clock, so
1
we can
o'clock.
talk about the jury instructions?
Second.
15 minutes, 20 minutes, what do you need for closings?
20 minutes, just
All right, make it easy on yourself, I don't care.
20 minutes.
Okay, all right, that's all.
So now the mic's off. That means might be done. Judge takes his laptop and goes home. Styrofoam cup, phone. Inmate's getting prepared to be moved back to a holding cell. Okay, 1:15. That means we get about an hour and 15 minutes before we continue. I'm not sure if the live stream is going to continue. Like if it's just going to go and go and go. Oh, he goes out the same door everybody else does. That's interesting. Defense chuckling is like, yeah, you've pretty much got us on this one. But, you know, what do I say? He's guilty. We've got no case. I don't know why we're here either. Yep. You're going to win this one. Yeah, I'll give you that. Had to try. The feed stays up. Prosecutor and defense are clearly cordial with each other, at least. Stacy, thanks for the update. Yes, we did see just last week, we got the updates. Corey Richens' trial, the other KR case, is not going to happen until next year, February 23rd, which means it's going to be like right after Koberger. If Koberger doesn't get delayed, August, September, October, November. So we got a couple months break between the two. But yeah. He's smiling because he's still getting paid. I see the attorneys actually friendly with each other. It's looking good. Styrofoam cups all around. Richens is still in custody. Yes, she is. Previously, prison dude was incarcerated for assault. I am surprised he's not shackled in the courtroom. That he's completely free. If he's got a quick temper like that. Is the Koberger trial going to be on YouTube? It will, right here on this channel. Living Ghost, thank you. The shooter was transferred to federal custody. Love me some bad lip reading. Yeah, that's good times. I'm only here to fulfill my public defender hours to get the discount on the renewal for my dues. Might have a zapper belt on. Still free to throw a punch. Yeah, and he's You can see I mean, he did that blow. That first blow is what did the damage. It only takes one hit. What kind of laptop is that? Prosecutor is completely disengaging, unplugging, putting everything away. Don't take the cable. That belongs to the styrofoam cups, of course. We've got more of those. Let's see, what is that? It looks like a power supply. Just stuff that in there. That's good for the cord. Nice. It's actually a little better than winding it tightly around your hand. Okay, there's the case file. Nope, that's the legal pads. We won't be needing those. Jam that in there. Highlighter. See what else we can take. Anything? No soap, no shampoo. No, we've got it all. All right. It's a nice bag. That bag may have cost more than my suit. Is this case over? No. We're waiting. The jury gets instructions. They come back at 1:15. So we're going to take a break. I think we're going to be here for the break because we've got audio. Here's the thing. We can't really take a lunch because at any moment the jurors in the Karen Reed trial may come back. They may be deliberating through lunch. They might just be plowing ahead, trying to get to a resolution, and it could happen any time. So we're going to just stick around and wait, see what happened. And then if we get word that there is a verdict, we're going to stop and restart, I think. Let's see. The juror that showed up in the t-shirt and shorts has worn that before. So it's not like he dressed down for deliberation day. Domino's Pizza on Twitter posted and asked, tell us your favorite topping, wrong answers only. I posted spicy maple bourbon pickles, and Notorious Jules says this is so gross. Yeah, it was a wrong answer. They're yucky on pizza. Not good. Not good. So here's the dilemma. We most likely are going to have verdict music right before verdict music. We're going to have a verdict in this little trial we're watching, and we'll have to play the music, as is the rule, but I don't want anyone to be confused and think it's the verdict music for Karen Reed if it's not. So we'll keep the little fan and the counter going in the corner, but I'm sure there's going to be some confusion. We will only stop and restart the stream if there's a verdict in the Karen Reed trial. If there's not a verdict, we'll just keep this going, and we'll have one stream all day long. Does that work? I'll just get up and walk away and have lunch. We need a B-trail verdict. Yeah, we'll get a warm-up for the Karen Reed verdict. We'll test the music button, make sure it works. Play the music backwards. I don't know if I can. Probably could, but... Can we have a mega mix, please? I wonder if we could mix Big Dill into the verdict music. What AI tool would do that? What AI tool lets you mix your songs and do a mashup? Upset Baguette, we did not play the verdict music in the trial the other day because we did not watch the verdict. But I can tell you, I can spoil it for you, not guilty. That was the lady who took a picture of her neighbor's fence and was charged with stalking and harassing. Not guilty. Sing the verdict music for this trial? I'm not very good at that. It has been a long time since we've had verdict music. Another win for Roe. Yes, I tell you, she's unconventional. She's not polished, but she gets the job done on defense. Very impressive. I'm tempted to leave it right here. I don't want to miss anything that happens in this court. Maybe we can put a little notice up here. Let's see, where would it come from? It would have to come from this computer over here. How about that? If I just put this on the screen like this, boom. And I'll move it up so it's not in the way. So we can see the fan. We'll keep watching this courtroom, so if something happens, people come in and start talking, that'll happen. And then I get to go to lunch, and we just won't stop. Does that work? So everyone could just have this on in the background? Entertain us with slow-mo. I cannot, I'm recording the fan right now, and I went to record the other one, and it's trying to record in 4K, which is not helpful. I need it not to record in 4K because the codec doesn't match the stream. It's not working. Can't do replays of Santa Claus. So what will we do while waiting for 2 verdicts? Another even shorter trial? All my watchers are tied up. Let's see, where is this coming in at? We're bringing in the replay. Oh, I actually do have another watcher. We can, but its audio is poor. Okay, hang on, I'm trying to get this configured right so we can get this to work. Need to change the video to be 1080. It's not liking it. All right, I will pin that message as well, Josh. That works great. Break until 1:15. All right, I'm going to get up and I'm going to go eat some lunch. And then I'll be right back. It's probably going to be short, so we will... let's see. Where's my other little comment that I had? There we go. I'll put that one up. All right. I'll see you in a little bit. Should I play some music so it sounds like I'm actually left? Here we go. Be right back. Not stopping the stream, though. Just give me a minute. Or 20.
think I'm about to catch a whooping.
I'm not a cat.
There's nothing in the order that restrains you from talking to cats.
Thank you. Is that correct?
Hear ye, hear ye, hear ye.
Shame on you, sir.
I was kicked back, taking it easy.
I don't like podiums, Your Honor.
The zombie apocalypse may be upon us.
When are we going to break for lunch, Judge?
Alex stolen as well.
What more do you need to see? Because he's the guy.
Have them send someone with more experience.
Don't miss the forest for the trees.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm not going to argue about semantics here.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Because he's the guy. When are we going to break for lunch, Judge?
Are we going to address subject matter jurisdiction?
For the record, I don't consent to that name.
I don't like podiums, Your Honor.
In front of the Walmart.
Happy birthday. You look good.
I'm not a camel. Somebody just sent me a video of roaches fighting. I don't know who won.
Hear ye, hear ye, hear ye.
Bring the jury.
Squirrel.
There's nothing in the order that restrains you from talking to cats.
Thank you.
I think I'm about to catch a whooping.
I don't like podiums, Your Honor.
I'm not a cat.
I'm not going to argue about semantics here.
Bring the jury.
I object.
Are we going to address subject matter jurisdiction?
Alex stole it.
Because he's the guy.
I'm not a camel.
This is not Burger King. People do not get to have it their way.
Have them send someone with more experience.
Don't miss the forest for the trees.
You're talking about stuff that is not relevant.
Hear ye, hear ye, hear ye.
I think I'm about to catch a whooping.
Happy birthday. You look good.
I'm not a cat.
Are we going to address subject matter jurisdiction?
I'm not going to argue about semantics here.
Shame on you, sir. I object.
Alex stole it.
I was kicked back, taking it easy.
Have them send someone with more experience.
How does he do that?
There's nothing in the order that restrains you from talking to cats.
Thank you.
I don't like podiums, Your Honor.
In front of the Walmart.
I think I'm about to catch a whooping.
The zombie apocalypse may be upon us.
Hello? Hello?
Thank you, sir. You're my new best friend.
Hello? They hung up. Sorry, I was going to do a prank call. Back to lunch.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm not going to argue about semantics here.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Don't miss the forest for the trees.
You're talking about stuff that is not relevant.
I'm not a camel.
Have them send someone with more experience.
Are we going to address subject matter jurisdiction? For the record, I don't consent to that name.
Grand jury.
Hear ye, hear ye, hear ye.
Don't miss the forest for the trees.
And now let Murdoch stall it.
Are we going to address subject matter jurisdiction?
There's nothing in the order that restrains you from talking to cats.
Thank you.
I'm not going to argue about semantics here.
Bring the jury.
Thank you, sir. You're my new best friend.
Happy birthday. You look good.
The zombie apocalypse may be upon us.
Scratch all that. Oh, that was terrible. I apologize.
Somebody just sent me a video of roaches fighting. I don't know who won.
Have them send someone with more experience.
Because he's the guy.
Don't miss the forest for the trees.
Alex stole it.
Alrighty, I'm back. Wasn't really ever gone, but sidebar is not working. Why is sidebar not working? Let me check.
I think I'm about to catch a whooping.
Let me turn the volume up so I can hear it.
When are we going to break for lunch, guys?
Commands. I've got a new one to watch while we wait for this case to come back. Just one second. And thanks to Josh for that as well. Sidebar. Ooh, it doesn't like it. Oh, it's because Big Dill went missing. Well, that's an easy fix. Hang on. Network, Cloud Dock, Big Dill. Now I need sidebar. There it is. Copy. And we're going to go back to Macintosh.
I was told counsel wanted to see me at sidebar.
There it is. It's that quick. It's that quick. I mean, I fixed it, but I want to fix it better. Well, no, it's good enough. It's working. It'll break again, but I'll leave it like that because, halfway is as good as good. As good as used, as another fellow YouTuber would say.
Hear ye, hear ye, hear ye.
All right. We've got another case to watch. And I think it's going to be short. Let's see, 10 minutes. It's 15 minutes maybe. Let me check the schedule. Could jurors petition the court to amend the verdict slip? If they sent a question to the court and said, we don't understand how to use this verdict slip, it doesn't make sense, then it would hold a lot more weight. But Red sent a Canva link. Run out of ways to get things to. Okay, I could do it. To go to Canva, then join Red's team. There we go.
There's nothing in the order that restrains you from talking to cats.
Thank you.
It's not showing up.
I was told counsel wanted to see me at sidebar.
Do I have to join every single time, Red? I thought I was like on your team. I could see everything you do, but. If the jurors did send a question, I think it might prompt at least instruction. Can we please get Runkle's clip back? It's my favorite, but I don't see it on the list. I've got it. I don't think I've ever given it to you.
In front of the Walmart.
It's this one.
Because we here in Canada hate you and hope for bad things for you. Because we hate you.
Because he's the guy.
Okay, Red, hang on. There it is. Opening Canva.
I'm not going to argue about semantics here.
Ohio versus Jason Snyder. All right, here we go. We've got.
About to catch a whooping.
Here's Red Pen's thumbnail for the court case that we're about to come back to. The one that's on full screen right now. When it comes back from lunch, the jury's going to get instructions. They're going to start deliberating and hopefully return a verdict very quickly, probably within about 10 minutes. Here is the thumbnail for this one, courtesy of Red Pen. Ohio v. Jason Snyder. We've got. It's all there. It's all there. Rock'em Sock'em, Styrofoam Cups, Santa Claus Boxing, Body Cam, Injuries, everything but the potato chips. But it looks great, looks great. All right, give me just a second. We're going to bring you one more trial while we wait for this one to come back. And it's actually something that just happened today in Judge McNally's court. So let me bring this up and make this full screen for you. So we'll get some audio going. There we go. And I think we're lined up. Let's do this.
Thank you. All right. Donald versus Ronald Pittaway. 2502023. Who's Donald? Who's Ronald? Come on up here.
They're both down.
Your name, sir?
He's
He's Donald Pittaway Sr., I'm Donald Pittaway Jr.
Well, who's the plaintiff? I can't even tell.
Me, but my father was the homeowner and stuff, and we had a discussion about that last time we were here in court.
Who's a red shirt?
Wait a minute. Who filed the claim?
I did.
You can't do that. Didn't I tell you that? Did I not tell you that?
Tell me.
Did I not tell you that?
Yeah, you said something about, well, you're not the homeowner.
Well, and so I adjourned it. You got to get a lawyer to handle this for you, sir.
I did.
It's not for you, it's for him.
I did wind up contacting an attorney. I don't have I can't meet with him until June 30th.
Your name?
Ronald Pittaway.
Who owns this home? You own this home? Yes? I can't hear you.
Yes.
And you're Donald Pittaway Sr., right?
Yes.
And where's the property? On Maple Lane?
No, 20.
Why?
The Maple Lane is where he lives.
That's not where I live. My address is.
Shush, Red Guy. Shush.
The property that we're talking about here, is it for Churchill Avenue? Is it for?
Yes. Yes. That's where we live, Churchill Avenue.
Do you live there?
That's my residence, yes. It's on my driver's license. I live there, my property's there. I'm trying to take it.
Hang on a second.
They locked the doors on me and changed.
Time out. Time out. You're his son? Are you his son?
Yes.
Well, this isn't very fun.
Exactly.
Who else lives at that Churchill address? Do you live there, Don Pittaway Sr.?
Yes, I do.
Do you live there, Don Pittaway Jr.?
Correct.
And so does Ronald?
And he moved his stuff to the Maple Lane address, and he's trying to get away with living at two addresses while I'm trying to evict him. What's basically going to happen?
Hang on. You are not trying to do anything because you're not the plaintiff. What do you mean, whatever? Mr.
My father's 85 years old, sir.
I don't think he's being disrespectful, but I can't just say whatever. I have to have the real party and interest starting the action. That being said, Ronald, come on. What was yesterday again?
June 15th.
Yeah, I know. What else was it?
Father's Day, I was there.
Yeah. Stop. I didn't ask you that. It's Father's Day, right?
Yeah, I just thought we were starting to fight yesterday.
Stop.
All my brothers were there.
Listen to me. How many dads you got? That's what I want you to answer. How many fathers you got?
One.
Okay. Yesterday was Father's Day. What a sad commentary that an 85-year-old, and how old are you?
He's 84. I'm just being accurate, sir.
All right. How old are you?
53.
My dad. See that guy in the mall?
I know Gerald.
Huh?
Gerald was down.
Who's my dad?
Yeah.
53 when he died. How old are you?
56.
You guys are carrying on like that in this world that's so short, this silly, ridiculous, and I've got a lot of other words I could call it, but they wouldn't be appropriate. Now, why aren't you just vacating the house without putting people through all this nonsense? I did not finish asking my question. You keep interrupting me. Why aren't you just moving out of the house? You live on Maple Lane? Yes or no? Do you live on Maple Lane, yes or no?
My address of residence is 20679 Churchill Avenue on my driver's license. Sir, my property's there, and I have money invested in that house, and they're trying to take it. He is my brother. I got about $30,000. Who else will do that for their father, sir?
Oh.
Not this deadbeat who's got my dad broke.
Hang on. Watch your mouths. Now listen, 85, 48, don't start swearing in here. I'm as serious as a heart attack now. Stop it.
Yes, sir.
Do you have a lease with him?
A red lease, sir?
I'm talking to your dad. What did I tell you last week? I said you can't be his representative here. You're not a, listen, sir, listen to me, please. Just so you don't think I'm being mean or anything. I cannot allow people to engage in the unauthorized practice of law, and that's what you're doing right now. You're not a lawyer, and you can't represent him. Period. I can't go over and set up a medical office and act like a doctor. You're not going to act like a lawyer. Now, I thought I made that clear. Did I not make that clear?
Jurisdiction? Yes, you made that clear.
Then why are you here doing the same thing? I don't care what the reason. Look, let me just try to help you guys. Maybe you can save a lot of people a lot of time and a lot of money on lawyers that maybe isn't quite necessary. What do you mean you put $30,000 into the house?
I got the receipts. I put a whole back patio.
I want to. You put in a back patio?
All brick pavers, 2 fireplaces, a hot tub. I did it for my mother because.
How long ago?
It's like right around the start on COVID, it got delayed.
Is your mother still alive?
No, she passed away.
When?
18.
So you're telling me you put in brick pavers and what else?
2 fireplaces, a hot tub. Well,
where's this all at?
It's all on at my dad's.
In the back?
Yes, sir. I got pictures and
And you did this 7, 8 years ago?
No, it's a few years ago. I promised my mom to take care of it.
Wait a minute. When did you do that? What year?
It started in 2020.
But your mom was already deceased.
I promised her I'd take care of it.
Your mom was already deceased.
I promised her I'd take care of it. I made a promise to my mom and I honored my own. When I moved in there for my divorce, I promised her I'd take care of it. A tree fell down, destroyed the pool. They paid to have it. My dad didn't have the money. I did. So I pulled it out and I took care of it. Like I promised.
You did this 5 years ago.
It started off.
Was there any agreement that he was? You told your mom you were going to do this, right?
Yes, I did.
Because you wanted to be a good son to your mother.
Yes, sir.
And you took care of it even after your mother died.
Yes, sir.
Do you have anything in writing that says your mother, stop, don't interrupt me. Do you have anything in writing that says your father, Don Pittaway Sr. here, agreed to pay you? Yes or no?
No.
You have anything in writing from your mother saying she agreed to pay you, even though this happened 2 years after she passed?
Anything I did.
Yes or no?
No.
How are you going to win this? You want to say something? How long have you been living there?
Since like 2018.
18? How much you been paying in rent?
$50 a week, just like he paid. My other brother paid $0. And everything I put into the house, my dad said would be taken off my rent.
Have you been paying the rent at $50 a month or a week?
My dad took like $5.
Sure.
Yes.
Have you been paying your father $50 a week?
Yeah, he just took like $500 on my bank account.
No.
They take more than.
Wait. You have this terrible habit of interrupting me. Have you been paying since 2018 $50 per week?
Yes.
How you been paying that?
Cash.
Check?
Cash.
Did he take 50? Is he been paying you 50 a week? Look. You know what I think?
I have proof.
How do you have proof? Did he sign receipts? How do you have proof? Did he sign receipts saying every week, my son, Ronald Pittaway, paid me $50 to cover his rent for this past week? Do you have proof of that? You have receipts like that? I'm asking you a question.
But to make sure I don't interrupt you, sir. I got my bank statements right there. My dad took it out of my bank account. From the bank, I got them out there. They'll verify that he took it out.
For 6 years? Hang on.
He's on my bank account.
For 6 years, he's been taking $50 a week?
He takes money whenever he wants to.
Have you been taking money out of his account?
Here's what happened. I didn't even know that he was on the account. And then all of a sudden, I found out he hasn't been paying me any rent. He pays the rent. He's paid.
Who's he?
Ronnie doesn't pay nothing.
Who's he? Don Pitaway Jr.? You pointed to this son. Wait, you pointed to this son, right?
Right.
He's been paying rent.
He's been paying, but the other guy right over there has not. And every time I try to collect from him or something, no, I ain't giving nothing. Well, that was like 6 months ago or something. I found out that he has a bank account where I'm at, and my name's on there as runner-up or whatever you want to call it. So I start taking money out of there.
You did?
Just a minute. He found out about it, and so he cut me off of there. I can't go in there and get money out of the bank anymore for my $50 because he's killed me on.
You kind of lost me. Who's on the bank account?
He's the head on the bank account, and I just found out by accident that I was on there. So I said, well, good, then I'm going to start taking my $50 a week.
When did you start doing that?
Oh, about a year ago or something like that. Whatever it was, I would just take it, $50, and he found out, and then he just cut me off of there. But for years, he didn't pay me nothing. My son here did.
Even if you've been paying, you have nothing here. You have nothing. He has a right to kick you out. You guys didn't sign a 10-year agreement or anything, did you? He has a right to kick you out.
Everything is verbal.
All right, well, that isn't good enough.
I understand that part. But he still can't change the locks and throw me out without evicting me.
You didn't do that, did you?
Yeah, he did.
Who's he?
My brother. I told him
also that
you guys are trying.
criminal complaints against
You guys are trying.
malicious destruction of property. I'd like to let you see if you'd like to see it.
You guys are trying to be your own lawyer. That never ends well. Never. Oh, how do families get this angry at one another? I don't get it. You have to heed my advice. You cannot represent your father. He seems completely competent to me, by the way. Why don't you have a seat, Mr. Don Pitaway Jr. in the back? And Don Pitaway Sr., would you like to stand at the podium, or would you like to have a seat at the council table right there?
I don't know.
No, I'm just asking you how you're going to feel more comfortable. You want to stand or you want to sit?
Well, probably sit, I guess.
Sit. Why don't you sit down? You're not getting anywhere with me, Ronald Pitaway. $50 a week on Churchill and Brownstown, that's a pretty nice area. Will you move me in for $50 a week? I'm just kidding.
No.
I don't want to hear anymore. This is silly. Do you also live on Maple Lane?
Yes, I also live on Maple Lane.
And why do
I
you...
had to move in there because they changed locks on me. Well, I was helping my buddies when his dad died, emptied out his house. They lived on 7 farms. So I was helping him, his dad had a hoarder.
You have, I'll tell you what I'm going to do.
They've got a washer, dryer, a hot tub.
I don't even think I have a triable issue now. I really don't. I have to have a triable issue. I'm telling you right now, Don Pitaway Jr., don't stand up at that podium again and act like you're representing your father. Do you hear me?
I understand.
This is kind of all coming back to me now. I'm adjourning this 1 week. You guys want to come in and tell me the same kind of thing? I'm going to order you out in 10 days. You want to come in here if you've got a lawyer or some legal argument to make that's legitimate, then I'm going to find there's a triable issue. So far, I haven't. I find this more sad than anything. I really do. I get this families fight, dads and sons and mothers and daughters and mothers and sons and dads and daughters, but I don't understand it. I'm adjourning this case 1 week. If you don't come back with some legitimate legal argument other than I honored my mother's wishes that she asked me before she died and in 2020 did some work around the house. Stop. You look like you were going to cut me off again. Then I'm gonna order you out. You want to try some other legal theories? Feel free. I'm giving you 1 week to get a lawyer to do whatever you want to do. Maybe you need to find another one, Don Giveaway Sr. I don't care. June 23rd at what time, Jen?
10:30, Your Honor.
At 10:30 in the morning, and that's it. I find this incredibly sad. Good luck.
Can I get my property out of there?
I don't know what your decision is.
Well,
are you saying you want to relinquish?
Like I said, that I'm gonna have 10 days, and I want to be able to go get my stuff. I got the doors locked. I have to call the police to get.
Sit down. You're pushing me. Don't push me. Now you want to stand from the pews back there and start debating why he shouldn't be able to do that? You're not the real party of interest. You got no business being here except to observe. How many times I got to tell you that? Wait. When I issue this order, this judgment, if I decide to enter the judgment, I'm still going to give you a week if you want. You guys, sir, you're going to let him come in and get his property. If I have to treat you all like children and have the police stand by and set a specific time, then I will do that. Stop. Stop acting like children.
He was there the other day and taking his stuff out.
Is that true?
Still some left
Some of the stuff I put my washer and dryer. My dad tries to.
Is that true?
Yes, but they won't let me.
Hang on.
They won't let me in the house to get the other stuff.
Yeah.
No.
Hang
They
on.
won't let me in the house. Mark left it.
Stop.
He doesn't own
Stop.
a washer or dryer.
I got proof.
I'm getting tired of hearing you say you have proof. Where's your proof?
I bought the washer and dryer from Sears. It was on my credit card. Please.
How many years ago?
Shoot, about 20.
You're not taking the washer and dryer, okay? You're not taking the washer and dryer
20 years ago.
that you bought 20 years ago. What else?
My hot tub out the back.
Do we have a problem with him taking the hot tub? Not you. You don't say a word, Mr. Pittaway Jr. You have a problem with him taking his hot tub?
Nope.
What else do you want besides your hot tub?
Like I said, the freezer and the two pitchers that are downstairs that Sean had stored that they wouldn't let me get access to.
What's the you have a problem with him taking the freezer?
No, it's empty.
You have a problem with him? What's the pinchers? I don't know what you mean.
Pictures. My friend stored some of his stuff there.
Pictures.
He's got some antique.
What kind of pictures?
They're antique pictures. They were sitting on top of the freezer.
Well, you got to be more descriptive.
They're my friend Sean's. When we were moving his dad out.
You got to be more descriptive.
Two big pictures, antique pictures. He's got.
Of what?
They're just antique pictures he had down there.
I know, but are they to depict a baseball field, World War II? What do they depict?
I couldn't tell you.
Well, then why do you need them
Because
so
they're my
bad?
friends, I need to get them out of there. And his motorcycle's in my dad's garage. They were storing it for my dad. My brother got mad, pulled the gun out, poked me with it.
Oh my God, you guys are out of control.
Listen,
Hang on. Hang on. Do you have is there a motorcycle in the garage?
They come over to get it just the other day, and they couldn't get it started. So he towed it back into the garage. They're going to come.
Is that true?
Yes.
Okay, so it doesn't sound like anybody disagrees about the freezer. Hang on. Hang on. Or the motorcycle, or the pictures. I guess, do you disagree that he can take the pictures?
If they're his, take them. We told him he can have that freezer, and what else is that, Donnie?
What else do you need?
That's just everything I have. I don't know where they put everything.
Hang on.
They took my room, put stuff in the.
Mr. Pittaway, I want a list from you. So far, you've told me 2 antique pictures that you don't have a clue of what they depict. Which I guess if I wanted a picture, I'd at least know.
Can I suggest something to be just real quick about this? Say the board's time. Can I have 30 days? I'll have it out. I'll go there with my dad, go through this stuff. I'll get it out in 30 days. And if you don't hear from us, you know everything's good. But give us 30 days. I'll have it out. And then,
hang on.
Is that fair?
I can adjourn this a week.
30 days.
Why do you need 30 days? Where are you working at?
General Motors. We're here every day of the week.
You've got 1 week. Come on.
We have a trailer. I'm trying to figure. I gotta find storage and everything else. I mean,
I think Don Jr. Pittaway should stay out of this, to tell you the truth. Don Sr., can you collaborate okay with your son here? I'm talking about with Ronald.
I'd rather handle it between my dad guys.
What's that?
I'd rather handle it between my dad guys. And I'll talk to him on the phone, tell him we're coming over. And if, like I said, it's going to take about 30 days.
Okay, hang on. What do you want to do, Mr. Pittaway Sr.?
I don't know why it's going to take 30 days.
I don't either.
How do you pick up a hot tub?
You get a truck, and you get some friends, and they come and help you. You should be able to do that today if you want.
That's not how hot tub works.
Okay. Well, how do you intend to move the hot tub?
Well, I'm going to get some money. I'm going to call people that deliver and see if they'll come back and get it. The guy that drops it off, I'm trying to get a hold of him and see if he'll do it. Get some people. Where it's at, you kind of got to wheel it.
He filed this May 20th. How about I'm going to adjourn it 1 week. I'm going to let you guys figure this out.
Okay, 2?
I'm not going to be here in 2, and I don't want to move at 3. Do you have a problem with 3 weeks? If I adjourn this 3 weeks?
Rather bring it sooner than that, but whatever.
I'm not going to be here June 30th, so it's either got to be June 23 or July 7th.
July 7th.
Is that okay?
Right.
July 7th?
I guess.
At what time, Jen?
10 o'clock.
At 10 a.m. All right, that's what I'm doing. Okay? July the 7th at 10 a.m. You guys come back. Don Pittaway Jr., I think you should probably really stay out of this, and I don't think I can emphasize that enough, and I know you're not going to listen.
No. We have a younger son, and Donnie's been taking care of him or whatever. That's why he's basically running everything. Because,
All right.
I'm going to be 85, and I ain't got that long to go.
And I mean, and that's what exactly my point is. It's a sad commentary. You guys are fighting like this. Jeez. Look, I'm gonna move this.
I don't hate my son. He just acted up a few times. That's all.
Okay. I would hope that you guys could resolve this. Really. I don't want to.
We did the other day, but let's just see what's happening. So whatever.
Be nice.
I'm gonna get all this stuff out of the garage.
If this is you and your brother fighting, let this be you and your brother not seeing each other, but stay in touch with your dad. July 7th, come on back here. You guys see what you can work out in the meantime, will you? I really mean that. Good luck. Don Jr., maybe you should stay out of this.
No.
But don't come up to the podium again, sir. Did you hear what I said? Yes?
Yes.
Okay. See you in 3 weeks. Good luck. Fadabi Bell versus Tamisha Bell.
Okay. Wow, Judge Dad. What a clip this morning for the day after Father's Day. Oof. Let's see, where's our other clip? There we go. Okay. We're getting ready to come back in court with Warren, Ohio. They're just finishing their lunch break. The interns are flirting. Prosecution's there. Judge is missing. I don't have settings showing. I don't want settings on the screen. There we go. Oops. Go. All right. I think it's mute right now. We have audio turned up. We're all good. All right. What a zinger. What a zinger. Judge Dad, day after Father's Day, dealing with a feuding family, Dad and his sons. Hope Dad has a will. You know, when he passes, it's going to be all-out war. It's going to be like World War III. So glad I get along with my brothers. Yeah. Would you have thought there would be a verdict by now? Getting word for Karen? No, I don't think so. I mean, looking at the time, sorry, I haven't been watching where my face has been. I was watching a different way. Hopefully I didn't have something on the screen the whole time. Did I mess that up? Okay. Now let's put this back down. Nope. I've got, sorry, I had that where I needed it. For a reason, I forgot. Got to be over the fan. That'll move me as well. There we go. All right, that'll work. We'll keep an eye on the fan here. We're approaching 6 hours of total deliberation time. Remember, about an hour and 50 minutes of it happened yesterday, or Friday, yesterday, business day. I remember one law tuber saying quick verdicts are usually guilty, so maybe it's a good thing. Josh says, I'm all clipped out for today. That's all I got. Judge Dad and this one. Josh has really delivered today as we have a verdict watch and appreciate the change of pace that we're getting here, as we're used to watching Karen read for the last month or more, month and a half. Luca, happy birthday! Happy birthday! Hope you had a great one. Andy, the problem I have is YouTube does not allow closed captioning unless I delay the feed, and I can't delay the feed and have the interaction we have. It causes lots of loops and lots of problems, especially with the phone. So I cannot do closed captioning. It's just not a feature they will enable quickly. See, last trial was 5 days. Don't expect a verdict until tomorrow or after. Our comedy is very dependent on timing. The problem is when we do open up the phone. Oh, looks like we're coming back right now. It's a little early. It's only 1:07.
First is the case of the State of Ohio versus Christy Brown, case number 17 CR 33574. Present before the court is Ms. Brown, right?
Yes.
And we have Mr. View from the prosecutor's office. I'm in receipt of a report from probation indicating that you were granted ILC back in January of 2018 and that you completed it. But we have still $1,910.70 in restitution or in financials that is owed.
I'm not aware of that. I actually didn't even know that until, I'm not sure how they came up with that.
Okay, well, they can give you a cost bill down at the clerk's office. We might be able to print this from here.
It's the same one. We have the same gavel.
I'm sorry.
So there's a couple of ways we can do this, Ms. Brown. I can go ahead and decide this issue without the cost being paid, because costs are not your only criteria, but the fact that you didn't pay the cost does sort of count against you. in the sort of consideration of this. So I can continue this out for a couple of months if you want to pay some of those costs. If you just want me to go ahead and decide it, I can do that. What is it that you want to do? Ms. Kuroko, can we grab that statement off the printer? Give it to Ms. Brown.
Your Honor, I'm not sure how they're saying I have charges, or this is 5 years ago, and nobody's ever contacted me, and I was unaware of this.
They can give you a more detailed breakdown at the clerk's office if you want. So what I'm looking at here is the clerk's fee, $533, whatever. Supervision fees. We do have the fine in the amount of $375. The one thing on here that nobody cares, well, that I don't care about is the $622 for attorney fees. That's between you and the county commissioners. I don't care if you ever pay that. But we have supervision fees, we have probably costs of drug testing, and also your fine. So, like I said, if you don't want to pay that and you're just saying, hey, go ahead and decide the case, I'll do that. If you want some time to pay the $1,300 or so, I can give you 60 days, 90 days, whatever you need. What is it that you want to do in this case?
When I was on ILC, my officer said that I wasn't having to pay that, so I guess I guess I'll just have to make a decision regardless today, because I don't think I'm supposed to be paying that. I don't know how I'm going to pay that.
According to Officer Bridgman, when she sent me an email back in 2020, she told you this: you have not made any payments. Your overall stability is greatly improved. I'm recommending, barely, early successful termination at this time, and for her costs and mandatory fine to remain. I will explain that this must be paid in full to have her charges bifurcated for filing of the expungement. If that didn't happen, maybe it didn't, but that's where we're at today. Do you want me to go ahead and decide this without the financials being paid?
So if I put it out, like if I decide that I'll wait, but I decide not to come because I don't agree with this, and I'm 100% sure that didn't happen, but if I decide, just so I have time to think, because this is a big shock.
That's fine. Do you want me to send it out for another hearing in a couple of months and you can think about this?
Yeah.
Okay. Why don't you step up? Ms. Kuroko will get you a date to come back in a couple of months. If you want to go back and talk to the clerk's office and they can give you a more detailed breakdown of what it is.
I'll just make the decision today, because it doesn't matter. I don't understand that, and this is very important.
Okay, so what is it that you want to do?
I just want the felony the felony that was dismissed. I don't get anything else, it's fine. I just needed the felony to be off of there.
Okay. I mean, I understand that that's your request. Do you want me to go ahead and decide that without the costs of the action being paid?
No.
Okay. Do you want, because we can also have this discussion again in a couple of months, and then you can tell me what you want to do.
I would like to find out this, because that's not.
Do you want to come back sooner than 2 months? Do you want to come back in 30 days? Do you want to come back in 2 weeks?
No, I don't even want to come back, honestly, but this is, like I said, important.
Okay, Ms. Kuroko will get you a date to come back in a couple of months.
Thank you, sir.
That seems, it's sad, but it's surprising that she doesn't.
Case number 25 CR 42416. Present before the court is Mr. Whittle, right?
Yes, sir. Correct, Judge.
Represented by Mr. Coleman. We have Mr. View from the prosecutor's office, Officer West from probation. We are here today for sentencing. Is everybody, wait, do we have a jail time credit figure?
Yes, 41 days.
All right. 41 days of jail time credit sound right to everybody?
Yes, Your Honor.
Any reason not to go forward with the matter of sentence today?
No, Judge.
Mr. View, on behalf of the state,
We just encourage the court to follow the negotiated agreement between the parties.
Mr. Coleman?
Judge, this was a settlement that was worked out between the state and myself on behalf of Mr. Whittle. Mr. Whittle didn't have a statement that he wanted to read to the court, but I would ask the court to certainly consider adhering to the settlement that had been negotiated, Judge.
Okay, what do you want to tell me, Mr. Whittle?
I had wrote a letter, but everything I'm about to say, I can just say it. I'm 22 years old. I made a mistake. I got 2 kids with another child on the way. As a man, I got to stand up. I'm ready to get this over with, to get back to my family and to my children. I know it's a long time, but it got to come. I'm ready. I apologize to the victim, whoever the victim is. I apologize to them, but I'm just...
I apologize to the victim, whoever the victim is.
I'm a young adult, so 22, so my mind straight, and I'm just ready to get this over with, to get back to my family. I got a great supportive system, my family back there in the back, my mom, I got a father, and I'm a father myself. I'm just ready to get back to my young kids. I'll be 5, both my kids are gonna be 5 when I come home. I'm gonna have a 2-year-old that's almost 3, but I'm praying that I'm gonna get the good days. I know that's for sure. That's whatever I'm eligible for, I'm gonna do it to where I can knock some days off to get back home, but just ready to get this over with and put it behind me. I made a mistake and I'm 22. This is my first ever real offense. If you ever go look, I only got driving tickets. I don't get in trouble. I made a mistake, and as a man, I can't blame nobody else but myself.
All right, the court is going to impose the joint and recommended sentence. That is a 2 to 3 year prison sentence on the F2. It will be a, we're doing it was a 1 year gun spec, right?
That's correct.
So 2 to 3 plus 1. So it'll be a 3 to 4 year prison sentence. You're going to receive a sentence, or you are receiving a sentence that includes both a minimum and a maximum term. It's presumed that you're released at the minimum term, but if you don't abide by the terms of the prison, don't follow the rules, they can hold you up to the maximum term. Did we give him the notifications on Reagan Tokes or not last time, Mr. Coleman? I can give you this.
Judge, I believe we did. We did, in fact, do that.
Okay.
They were provided by the court, and I went over it with them.
Okay, so we have the notification, indefinite term Reagan Tokes. You've seen that, right? Do you want me to read that to you, or are you satisfied that you understand the Reagan Tokes?
I'm satisfied, and I got another question. I know I was watching one of the co-defendants, the way, so there's no judicial after the mandatory 1 year, or how do it go?
It is part of the plea agreement that there is no judicial release in the case. So we also have Exhibit 2, which is notification of post-release control. That means the adult parole authority is going to supervise you for anywhere from 18 months to 3 years. No. Yeah, 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. So again, 2 to 3 plus 1 for a total of 3 to 4. There will be no judicial release. I'm not going to impose a fine. I am going to impose the costs, give you credit for the 41 days that you have already done. Is there anything else we need to? Anything I forgot?
There was an indication that he has no property interest in the seized firearms in the case.
Oh, that's right. No, he doesn't have any ownership interest in the gun.
He does not.
All right. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they will all be provided to you at no charge. Good luck to you, Mr. Whittle.
Thank you, Judge.
And the bailiff's going to take him away.
All right. Next is the case of the State of Ohio versus Chandra Miller.
Surprised the headphones in court was approved.
You guys need to go have a seat.
Wait, which one is Ms. Miller?
Right here.
Okay. Everybody who is not Ms. Miller, have a seat.
Guy's wearing a
All
wanted
right, this
shirt.
is the case of the State of Ohio versus Chandra Miller, case number 24CR42234. Present before the court is Ms. Miller. Great.
Yes.
Represented by Mr. Brenner. We have Mr. View from the prosecutor's office, Officer Sukovecki from probation. We're here today for sentencing, so everybody had the opportunity to review the PSI.
Yes, Your Honor.
Yes, Judge.
Any reason not to go forward with the matter of sentence today?
No, Your Honor.
No, Your Honor.
We have $127.37 in restitution, 88 days of jail time credit. Does that sound right to everybody?
It does.
Yes, Your Honor.
All right, Mr. View from the state.
Nothing additional from the state, Your Honor.
Officer Sukovecki, anything from probation?
Nothing further, Your Honor.
Mr. Brenner?
Your Honor, as I indicated back in chambers, I had some discussion with court staff down in Hamilton County. It sounds like she is going to be accepted to the mental health court down there as of tomorrow. So I would just ask this court to permit her to engage in that mental health specialized docket. It seems like the most appropriate place for her to be supervised and receive kind of the accountability and the help that she does need. And I would just ask this court to permit her to engage with that.
Ms. Miller, what do you want to tell me, if anything?
I'm sorry for what I did, and I learned my lesson, and that's it.
That's it.
So there's three things that we do here, Ms. Miller. We punish people, we supervise people, and we rehabilitate people. Those are sort of the three goals of what we do. The punishment part of this case, in my opinion, is over. The 88 days of jail time credit, that's enough to make sure that this kind of nonsense doesn't happen again. The rehabilitation piece of it seems like they're going to take care of that in another jurisdiction. So really the only thing and the only interest that I have is supervising you to make sure that this doesn't happen again. So what I'm going to do is I'm going to place you into my community control program on 3 years of non-reporting probation. That's non-reporting after today. You need to meet with Officer Sukovecki to get signed up for rules today. We're going to run your record twice a year. As long as you don't have any new kind of stuff, we're never going to hear from you again. You do need to pay the restitution. I'm not going to impose a fine. I am going to impose $127.37. And if you violate the terms of your supervision, I could sentence you to up to the maximum penalty in this case, which is 36 months in prison, plus the mandatory period of post-release control that is provided by law.
Okay.
Anything else we need to do? Anything I forgot?
I don't believe so, Your Honor.
No, Your Honor.
All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the cost, they'll all be provided to you at no charge. Good luck to you, Ms. Miller.
Thank you, Your Honor. Okay, so as far as that, any questions?
All right, we might be ready to go on to the next case.
Oh, can we go get Ms. Kilgore?
I'd like to mute the mic and then turn it back on to indicate the change of cases. Here's me just looking at the weather to see what I'm going to be camping in. I say camping, but you know, not really camping. Hourly, daily. There we go. Oh, 91 degrees. Thunderstorms. 93 degrees. Thunderstorms. It's going to be great.
It's after testimony of the defendant. It's not necessary the defendant take the witness stand. The next one I changed to evidence was received that the defendant may have been incarcerated for an offense that is completely unrelated to the charges. That evidence was received only for a limited purpose. It was not received, and you may not consider it to prove the character of to prove his character in order to show that he acted in conformity with that character. So I don't think we had evidence of a prior conviction. Oh,
No,
do you want
I mean-
Mr. Snyder here for the discussion on jury instructions?
No.
All right. You can go ahead and have them brought around whenever they're ready.
Lawyer
Anything
waives
else
the
on
client's
instructions, Mr. View?
presence.
Nothing additional from the state.
Mr. McKenna?
No, sir.
All right.
The prosecutor in my last traffic infraction.
Mr. McKenna, did you want to rest in the presence of the jury?
Sure.
Okay. All right,
Speeding,
we'll do that, and let's take about a 5-minute break. We'll get him in here, and then we'll get the jury in.
His name is Oda as well.
Judge?
Judge.
Yes.
What happens if I don't rest in front of the jury? We would just do it in front of the court?
Yeah, I mean, I'll just tell, if you don't want to rest in the presence of the jury, I'll just tell them both sides have rested. We're going to hear closing.
Yeah, I'm just, because my client didn't testify, I'm just trying to think. I guess I'll do it in front of the jury. That's fine.
Okay.
Yeah.
Yeah, whatever. The court has lunch today. You're correct. The judge has told them we'd like to not have a verdict during that time. Just be mindful of that. But they might still come back with one during that time. Don't tell the jury you're resting. What happens if I don't rest? Your client still loses. Judge needs his sleeves altered. I think maybe let down a little bit, or maybe gathered in. HowCoTube, thank you very much for clicking the subscribe button. We call that admitting to being a true crime addict. Welcome. You're one of us now. And in about a minute, you can talk. Sorry, this is just a restriction we have that keeps the trolls out because apparently they don't have patience. But all right. 5-minute tops for the Ohio verdict. I wonder if they're going to be like, Judge, do we have to leave to the deliberation room or can we just give you the verdict here now? Because I'm pretty sure we're all on the same page. Court hack, never rest. Aha! That sounds like a soft sit solution. Which county is this? This is Warren County, Ohio. There's our defendant just coming in there with the bailiff. The jury should be brought in just a moment. They're going to be read very abbreviated jury instructions. Like, I'll be surprised if they take a full 10 minutes. Still have the belly chain on. He might be getting that off. There it is. It's coming off. He'll be unrestrained. Once he's unrestrained and seated, the jury will come in. Says to his lawyer, so what do you think my chances are? The interns behind hear the question and look away out of shame. They're like, not good. Something tells me that attorney rests a lot. He has leg irons. It's his arms. He was swinging fists. That's the problem. What? I want to hear this part. If he's talking to the judge, I want to hear this. Can we mic up, Judge? Brooks Skylar Richardson? Why does that name sound so familiar? Crazy Room Convos, by the way. I love your name. Do you have a podcast? Just asking. Oh, The Buried Baby. Oh, my goodness. That sounds familiar. Yeah. Buried a baby in the backyard. Judge is eating some snacks. Getting some lunch. Is this filmed in Greenland? No, but this white balance and the contrast and the gain's too high. It's a terrible camera. It's basically shot on a potato. Trying to start and get your channel launched. That's awesome. That's really cool. I'm curious. You know, you've piqued my curiosity with the name alone, and that's something. The Crazy Room Convos. It sounds like something I would listen to. Once you get something up and get something going, drop me a line. I'd love to, I'm not saying I'd like pop in as a guest. I'm not sure if I'd even, fit at all in the genre, but I'd like to at least watch or listen and follow along. What is this case about? The defendant is incarcerated and attacked a corrections officer in jail, and it happened on camera. We have 4 cameras that captured it, 3 security cameras, 1 body camera, and he attacked the corrections officer, broke his nose, and Santa Claus came and punched the guy into submission, and now we're here in court. I kid you not, those are the facts. That's how it happened. You'll have to rewind to watch it, but that's what happened, and we're here. He's on the naughty list. Santa piled in. Santa was throwing some rights, and then he started throwing some lefts. Santa Claus is coming to town, and he's bringing the heat. All right, let's get some audio up. Oh, come on, Judge. You've forgotten the audio?
Attorneys has to argue to you for a specific verdict and sum up what they believe that the evidence is shown in the case. Remember what I told you earlier about the opening statements. Closing arguments are not evidence. They are designed to assist you with the evidence. Because Mr. View has the burden of proof in the case, he is going to address you both first and last with Mr. McKenna in the middle. We have agreed in advance that both sides will have up to 25 minutes for the closing arguments. Mr. View, you may proceed.
Thank you.
It's going to be quick.
Unprovoked, inexcusable, unnecessary, and illegal. On December the 23rd of 2024, the defendant, Jason Snyder, assaulted corrections officer Donald Hopper. And in doing so, he committed 2 violations of law. Because of the seriousness of that assault, that unprovoked attack, he broke Officer Hopper's nose, requiring additional medical treatment. Not only did it cause the laceration to his nose, the laceration next to his eye on his cheek, and the laceration on his forehead that required stitches and medical treatment on that day. A week later, Officer Hopper had to go and have an outpatient surgical procedure to have his nose re-broken and straightened.
3rd time.
Prolonging the injury, the pain, and the treatment involved.
That's 3 breaks.
And then beyond that,
in 6 months.
Once he began to wean off the pain medications, he learned that in fact the defendant's assault had also resulted in 2 rib fractures to him. You have had an opportunity to listen to Officer Hopper's testimony, but beyond that, you've had an opportunity to witness the crime itself. Because Officer Hopper was wearing that body-worn camera, you saw exactly what happened between the 2 of them. You know that Officer Hopper, in the responsibilities that he has, was given notice by another officer that Jason Snyder was approaching the mental health unit and that he was seen to be getting items. He was out of place. He did not have a pass to be coming to the mental health unit. He was getting other items. He was doing something out of the ordinary, gathering things that the officer, in his responsibility for the safety of other officers, for the safety of other inmates, was required to find out what Snyder was doing. And so when he contacts him, you may think, well, that wasn't a very nice interaction. It is happening in a prison between a guard and an inmate. And maybe that isn't the way people would necessarily talk to each other if they bumped into each other at the door of the Kroger's. But certainly, Snyder was aware that the person who was talking to him was a corrections officer. And Officer Hopper said, what do you have? What are you doing? Something that he has to do, right? He has to see, is there contraband here? Is it major contraband, minor contraband? Is there something dangerous here? He's coming into the mental health unit.
Is he chewing the ice?
Other officers, other inmates.
He's chewing the ice.
But that interaction between you, though you may think it was rude or direct or short, in no way excuses Jason Snyder's conduct in retaliating against that by brutally assaulting Corrections Officer Hopper.
He's slurping and chewing the ice.
The state has to prove to you several
Into the
elements the
microphone.
judge is going to go over with you for the crimes of felonious assault and assault on a corrections officer. First of all, the assault has to be knowingly. And this is something, that's what we call the mental state, right? This was not an accidental, he fell into Officer Hopper and accidentally caused an injury to him, right? He was aware that the conduct that he was engaging in was assaultive in nature. When you pull your fist back, you throw it, you stay on top of the guy while he's trying to cover up, push him down into the door. You're assaulting him, you're aware that's what you're doing. Now remember we talked about circumstantial evidence, right? We don't have direct evidence. In other words, we don't have a statement from Mr. Snyder saying, I'm assaulting you, I know what I'm doing, right? You have to look at the circumstances. What was the nature of the interaction? What was the conduct that he engaged in order to arrive at, is he aware that what I'm doing is an assault? And if he knows what he's doing, and the state has to prove to you that what he did caused the injuries to Officer Hopper. Well, again, you saw the video, not just the body-worn camera, but also the block videos that show, you can see in that altercation as Snyder continues to throw punches at him, that the glasses go flying, the things that are in Hopper's hands go flying, and you see Officer Hopper before the incident seeing that he doesn't have an injury. I know this seems simple and straightforward, but these are the things I have to prove you. Those punches are what caused the injury. The defendant, I don't have to prove to you, we talked about this in, during jury selection, I don't have to prove to you that Jason Snyder intended to break his nose, that he intended to cut his face, that he intended to cause that bruising and swelling on the face. He is responsible, if he's engaging in that conduct, he is criminally responsible for all natural foreseeable consequences. You can rely on your common sense, your experience as human beings. Someone gets punched in the face, sometimes that results in a black eye, but it's also foreseeable it can result in a broken jaw, a broken nose, cuts, bleeding, bruising. Jason Snyder is responsible for every foreseeable contact, not consequence, not just what he may have intended to do or not intend to do. The state doesn't have to prove to you what his intent was, only that he knew he was engaging in an assault and that assault resulted in a serious physical injury.
The defendant is chewing ice.
I keep using the term serious physical injury. The law is serious physical harm. I apologize for that. I was a prosecutor in Oregon for many years, and sometimes I still do the opposite. So the judge is going to instruct you on serious physical harm. And there's 4 things the judge is going to instruct you on. The first one is that any physical harm that carries a substantial risk of death. I don't think this is that kind of an assault. The state's not going to argue to you that a punch to the nose is likely to result in Officer Hopper's death. But the other 3 circumstances are ones that you should consider, and that is any physical harm that involves some temporary substantial incapacity. So that's the first one. We know, 1, that this assault resulted in 3 months out of work. 3 months. 3 months of difficulty breathing, 3 months of limited sleep. You have that limited but substantial incapacity. So, if the defendant's assault and the injuries that he caused result in this, then that's serious physical harm. The second that you should consider is any physical harm that involves some temporary serious disfigurement, like having your nose completely smashed across the other side of your face. That's scarring, that's bleeding. temporary substantial disfigurement. So temporary serious disfigurement. Even though, you know, a week later he had to have that straightened out, he still had to suffer that type of an injury. And the last, for you to consider, and these are not separate from each other, they can all be intertwined together. They are each by way that you can find that this is a serious physical harm. And the last is any physical harm that involves acute pain of such duration as to cause substantial suffering, or that causes any degree of prolonged pain.
There's the prolonged pain we were looking for.
You've got the serious specific injury pain that occurs when the assault occurs, but 3 weeks of taken Vicodin in order to manage that pain. That's pain of any degree.
I thought he only got 7 days worth of it.
That is what we call a serious physical harm. The second offense that the defendant is guilty of is assault on a corrections officer. Judge is going to instruct you that for the charge of assault, you must find, again, that the defendant knowingly engaged in the conduct. He knew this was an assault. He knew throwing punches is the kind of thing that hurts people. But this time the state only has to prove that sort of lesser level of injury for this charge. Serious physical injury, physical harm, or sorry, I keep using that. Serious physical harm is subsumed within that. If you have the higher level of injury, it includes the lower level, okay? So the state only needs to prove for that purpose what we call physical harm, which is any injury, illness, regardless of its gravity or duration. You have that bleeding, you have that swelling, you have that pain. Certainly things that rise to the level of what we see of serious physical harm is going to qualify for a physical harm. But the state needs to prove to you the circumstances, additional circumstances. One, that this happened on the grounds of a state correctional facility. You know, this happened at Warren Correctional, one of our prisons here. And two, that the victim of the assault was an employee of the Ohio Department of Corrections, which Officer Hopper is and has been for 30 years. And that it was committed by a person who was incarcerated under detention at the time of the assault, which we know that Mr. Snyder was. He was an inmate at the time this happened. You have substantial evidence from which to rely on in making your decision. First, as I already said, you witnessed this assault. You have the body-worn cameras and you have the cell block cameras that show the circumstances of this assault. They show, one, again, it was unprovoked. There was no use of force by Officer Hopper. This is not like a self-defense claim. There's nothing here that excuses this use of force legally by the defendant. Those videos also show the manner of the assault, that it's aggressive, it's continuous, it's ongoing until other officers intervene. You can use that information to determine the nature of the assault. Did he know what he was doing was an assault? You have the photos. You can look at this and see the extent of that injury, that this is a physical harm, that this is a serious physical harm. And you have the medical records from Officer Hopper's treatment at Atrium, which confirmed the nasal fractures, the prescription pain medications, and all the medical treatment that he received that satisfy the state's burden of proving to you that this is a serious physical harm. Members of the jury, when you retire to the jury room, take the time to review the evidence. Talk to each other. Listen to the judge's instructions. Apply the things that you have heard from the state's case to the instructions of the court. And when you do that, you will find that Jason Snyder is guilty of felonious assault, and he is guilty of assault of a corrections officer. Thank you.
All right, defense, I think, is going to wave the white flag and say it was bad. What he did was bad, but it was just the lower of the two charges.
Ladies and gentlemen, you've heard the evidence, and this is a short jury. It's not a long trial. It's quick. It doesn't mean it's not important. But it doesn't mean that all the evidence is perhaps more important, because there's not a lot of it. The state can only put on what it has. It had the alleged victim, it had the investigating officer, and that's what the evidence is. And so when we were talking about in Vordaer and picking jury selection, I said you got to pay attention and wait till the end, and you have. And that's where we're at now. You got to decide what happened. And the issue here in the case is the level of harm. Okay, you have serious physical harm, and then you have physical harm. There's two different charges here. There's the felonious assault, which requires serious physical harm. That's a term of art and law, which the judge will instruct you on. And the lower offense of assault, which is just physical harm. So we have an offense here. You saw the video. Okay, nobody's getting hit with a baseball bat. Nobody's getting shot. Nobody's getting stabbed. As far as I could tell from that video, there was one punch to the face. That's it. There was a scuffle after that. I asked the corrections officer, was there a scuffle after that? He said, yeah, but it wasn't a punch like the first one. So you have to look at the evidence. What do we have here? We have someone who was assaulted 6 months earlier and had a broken nose. Was his nose still broken? We don't know. Could have been. Was it still broken that day? Very might have been. That's where we get into, was it serious physical harm or not, or was it just physical harm? During when talking to the corrections officer, he said, I'll be fine. He said, it made me mad more than anything else. He said he did his paperwork for an hour and a half, and then he drove himself to the hospital. Didn't take an ambulance. So I'm going to suggest to you that while he did have physical harm, he got punched. That hurts, for sure. He didn't have the serious physical harm caused by Mr. Schneider. Again, the judge is going to read these to you, but you know, the physical harm is a much lesser threshold than serious physical harm. And the prosecutor, Mr. View, listed all these things as incapacitation and all that. That didn't happen from the one punch to the face. It was just one punch where he said, and he told them on the video, I'll be fine. He took some pain medication, did his paperwork, and that's fine. I'm not criticizing him. He did what he could do. That's what he could do. And then he went to the hospital by himself in his own car. Didn't take an ambulance, wasn't laying on the ground, wasn't crying. He's kind of a tough guy. The initial interaction was a little brusque. I'm sure he, you know, after working in the jail for 31 years, he is a tough guy. Okay, and he's used to maybe that's how he has to deal with people. But we're dealing with real evidence here, and that evidence is that video. You saw the video. There was a limited interaction about some styrofoam cups. I asked, are the styrofoam cups illegal? No. Did he have rocks? No, he had some pebbles. There was some kind of shaving thing that he said he was allowed to have, and then there was that punch to the face. And again, the state doesn't have to go why there was a punch in the face. They don't have to prove motive or anything like that. If they proved anything at all, it's count 2, which is that physical harm, assault on a corrections officer. That's the language of the account. They did not prove serious physical harm. We just don't know what happened from this punch. He was punched earlier. He admitted he had the broken nose. He admitted that before this incident he was already using a CPAP machine because he couldn't breathe. And then 3 weeks later he's making a workman's comp claim and saying his ribs were damaged. We don't know if that had anything to do with this. So I ask you to find not guilties, or if you're going to find any guilty at all, it would be on count 2. Thank you.
Give us the lesser is what he asked for. He waves the white flag. Find him guilty, but it's going to be on the lesser.
Members of the jury, there is a reason why the judge instructs you that the things that Mr. McKenna and I say are not evidence, because they are arguments to you. You should rely on your recollections of what the evidence is. Evidence is the testimony of witnesses who take the stand. Evidence is photographs, documents, videos, not the things we say.
10 minutes.
Here's what I'll tell you, because I want you to remember this. Mr. McKenna asked Officer Hopper about the CPAP machine. And I want you to remember that, because Mr. McKenna said, So you already had problems with breathing? And what did he say?
No,
No,
sleeping.
I had problems with sleeping. The breathing happened after he smashed my nose. So that's why you need to talk to each other. You need to look at your notes, right? Remember, because the state makes accusations, right? It is my job to prove to you the things that have been alleged, the things that Mr. Snyder is accused of. That's my job. The person who is accused of the crime has the right to a trial. They can say, you accused me, you prove it. That's what we did today, right? You put on the witnesses, we put on the evidence so that you know what happened. Is there any reasonable argument to be made that this punch, even if it's only one punch, first of all, watch the videos. You can see him keep swinging on him, right? That somehow Officer Hopper already had a broken nose 6 months later. Well, we know it took him 3 months to heal from this one. We know he was ready to return to work. We know his nose wasn't out of his, joint across his face. Watch the video, watch the body camera. You can see the medical personnel from the prison saying, oh yeah, you can see that. You don't think they would have noticed if his nose was bleeding and out of joint before the defendant punched him in the face? And I don't have to prove to you that he hit him more than once. If he assaulted him, one punch, and that one punch resulted in a serious physical harm, that's a felonious assault. It takes one punch to break somebody's jaw. It takes one punch to knock somebody unconscious and they fall and hit their head on a brick and get a brain injury. It takes one punch to break someone's nose. That's a natural, foreseeable consequence. You're not going to hear the judge say, I have to prove to you that he hit him more than once. Only that the one punch that connected is the one that broke his nose, that caused these injuries that required this level of treatment. Remember, I told you during jury selection, I'm okay with proving to you the things that I am required to prove, but I don't want you to ask me to prove things I don't have to. The judge is not going to instruct you that I have to prove he was shot, that he was stabbed, that there was a weapon involved, right? Why would Mr. McKenna make those arguments to you? He wants you to think that this is not a serious physical harm, but the judge isn't going to tell you anything like that. The judge is going to tell you, look at what the evidence shows of what this injury is. It is a temporary, substantial incapacity. It is a temporary, serious disfigurement. It is acute pain that causes substantial suffering, and it is any degree of pain that is prolonged in duration. That's what Mr. Snyder did. That's the evidence that you heard. The judge is going to tell you not to speculate about things, not to guess about things that you didn't receive evidence on. There was no evidence that said, oh, he never really had, his nose was already broken. Mr. McKenna is inviting you to speculate about the evidence you did not hear. Mr. McKenna had the opportunity to ask Mr. Hopper, was your nose already broken? And he didn't. So you heard no evidence about that, and guessing about it is something you're not supposed to do. Members of the jury rely on your collective memory, rely on your notes, rely on what you know the evidence is. Those
right.
videos are not very long. You
Land the
retire to
plane.
the jury room, you can watch them all. Probably in under half an hour. Look through the medical records. They're all right there. What they're going to show you is a fractured nasal bone, 3 lacerations that required stitches and glue, and prescription pain medication. They're going to show you the evidence is that Jason Snyder committed a felonious assault and that Jason Snyder assaulted a corrections officer. Those are the crimes he was accused of. Those are the crimes that are proven, and those are the crimes you're going to find him guilty of. Thank you.
So, ladies and gentlemen, in the 20 or so years that I've been doing this, it's been my experience that different people absorb information in different ways. And right now, Ms. Kuroko is going to distribute to you a written copy of the jury instructions that I am about to read you. If you're one of those people that absorb information by reading and listening, following along, then you're going to have a printed copy of my materials. Sometimes I ad lib. I try to tell you when I leave the materials and when I get back so that you can follow along. If you're not that person and you just want to listen to what I have to say and not follow along, you can just place the instructions face down on your lap and you don't have to read through them. You can circle stuff and make notes if you would like, but the one thing that you can't do is sort of skip ahead and look at what's coming.
No skipping ahead.
And also you will be taking this copy with you back into the jury room, so you will have your own individual copy. So we'll start here. Members of the jury, you have heard the evidence, the arguments of counsel. It is my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts. The court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law, nor to apply your own idea of what you think the law is or ought to be. The case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. You are not to consider the fact that it was filed for any purpose. The defendant has entered a plea of not guilty, which means you are not to assume that any of the facts alleged in the indictment are true. A plea of not guilty is a denial of the charge and puts at issue all the essential elements charged in the indictment. The defendant is presumed to be innocent until guilt is established beyond reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged. Now, what is reasonable doubt? Reasonable doubt is present when, after having carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's affairs. Evidence is all the testimony received from the witnesses and the exhibits that were admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all the elements beyond a reasonable doubt. Direct evidence is testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes the exhibits that were admitted during the trial. Circumstantial evidence, on the other hand, is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically flow according to the common experience of people. I'm going to depart my script to give you an example. Let's say it's your job as jurors to determine whether or not it had rained outside. If we brought a witness in here and said, I saw that it was raining, that is direct evidence that it was raining. I show you a video, you see the rain coming down, again, direct evidence that it's raining. But if we brought a witness in that said, you know, when I came into the building, it was dry out. I heard a little pitter patter on the roof. When I went out, there was water on the ground and on the cars. That is indirect evidence, circumstantial evidence, from which you could consider that it had rained. Returning here to infer or to make an inference is to reach a reasonable conclusion of fact that you may but are not required to make from other facts you find have been established by direct evidence. You may infer a fact or reach a conclusion only from other facts that you find have been proved by direct evidence. Whether an inference is made or not rests entirely with you. Direct and circumstantial evidence are both of equal probative value. The evidence does not include the indictment, the statements of the attorneys. The opening statements and closing arguments are designed to assist you. They are not evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to a question or what the answer to that question might have been, because these are questions of law that rest solely with the court. Likewise, you must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. These statements must be treated as though you never heard them. You are the judges of facts, the credibility of the witnesses, and the weight to be given to the testimony. In order to do this, in order to weigh evidence, you must consider the believability of the witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests may include the appearance of each witness on the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use the criteria that you believe to be the most appropriate and assign to each witness's testimony such weight as you think proper. You are not required to believe a witness simply because they were placed under oath. There can be a natural tendency to assign less credibility to a person because they do not look like you, talk like you, or worship at the same sort of place that you do, or perhaps more credibility if they are of the same race or gender as you. We talked about this in jury selection this morning. We call this implicit bias. Make sure when deciding any of the issues in the case, including credibility, that you are aware that there may be unconsciously on your part a thought process, and you should check yourself to make sure that your decisions are not based on race, religion, gender, disability, or sexual preference. Again, you're not required to believe the witness of any testimony of any witness simply because they were placed under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered by you for any purpose. Evidence was received that the defendant may have been incarcerated for an offense that is completely unrelated to these charges. That evidence was received only for a limited purpose. It was not received, and you may not consider it, to prove his character in order to show that he acted in conformity with that character. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects in the same condition or whether or not they accurately depict what they purport to be. You will determine what weight, if any, the exhibit should receive in light of all the evidence. It may be that not all the exhibits that were referenced during the trial were admitted into evidence. You are not to draw any inference by the fact that some of this evidence may not be admitted. You will have with you in the jury room the recorded exhibits and a computer without internet access with which to play these recordings. You shall consider whether the recording is a true record of what transpired at the time it was taken. If you find that it is, you will determine what weight, if any, the recording should receive in light of all the evidence. If you are unable to play the file on the computer and wish to view it, please contact Ms. Karoko, who will help you with any of the technical aspects. The defendant is charged in count 1 with felonious assault. Before you can find the defendant guilty, you must find, beyond a reasonable doubt, that on or about December 23, 2024, and in Warren County, Ohio, the defendant knowingly caused serious physical harm to Donald Hopper. A person acts knowingly, regardless of purpose, when he is aware that the person's conduct will probably be of a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability the defendant knowingly caused serious physical harm to Mr. Hopper. Cause is an essential element of the... hold on.
Judge got an emergency text.
I don't know how to turn this off without answering. Sorry about that. All right. Cause is an essential element of the offense. Cause is an act which in a natural and continuous sequence directly produces the serious physical harm and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable results that follow in the ordinary course of events from that act. The state of Ohio need not prove the defendant intended to cause the specific harm that it resulted, but it must be established beyond a reasonable doubt that the harm that resulted was a natural and foreseeable result of his actions. Proof of motive is not required. as to the issue of whether the defendant acted knowingly. Serious physical harm means any of the following. 1, any physical harm that carries with it substantial risk of death. 2, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. 3, any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. Or 4, any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. The defendant is charged in count 2 with assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 23rd, 2024, and in Warren County, Ohio, the defendant knowingly caused, that's physical harm. Counsel, we agree that it's the count 2 is physical harm only, right?
That's correct.
Correct.
So everybody scratch out serious physical harm. I apologize for that error.
Microphones.
Serious physical harm is only applicable to count 1, not to count 2. So it should say the defendant knowingly caused physical harm to Mr. Hopper, a corrections officer in a state prison. The term knowingly and cause have already been defined for you, and you'll use that definition and those definitions for this count. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Physical harm means any injury or illness or other physiological impairment, regardless of its gravity or duration. If you find the defendant guilty of the offense of assault, you will continue your deliberations and determine whether or not 3 additional elements have been proven beyond a reasonable doubt. The first is whether or not the assault took place on the grounds of a state correctional institution. Second, whether or not the victim of the offense is an employee of the Department of Rehabilitation and Corrections. And third, whether the offense was committed by a person incarcerated in the state correctional institution. If you find the defendant not guilty, you do not need to make these additional findings. If you find the state proved all the essential elements of one or both of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any of the essential elements of one or both of the offenses charged, then your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count of the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty of one or both of the offenses charged. I've instructed you on the law in the case. Now I will instruct you on the law necessary for your deliberations and how to conduct your deliberations and prepare the verdict forms. You are going to have with you in the jury room the following verdict forms. I know you can't really see them from there, but they look like this. They have the caption of the case at the top. This one is for felonious assault. We, the jury, in the above captioned case, find the defendant, Jason Snyder, and it's either guilty or not guilty of felonious assault. Circle the one that matches your findings, scratch out the one that does not, and then there are spaces for all 12 of you to sign in ink. Likewise, the count 2 verdict form is a little longer, but it reads similar. We, the jury, in the above captioned case, find the defendant, Jason Snyder, either guilty or not guilty of assault. Then you have the 3 additional findings that you have to make. We find the defendant did or did not the assault did or did not take place on the grounds of a detention facility. We, the jury, find that the victim of the offense was or was not an employee of the Department of Rehabilitation and Correction. And finally, we find that the defendant, Jason Snyder, either was or was not incarcerated at the state correctional facility at the time of the offense. When you have reached your verdict, you will complete the verdict form that corresponds to your decision and sign the verdict forms in ink. You must make all your decisions free from sympathy or prejudice. I have an issue with my touchscreen today. Free from sympathy or prejudice, nor should your deliberations be influenced by any consideration of race, sex, religion, national origin, age, or disability. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of the law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality. without any bias, sympathy, or prejudice, so that both the state of Ohio and Mr. Snyder will feel that their case was fairly and impartially tried. If during the course of the trial I did or said anything that you believe to be my indication on the facts, you are instructed to disregard it. Because this is a criminal case, it is necessary that you have a unanimous verdict. That means all 12 of you must agree in order to bring a verdict back into the courtroom. You may not discuss or consider the subject of punishment. Your duty is confined to finding whether the defendant is guilty or not guilty of the offense. In the event you make the finding of guilty, the duty to decide punishment is by law placed upon the court. When you go into the jury room, your first function will be to select one of your number to serve as a foreperson. The person that you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than the others. The foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. The foreperson also has the additional duties of making sure that the verdict forms are filled out properly and that the blinds are closed during deliberations. In case it matters, it is not the responsibility of the foreperson to read the verdicts. I do that. Your initial conduct upon commencing deliberations is important. It is not wise to immediately express a determination or to insist upon a certain verdict, because, having so expressed yourself, your sense of pride may be aroused and you may be hesitant to give up your position even if it's shown that it is not correct. Consult with one another in the jury room and deliberate with a view of reaching an agreement if you can do so without disturbing your own individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with your fellow jurors. Do not hesitate to change an opinion if you become convinced that it's wrong. However, you should not surrender your position simply to be congenial or to reach a verdict based on the opinions of the other jurors. Deliberations may take place only when all 12 jurors are in the courtroom together with no one else present. Should any juror leave the room, all deliberations must cease until all the jurors are together. During breaks, you may not discuss the case with anyone, even the other jurors. It may be difficult for you to remember all the evidence or the law. If you disagree as to the evidence, you should just try to decide the issue based on your collective memories. If you disagree about the law, refer to the written and jury instructions that you'll have with you in the jury room. If you are still unable to resolve the issue, the court may, under certain limited circumstances, furnish this information. If you have a question, it should be reduced to writing so there is no misunderstanding as to what you request. Then deliver it to the bailiff, who will submit it to the court. Do not include the status of your deliberations in any question that you might submit. Except for those terms defined specifically in these instructions, you will use the usual, ordinary, and customary meaning for those terms. An alternate juror does not participate in the jury deliberations unless one of the other jurors is unable to complete their service. Thankfully, this has not happened, but I am going to retain you, ma'am, as an alternate juror in the case. Ms. Carrilco is going to get your contact information, and she will contact you if you need to return. So you're still bound by all the previous instructions. Do not discuss the case with anyone or permit anyone to discuss it to you, and do not disclose to anyone how you would have voted. When the jury has reached a verdict, she will call you and advise you of the verdict, and you'll be released from your instructions upon your discharge. We have only a few more minutes of jury instructions, and then she will see you out while the jury is getting settled. On behalf of the public and the parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned and then your jury service is complete, you may discuss the case with anyone, but you are not required to do so. Whether you discuss this case with counsel, the press, if there is any, or anyone else after your discharge is a matter of your own free choice. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. Until your verdict is announced in an open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Ms. Carrilco is going to collect your cell phones, smartphones, watches, all that stuff. Keep them during deliberations. If there is a pressing need to contact home, let her know, and we will try to work something out. Make sure that you turn those devices off before you give them to her. Does counsel desire any further instruction at this time?
No, Your Honor. No, Your Honor.
All right, after you retire, select a foreperson. When all 12, I repeat, all 12 of you have agreed on a verdict, you will sign the verdict in ink and advise the bailiff. You will then be returned to the courtroom. Make sure that you do not begin deliberating until all 12 jurors. You can take the jury out.
Sorry, we had a little situation mix up on this end.
Here's a Debbie, here's the verdict forms.
All right, I think we're good now.
Here's the verdict forms, sir.
They're gonna find you guilty. It's just a question of whether you get the full Monty or half. That was me changing the codec on a hyperdeck. When I changed the codec, it caused a bit.
We are on the
brief
record
hiccup.
outside the presence of the jury. Mr. View, anything from the state?
No, Your Honor.
Mr. McKenna, anything from the defense?
No, sir.
All right, we'll let you know when we hear something.
All right. Now we've got two verdict watches going side by side. And did I just say full Monty? I did. Sorry. Told you we shouldn't have arrested, says the defendant. Meet me out back afterwards. Settle this like men. All right. Defense attorney saying, all right, there's another one in the books. Cha-ching, cha-ching. We do have a poll up right now. We're going to end this poll and ask another one. Ooh, everyone's got styrofoam cups. The interns are coming up. What's with the knife you're twirling around? The knife I'm twirling around is it's the knife that's believed to be the counterpart to the sheath, the K-bar knife sheath that was found in the Idaho 4 murders of the Brian Koberger case, if you're familiar with that one. They found a sheath. They found the DNA, remember? The DNA on the button snap. So I got one so we could show you, mostly because people who are not familiar with knives might not understand the size of the knife and how big this thing is. This is the actual size of a K-bar. It does fit nicely in the K-bar knife sheath, like that, and it snaps on right here. So we'll be using this during the Brian Koberger case just to illustrate different points, specifically ones related to the weapon and the injuries that are sustained. So it's a safe version. It's also much cheaper than buying an actual K-bar. Some nice K-bars can run you, I don't know, $300 for a good one. You can get a cheap one as well. But I figure I'll get the nice exact replica of the U.S. Marine Corps stamped sheath that they found at the crime scene and then go with the dummy knife because it'll be safer because I don't want to cut myself on camera and then have YouTube have issues with it. So that works. All right. We're going to finish this as the prosecutor and the defense have a good laugh about the case. Finish this poll right here and do another one, which is going to be very, very important. It's going to be which case returns a verdict first. We are seeing some people come back from lunch in the Karen Reed trial, but we have not seen anything indicating... I haven't seen anything indicating that there's a verdict or a question. So that's just speculation at this point. All right. The current poll that we're going to end right now is Jason Snyder guilty of assaulting a corrections officer? No. Not guilty of either charge, 8%. No, it was self-defense, 4%. Yes, guilty of a lesser charge only, 15%. And yes, guilty of both charges, 74%. That's the trial we just watched right here. I'm going to end that poll with 616 votes in. Those numbers are now locked in the record books. And now we're going to do another poll, which is more important. Which trial gets a verdict first? So give me a second to type this one up. What's another jury? What's another jury? I need a third option. The poll never adds up to 100% because YouTube steals a percentage. They take their cut everywhere they can, even from the poll. When are the Oscars? We're going to include the Oscars on there to see which one gets a verdict first. There we go. And the Oscars don't really have a verdict, like a jury. But there you go. Which one's going to happen first? In the shooting that happened up in the north, the political shooting that occurred with 2 lawmakers getting shot and their spouses as well. Brian Anton tweeted this out. He said, the morning after the shootings, investigators say Vance Bolter texted his wife and family, quote, "Dad went to war last night. I don't want to say more because I don't want to implicate anybody." Sounds like that's going to be like anything you say or do can be used against you in a court. So if you don't see the poll, it's at the top of chat. If you don't see it there, for some reason YouTube doesn't like you and doesn't value your opinion. And I don't know why. I wish we could fix it to make it so everyone could share an opinion, but it implicated him in a big way. Bet Greeners voted. I bet Greeners voted Oscars. Got a couple people voting for the Oscars at this time around. He also shot and killed the family's dog. Man. I mean, I'm not going to say this guy's a loser, but he sure is playing all the cards. Sleepy Vapor, are you asking about this assault one? I believe it's probably going to be in the 10-year range, would be my guess. Might be more because it's an officer. As far as the trial of the guy who did the shooting, the feds have charged him, and that makes him eligible for federal death penalty. Do you know what Jason did in the first place? He was in for assault initially. I know, you're probably surprised. But yeah, assault. When the feds charge, we don't get to watch. Yes, and Brian Enton's in court right now. He's like, sorry, guys, I'm going radio silent because I can't take my phone into the courtroom. Going in right now. So that's happening as we speak. Those are some nice chairs. They look overstuffed, leather, reclining. Pause and Campfires, they caught him yesterday, alive. They got him. Can you watch the fight again? The only way I can show it to you is if we do this. First of all, let's jump to, let's swap 1 and 4. Swap boxes 1 and 4. Come on. There we go. Now we'll turn off box. Which is the little box? Is it 4? That was 1. Turn off box 1. I don't know. We're going to have a verdict so quickly. How do I do this? Oh, it's okay. I'm recording it. We're good. All right. New window. YouTube. We have to go back to this live. The only way I can show this to you is if I rewind my own live stream. Let's see. Okay. So now I'm going to move this over here. Make it full screen and hit play. So it's going to have me talking over it. Ready? It's going to be like this. Let you know. This is going to be body camera footage, so there may be some language here. Just warning. Now the timer is complete. This is the officer. He's going about his day. He's juicing up before the boss fight. It's like part hospital, part office, part jail.
What?
So it's the new me right here. That fridge needs to be cleaned out.
I didn't shoot last hardly. Can I get some potato chips, something? TGI fried chips. There's no potato chips. These are potato skins, and those are like Tostitos.
Tostitos.
I'm cool on the pie. You what? You cool on the pie? Yeah, look a little bit rough, man. Well, make work of them things then, I guess. I'm gonna get this thing rinsed that wash out the cherry. I don't think they ever even opened either one of these. Yeah, neither one of these even got up.
Pause. Hello? Hello? Oh, they hung up. Sorry.
Open. All right, even better. Say what? Oh, goodness. There goes to the closet.
We go wash our dishes. Just a random microwave in the hall.
Oh.
Are we going to watch this whole shift? It's not washing, it's just rinsing. You can wash your dishes and do a quick eye test in the same place. We're watching this whole shift. You ever wonder what it's like to have a career in corrections? Here it is. I'll give you the old me soap, just doing a quick rinse. paper towels.
Good. Pull up. What you got? Pass. No, what else you got? What do you just get out of the trash? There you go.
Just your lights and stuff. There's stuff on the ground.
You're what?
Stuff on the ground.
Can't be picking stuff off of. Man, what's wrong with you? Oh. No.
Can I have it?
No. What else you got?
Stuff I have, man.
Hey, what?
Just rocks and stuff, man. I collect rocks, man. Why are you taking my stuff from me?
What? You're getting called out on the road. Oh, you motherfucker! Go! Right there! You motherfucker! What the fuck is wrong with you? Get here, motherfucker! Hey, go to bed! Hey, go to bed! Come on! Get him up, bitch! Put your hands behind your back, motherfucker! I got him! Let go! Up off! Stop! Back off, Finley.
Why is Santa Claus there? Can someone... Santa Claus responded.
You get it fixed?
We got 8.
Right here? Yep.
So we wash dishes here.
Okay. Let's get that clean. When was your last tetanus shot?
3-4 years ago, maybe. Oh, it's my glasses got me again.
What hit your head?
Okay.
Say what?
What hit your head?
That's it. That's all we're going to watch.
I don't know what you're talking about.
I don't know what you're talking
The
about.
wound on your head.
Oh, your glasses. Oh, my glasses.
All right. Do you know when your last tetanus shot was?
No.
Okay. Now we need to bring back the watch we've got going on right there. That's it. That's all we're going to see. I died laughing the first time this was played and watching the reaction. It's pretty funny. Let's see. Where are we? What are you guys seeing? They're seeing that. Okay. Let's bring on... We need Karen Reed. Pop it up in the corner. Let's see. Swap boxes 1 of 4 again. There we go. That's where we are. I'll turn on one. Okay, we are in live, right? Yep, we're live. Okay, we're good. We're good. Got it all figured out. Knight says, thanks for holding off on the verdicts. The meeting was quick. You can start them now. Sounds great. We'll go ahead and alert the courts that that's available. That now that you're here, we can begin now. Send a quick text. All good. Don't hold the jury. Okay. Right. Just looking to see if we have any updates from Sue, who was there in the courtroom or at the courthouse. Lunch is just about over. Bob Alessi and the tech person came back to the courthouse briefly, but just stopped in and turned around and returned to their court day base. That's from Sue O'Connell. Candy Kiss, if I filed with the court, and particularly in Massachusetts, they're really stingy on who they accept. But usually when you file with the court, you give them a good number and they'll reach out to you and say, hey, we got a verdict. Definitely was not self-defense on the defendant's part. He acted out of anger. Officer didn't even see it coming. Yeah, especially some of the other angles of that attack. The officer was like literally not even looking at him, and he just got cold cocked. All right. Yeah, a couple times in there, some words. I heard some new words that were said this time that I didn't hear the first time. I mean, I heard a lot of MFers, but 8 of them, as a matter of fact. There was a couple others in there that I didn't catch the first time, which I'm not going to repeat. All right, we're going to end the poll. We've got 765 votes in, 766, 767. The poll ends with 81% saying we're going to have a verdict in the Jason Snyder trial, which is the one in the bottom right-hand corner first. 11% say it's going to be the Karen Reid trial, and 6% think that the Oscars will be given out first. I hope those 6% are wrong. We are back now in verdict watch officially. I think my neighbor is mowing my lawn. Good guy. Hey, how's it going? The VMAs might be first. Video Music Awards. Someone give me a funny dad joke. I need it fast. I need levity. Well, seeming as we're just ending lunch, do you want a box for your leftovers? No, but I'll wrestle you for them. How about that? Some bills for the cuss jar, says Bug Dugger. We've added a little bit to that one today. Thank you. If your nose runs and your feet smell, you were built upside down. You want a flashlight? What size of batteries does it take? Those are AAA. I don't have any AAA. I just have AA's. Think the guy needs mental help. This is over rocks he collected. Actually thought they would have had a verdict by now in the Jason Snyder case. Maybe. I was at the hospital for the delivery of my son. I met another father whose daughter was born the day before. He said, "Won't it be funny if they get married?" Now I need to turn off slow mode because we have to wait. We have to wait for what, 30 seconds, 60 seconds? What's slow mode set to? I said, sure, like my son will marry someone twice his age. Okay, that's funny. That is funny. Tony, we're going to keep this one up as long as it goes. Once there's a verdict, we will stop and restart with a new live stream with a new title. That will give us the best. We'll portal, first of all, we'll portal over. It will be almost instant. We'll portal over, and it will also send out the most notifications. It's the best way I can notify people when it happens. A lot of people have things to do, and we'll sort of watch for notification. So, what is brown and sticky? A stick. That's a good one. How long did the jury take in the first Karen Reid trial? I think it was 5 hours, what we determined, right? It is very much a fake K-bar. I did this. I was going to buy a real one. As a matter of fact, my local hardware store has one I was going to pick up. That I think is $197, and it's beautiful. And I love the K-bar knife. It's an icon. I don't have really much practical use for it, but it's a very nice knife. My problem was I'm going to be playing with this quite a bit during the Brian Koberger case, and I know my history with knives, and me injuring myself on a live stream could violate YouTube's terms of service. And I don't want to do that. And so we got the safety knife for my own protection. Did I say 5 hours? It was 5 days on the first one. I think I did say 5 hours. Thank you for catching that. It took 5 days, not 5 hours. You can knife if you want to. That's a safety dance. I caught the reference there, Greeners. I'm not that old. Not there yet. Welcome to the gallery. Thank you very much. Why was the baby strawberry crying? Because its parents were in a jam. Never heard that before. That's funny. 5 days last time in the Karen Reed trial to reach a hung jury verdict. Well, a hung jury. That's not a verdict. It's the 16th, right? A couple of you asked if I've been asleep here at the wheel. No. When I'm in this position, I'm reading and following Twitter, updating, checking through all the people who are updating us on the various cases that we follow. I have the K-Bar Space Force Edition. The Space Bar. Yes, it's a thing. AJ Brown, that's cool. Is it like titanium or something? Playing Candy Crush. I have not played Candy Crush in a long time. Who do I follow on Twitter? For this one, Sue O'Connell has been my go-to. She's been the most consistent and timely with updates without, skewing it one way or another. There are a lot of people out there updating things about the case, but so much of her just putting slant and throwing shade and insults. I don't need that. I can do all my own. But so I follow her. Cat W, welcome to the gallery. Nothing really to update yet, other than that juries are doing what juries do right now. AWOL Podcast says, I don't mind how long a jury takes because they're either looking at all the evidence or actually debating on their findings. It's good. Great. I just got a flood alert for my area. That's exciting. I'll pass. How long will they go till today? The jury has consistently left about 4 o'clock in this trial. And the first day of deliberation, they did the same. So it's probably likely that they'll do 4 o'clock. On a Thursday, they might go earlier because I know there was one juror on Thursdays that had an appointment. The jury can stay later than 4, but they choose not to, or have so far chosen not to. Never get my hopes up with juries. I've been let down too many times. One day to get a verdict, 4 to figure out the verdict form. It's tough. They're confusing, especially when judge uses her preferred method. No deliberation on Thursday. Holiday has court closed. That's right. It's June 19th. That is a federally recognized holiday. How does the moon style his hair? Eclipse it. What do you call a toothless grizzly? A gummy bear. HLF. I believe she's not guilty. Only speck of info I can't get around is not getting out and seeing what's going on with John. Would never drop off my significant other and not find out where she went and what's going on. We cannot wait till Friday for this. It's not the judge's preferred method, but the form used in Massachusetts. The one-liners are flowing in at a steady clip now. My birthday is also a holiday, July 3rd, so I'm accepting any and all gifts, says Josh. It's awesome. I'm gonna do fireworks shows nationwide in your honor, Josh. Does that work? Have you built any Lego recently? Not since the last live stream. Oh, we've got somebody came back into court. So let's take a peek here and see what's going on. Prosecutor's just using the free internet. Ooh, we might have a verdict. Let's see if we get... if people start pouring in, I'm going to play the music. This is in not the Karen Reed trial, just for clarity. I have seen the outside of what's going on. There's a massive showing of support for Karen Reed at the outside the courtroom. Where's Alan Jackson from? I know he practices out in California.
I was told counsel wanted to see me at sidebar.
Do you want to see me at sidebar? Sidebar was working again. He's from Texas. Practices out of LA. I know he worked in the same office as Josh from Courtroom Confidential. He worked with Ms. Little as well. I think they came together. P.S. This angle has 42 chairs, and I counted it during lunch. I like that. And EDB. EDB, I think, yeah. She also practiced out in those parts. Just got an ad. I don't know. YouTube does addy things even when we tell it not to. Court is not in session on Thursday. They'll take the day off. Hopefully we have a verdict before then.
I was told counsel wanted to see me at sidebar.
It's interesting that AJ was a prosecutor and Mr. Brennan was a defense attorney, and now they're swapped roles for this trial. Has Judge Fleischer decided to stream again? I know he still streams on the court feed. Like there's a dedicated website where you can access the court feed, but on an official level, they don't allow restreaming, even though somebody does. And I don't think he has a problem with it, but it's just like it automatically defaults to we don't allow it. EDB is in Tennessee. We drove through Tennessee. I looked everywhere. Did not see her. Please answer my Lego question. When you bought the mosaic, did you buy just the mosaic and then have them lay out your photo? How does that work? You buy the mosaic and it comes with all the parts, which I have I've since shipped to my daughter-in-law. She likes Legos. So I don't have the mosaic anymore. But you get like 900 of each of the 5 shades, like yellow, gray, black, white, darker gray. There's a couple different shades. You get like 900 of each. And then you go on the website, the mosaic website where you buy it, and you can upload a picture and it will create a map for you on the screen that you can print out or you can just access on a device. So you can just build your own picture as many times as you want for free, and it will orient it and lay it out and convert it to a mosaic setup. But it's a lot of work, and let me tell you, it hurts your fingers. It's not fun to make. People are coming back in, so I think we might have something. If Karen Reed loses this one, will the same team help her appeal? I doubt it. I doubt it. Appellate attorneys generally focus on being the appellate attorney. Oh, got a new face on the defense table. Or just somebody who wants to try out the chairs. Probably some other docket work that needs to be addressed. Correct, map how much the camera switches. I think it rotates like it's on a security cycle. Carolyn RH, I leave for Tennessee next Monday. They need to come up with a verdict before then. If Karen Reed gets found guilty of operating while intoxicated, would the family still get to read impact statements? And would it be limited to just talking about OWI? That's a great question, Shannon. I would think that, yes, they still get to read impact statements. Really could use verdict music for this one since we might not get it if KR's tomorrow. Okay, I've got to figure out how to do verdict music tomorrow. I'll just upload it to StreamYard. Let's do a quick... for the audio. This looks like this is other docket work. Quick case that's come up. These interns look so young, like 6th graders. How can that be? And like the boy there on the end, I think his mom tied his tie for him. He's just a kid. Oh man, we did this once before. I think we did this with Adam on Top Mark Media. We carried a live stream that way. Here comes prosecutor. Different defense table entirely. Judge is coming in. Different case. Brings his mil-spec
Alessandro,
laptop.
did I get that close?
That's correct, Your Honor. Rob D'Alessandro, Matt Burns on behalf of the defendant. Thank you.
All right, we're here today for a hearing on the expungement. The court is in receipt of the report from probation, which is still sitting on my desk. State have any objection?
No, Your Honor.
Anything I need to know about this?
Your Honor, I think I pretty much included everything in my application in motion. I'll just note my client has done pretty much everything you can ask for of someone after a conviction like this. He's been sober for 15 years.
Hey, that's awesome.
Has not been convicted of any other offense since that time. Has become very successful in his business, and these convictions in particular are the ones that are holding him up from expanding his business. He flew in today from Utah to be here for this hearing, and we appreciate the court's time. Thank you.
Anything you want to tell me?
No, I'm just very grateful to be here, and I've done a lot of hard work in the last 15 years, and I've made a lot of bad mistakes, and I sincerely apologize for my past.
All right, I'm going to grant the request to expunge your record. We'll send you a copy of the entry in the mail. Actually, we'll email it. Make sure when your attorney sends you this via email, hold on to it, because they're going to obliterate this file and you won't be able to get it later. So if somebody says, hey, you were convicted of this, and you say, no, I got it expunged, and they say, prove it, you can't go to the courthouse and get a copy of that entry.
Amen. All right, thank you.
All right, that's all.
Thank you, Judge.
I get an amen. We're going to expunge your record, but then we're going to delete the evidence that we expunged it. So if people say, hey, this happened, we'll be like, I don't know.
All right.
That's forever. But I'll save it for you, sir. I got it right here on the channel if you ever have a problem. Make copies. Send one to the the bank vault. I believe the courtroom is cleared. I believe so. I haven't heard that there's any other business going on in that court. We wait. Yeah, they've had enough time to watch all the videos, and after watching the videos, I don't know how you can come to any conclusion other than guilty in this little case. But all right. I think if I transfer the audio right now, it may cut my mic off for just a minute. So give me just a minute. See if I can transfer the verdict music to StreamYard. Can you still hear me? Okay, it's working. It's transferring right now. Sue O'Connell just posted no news. No news. We wait. Sue, I saw her post. I'm like, what's going on? Nothing. Just absolutely nothing. I think getting your DUI record expunged is worth a plane ticket from Utah. I think that was a good move. Do you remember the court? What was the court we were in that had the camera that aimed at the little red light on the wall where the jury flipped the switch if in case there was a verdict or a question? We sat there and watched this light switch forever. And it was funny because we looked at it and we're like, that switch is really dusty. Like there's tons of dust on top of the light. And then like a minute or two after we announced that, court person came in and like dusted the button and then went back off the screen. Do you remember that trial? Which one was that? We watched the red light for hours and then it came on. It turned on. Was that Rittenhouse? No, it wasn't Rittenhouse. It could have been the same courtroom. Could have been Zachariah Anderson, but I didn't do Rittenhouse. Wasn't the tree house unaliving? Oh, that was down in Key West. That could be it. Gailey May, that might be it. It's probably a year ago. Wasn't Anderson. Rust? The Rust, the first one, not the Alec Baldwin. Wasn't Treehouse. The early verdict light was the kid who unlived his parents. That's the one that shot him and walked down the hall. And Catsy member for 17 months. So glad to be here today. Verdict watching with you all. Thank you very much, Catsy. Congratulations on 17 months. Okay. Error downloading sound. I've got it already. So now we open StreamYard. Live stream. Unlisted. Test. Hang on, we're seeing if I can get this uploaded. Enter the studio, go to my media assets, and load up some music. File's too large. Ugh. Size limit for music tracks is 30 megabytes, and it's a wave. I need to compress it. What's that? It's been silent. No questions from the jury so far. Almost 8 hours of deliberation, assuming they deliberated through lunch. Import desktop, import the wave, and now convert to AAC. Would that be smaller? We're going to get this added to StreamYard here eventually. Add music. Just had news texted me from the New York Post about a guy who just charged into a lower Manhattan courthouse and slashed 2 officers in the neck. In Queens. That's wild. Oh, Greeners. That was Greeners that sent it to me, but that was Tuesday. No, that was today. This one, he sent me the button. Yes, that's the one. It was ex-boyfriend hitman trial. Darren Lopez Day. Thank you, Greeners. Okay, it's uploading now. Processing. We'll have the verdict music on StreamYard, so I'll be able to do it from River Road. The jury light was in West Virginia, Natalie Cochran. Have we had 2 jury lights? That's wild. I need to play this, but just for myself, not for you guys, so ignore the sound. Can't tell if it's working or not. I think both the ladies in the back of the courtroom are getting a little bit of sleep right now. Josh, I know. Somebody's going to be like, it was just one punch. But, you know, that's enough. It would be crazy if the defense, the little tiny defense that he put up, it's like, his nose could have already been broken. That's like the reasonable doubt. And they're like, yep, not guilty. What's the next interesting trial? I am really looking forward to the one that's happening in August, which is Brian Koberger, as long as it doesn't get pushed out. So August 11th is going to be the next one. It's going to be really good. I think it's going to be fantastic. It's going to take a lot of tracking details, because I think there will be points where the details either do match up or don't match up in critical ways. And it might even take, the Brandy Churchwells of the world to find those little points. Want to see Corey Richens? Corey Richens has pushed all the way out to February next year. So it's 2026 for that one. That was just announced here last week. Pardon me. I just have to keep watching Twitter to make sure nothing's happened. Wow. That shooter, Kevin Bolter. That's some crazy stuff. He wore like a latex mask, a fake mask. Got a whole bunch of guns in his car. Are we at 44 minutes for this one? I've not been timing this one. Everyone knows the best disguise is a sombrero and a distinct gait. Jury selection February 10th through 13th and 17th through 18th in 2026. It's only 5 days. It's 5 days to seat a jury, but I think just because I know a lot of people out there, a lot of them don't know about the case. So I think it will be very possible to get the jury seated pretty early. Jury trial will commence February 23rd and run for 5 weeks. Let's see. I know I've said we thought about going to Brian Koberger, but because the judge is streaming it on his channel and giving us access directly to that, it's negated the need to be there. But Corey Richens is a different story. I might have to go live in Utah for a month. Do you know why I can't renew my membership? Amy, I can tell you might have 2 different accounts on YouTube. Check and make sure you're logged into the right one. You might have like 2 emails that log in, and one works right and one doesn't. Donna Adelson. What are the dates for Donna Adelson? Do you guys, anybody know off the top of your head without me going to Discord? Security camera was shocking when you see the mask. Adelson. August. Vivian says, "Can you tell me about Corey, please? I'm in Scotland, so I haven't heard about him." It's a she. Her husband was the victim. What happens in the Corey Richens case is Corey Richens was sort of like a high-end real estate flipper. So she'd buy really high-end houses and try to sell them and fix them up and sell them. And she wanted to buy this monstrosity of a property that was like partially finished and never completed, and her husband didn't want her to get it. And they fought about that. And then he died, and the next day she bought it. And then she also wrote a book because she has a couple kids. And her book was about grieving for children, about losing their dad. And it was something about, are you still with me, or something like that. And she went on this book tour, went on Good Morning America, went on a bunch of other TV shows talking about this book, sold it on Amazon, sold it online. Only problem was she's accused of killing him, poisoning him with like a Moscow Mule with fentanyl in it. And the case gets crazier the more you dig, the further you dig, the deeper you dig. Her mom had a significant other who died under suspicious circumstances that might have been related to some sort of drug situation. She wrote a letter to her mom at the top that said, was it walk the dog in big bold letters like it's a code, and then had instructions that to the casual believer would look a lot like jury of witness tampering. What to tell witnesses to tell people, what to tell witnesses to tell her lawyer, how to pin things this way, what to look to find certain pieces of evidence, that sort of stuff. When discovered, she claimed it was just a manuscript for a book she's working on, even though it had like her lawyer's names in it and her name and everything else. It's a wild case. It's a wild case. She's had some pretty, like Sky, her lawyer Sky was pretty out there with with drawing attention. It was crazy. The whole scorched earth, tried to disqualify everybody, the judge, the prosecutors, everything, and then disqualified themselves. Blair says, I wish people would stop killing each other. Donna Adelson, jury selection on the trial are set for Tuesday, August 19th. Okay. We'll have to look at how we can get the feed for that. It might be something we cover on Top Mark Media at the same time as the Brian Koberger case. It's going to be tricky. Let's see. If I was in jail for murder charges, I would also try to write a book. I've traveled to Utah and been there in court for a couple of the hearings for Corey Richens. I'm in the media pool for that one. We filed for that a long time ago, long before these delays started. And so I've got all my connections to go set up there. But just not sure what's going to happen. Just looking forward to watching Sky. She recused herself now. She did. Is it a retrial or first trial? It's the first trial. Sky, they parted ways. Yes, road trip. I think I'm going to fly this time. That's a long drive. It is well worth catching up on some of the Corey Richens stuff. There's so much. The judge in Corey Richens' trial, amazing voice. Amazing voice. House long till verdict. 8 hours of deliberation time in the Corey Richens trial. I think we're over the half-hour mark for this Jason Snyder one. Corey is not in Sarah Boone League with lawyers. No. She has some money, so she's paying for her own lawyers. Sky's office was conflicted out, but before they did the conflicted out thing, they burned down the bridges. They burned everybody. They threw everybody under the bus. The prosecutor, the judge, you name it. It's over an hour on this one. Crazy. Will you set up residency in Idaho for BK? No. Only because the judge is now giving us direct access to the feed. we also have some friends of the channel we might be partnering with to get us some outside courtroom views through the wonders of live view. Be able to see what's happening outside the court and have the inside the court stuff, just so we can get the mix of the two. It'll be a lot easier because the courtroom feed doesn't give us updates about when they're coming back or anything else. And if we were able to watch outside and say, okay, everyone's headed in, that we know when to refresh because the system the court uses is terrible. Donna would be awesome to cover. Amber, you know the work we need to do to get into a case like that. Let me know. Let me know what you think. Do we have to start sending some letters out and all that? Who is the lady on the left side? I don't know. I don't think she's related to the defendant because she's seated so far in the back. So it's probably a reporter or a casual observer. Maybe there are people in some courts who just sort of live in the courtroom and like to watch. This is what they do for entertainment. I couldn't blame them. I'd love to do the same thing. No court on Friday for Karen Reed as well. That means it has to be Wednesday at the latest. I'll give you the go-ahead. Let me know if there's anything I need to sign. And as far as like all the credentials and things, anything I need to send. Larry Foreman said, if convicted on DUI in Massachusetts, you can be in prison for up to 2.5 years. No mandatory minimum sentence. Larry would know. He's done a lot of work in the DUI range for self-defense, for defense. She's just there because she wants the AC, and it's hot. Ashley says, I can't wait to get older and just wander around and watch different courtrooms for fun. Why wait, Ashley? Let's do it now. Just figure out how you can do it for work. People like to watch trials? No. I've never heard of that. Remember, the judge instructed them to look at all the evidence again before they do anything. In this particular case we're watching right here, the Jason Snyder, the judge instructed them to, or at least the prosecutor said, watch all the videos. It'll only take about half an hour or so. So they might have, once they got in and voted for a foreman and figured out how to do things and set everything up and watch the videos, they might just be finishing that up. Check Twitter and see what's the latest. All right. Nothing new. Sorry, I got sucked into Twitter so easily. Nothing from X. Someone was asking about Donna Adelson. She's accused of being involved in the murder for hire plot of her former son-in-law, Dan Markell. Francis is like, you watched the crime on video. What's the holdup? The jury has been deliberating longer than the case and defense presentation. Juror number 2. It's a movie about a man who's called to be a juror for a crime he thinks he may have committed. Oh, man. That's like a psychological thriller. I'm sure a lot of people are a ball of nerves and anxiety right now in that courthouse. They're all like, why did nobody mention Santa? Did you guys see Santa in that? Why was Santa there? I realize it was right around Christmas. Makes sense. Do they get lunch in this court? They do, but it's they've already had it. Lunch was over. It came, lunch concluded, and then the jury got the case in that order. Maybe it's Pork Chop Monday. I have filled up an entire card worth 128 gigabytes of video today on one side. Let's see. This one's dropping frames. 1 second. All right. This is another 39 minutes. Sent you a verdict is in song on the burner. Is this a custom creation? Tumwater, Troy, is this one you made? Like, do you own the full rights to it? Right. Do you give me permission to play it without any compensation, now or forever? Of course, he says. Let me listen to it first. Oh, it's got like an Erasure type feel to it. Like late 80s music. It's definitely AI. You can hear like how the timing's not quite right. And it uses some weird words too. Yeah, it seems like it almost does Dr. Seuss. Can we just keep our normal... We're not getting rid of our verdict song. It's almost Dr. Seuss-like, where it just finds words to rhyme and fill up the space. All right. Man. Taking a look at the clock, it is 3:30 on the East Coast. And... I would think we're at least going to get one verdict today, if not the Karen Reed verdict. Troy, thank you for that, Troy. I'm going to be very cautious with what I play verdict related, because we are watching such a high profile case, and so many people are just like listening in the background, and I don't want to send out shockwaves. And get people confused about that. Okay. Okay, Jessica Machado. I don't see anything from her. Utah lawyer got sanctioned for using ChatGPT. I think I saw that news. Got defense here. Maybe something's happening. Okay, I'm going to play the music. You ready? Just for this little trial, not the Karen Reed trial. 12 jurors listening to the fate or deciding the fate of Jason Snyder versus Ohio. Jason Snyder, currently serving time in the penitentiary, is here in court again because he's charged with assaulting a police officer, namely a corrections officer. Punched him in the face, and he did it all on camera. Even Santa saw it happen. Not much here for the jury to decide here, but I think they've done their work. They've done their duty. They can go home, have their parking pass punched, and feel good about the work they did. Not really a lot of question about guilt here. His own lawyer asked them to find the lesser of the two charges. This was not a who done it or did he do it? This was but was it really as bad as they say type case? And the jury's going to let us know. There are 2 charges they can convict him on. If they agree with the prosecution, they'll return guilties on both. If they heard the defense and some of that resonated with them, they will.
All right, Ms. Kuroko, you can get the jury. We are on the record outside the presence of the jury.
A mixed verdict.
Hey, Judge.
There's no way there's
Do you
a
want to talk to
question.
the jury afterwards? No? Okay.
No.
I know Mr. View's position, only if they want to talk to him.
Forward you the motion about fire.
All right, the jury is being fetched. The judge is using wording that makes it seem like I was right in guessing this was in fact a verdict and not a question. All the interns are here. The bailiff says, stand up. Stand up. Show some respect. The judge will read the verdict in this case.
You may be seated.
Almost perfect timing on this.
Ladies and gentlemen, it's come to my attention that you have reached a verdict without disclosing the nature of the verdict. Who's been selected as foreperson? Mr. Gum, has the jury reached a verdict?
Yes, Your Honor.
All right. Was everybody able to follow my instructions and admonitions while you were deliberating?
Yes, Your Honor.
All right. Ms. Kruko, if you could get the verdict, I want to thank you in advance of the reading of the verdict for your time and attention to this case. After the reading of the verdict, you will all be discharged from your service, reunited with your electronic devices. Verdict form reads as follows. Count 1, felonious assault. We, the jury, find the defendant, Jason Snyder, guilty of felonious assault. It appears to have 12 juror signatures affixed. Count 2, we, the jury, in the above captioned case, find the defendant, Jason Snyder, guilty of assault. We further find, so we have one that does not have an answer to it. So what I'm going to do, ladies and gentlemen, I take back what I said. You are still governed by the instructions and admonitions that I have previously given to you. We have number 1 under the subsection that has not been completed. So I'm going to send you back to the jury room to go ahead and circle that one if you can reach a verdict on that issue. I'm just guessing that you forgot to do that, but I'm going to send you back in to continue your deliberations. I'm going to return these verdict forms to you. And just let Ms. Kuroko know when you have reached the verdict.
No, you don't get the music twice. Defendant's like, you had one job, Foreman. You had one job. Now, this is the worst wait ever for him. He knows they found him guilty on both, but he's just waiting for the paperwork. And then they're going to reenact the whole thing again. Okay, don't hold your breath. I think they're done.
On the record, almost outside the presence of the jury.
Doors wedged open.
Okay. We're on the record outside the presence of the jury. So the finding on the grounds of a corrections facility was not completed. The other 2 were. So we'll send them back.
The judge should have looked over both of them completely before he read them.
My advice for everybody would be to wait here.
Yeah, hold your breath.
It's not going to take too long, but if it seems like it is, then we'll go ahead and send Mr. Snyder out. Probably makes sense just to wait here, though.
They come back in. We have a new foreman. we have a new foreman. It's like, psych. Yeah, we changed our mind. Oh, man. Happens occasionally. The jury doesn't quite... get it right. Students there quietly smiling. All rise for the jury. He's like, look, I didn't read it. I just signed the bottom. It's your job to fill it out.
All right, you may be seated. We are now back on the record in the presence of the jury. Mr. Gum, did we resume our deliberations?
We signed circled the correct ones.
All right, so count two. We, the jury, in the above captioned case, find the defendant, Jason Snyder, guilty of assault. We, the jury, further find the assault did take place on the grounds of a corrections facility. We, the jury, find the victim of the offense was an employee of the Department of Rehabilitation and Corrections. We further find the defendant, Jason Snyder, was incarcerated in a state correctional facility at the time of the offense. Do these verdicts accurately reflect the verdicts of the jury, Mr. Gum?
Yes, Your Honor.
All right. Mr. View, anything from the state?
No, Your Honor. Thank you.
Mr. McKenna?
Poll the jury, please.
Poll the jury.
All right. So what I'm going to do is, for each of you, I'm going to ask you 3 questions, and I will ask these to you individually. So, Ms. Daniels, did you hear the verdicts that I read in the courtroom? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. Ms. Cray, did you hear the verdicts that I read in the courtroom? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes.
Got a spam call.
Mr. Jones, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. Ms. Dunn, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. Ms. Burns, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. Ms. Appleby, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Mr. Gum, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. Ms. Edward, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. So we move people. Mr. Collins, right? Yes, sir. Did you hear the verdicts that I read?
He just remembers
Were those
everyone's
the verdicts
names.
of the jury? Yes. Were those your individual verdicts? Yes. Mr. Luxembourg, did you hear the verdicts that I read?
Yes.
Were those the verdicts of the jury?
Yes.
Were those your individual verdicts?
Yes.
Ms. It's Homan, right? Did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? And finally, Ms. Burns, did you hear the verdicts that I read? Yes. Were those the verdicts of the jury? Yes. Were those your individual verdicts? Yes. All right, ladies and gentlemen, this concludes your service in the matter. You are all discharged from your service. Ms. Kuroko is going to return you to the jury room. I'm going to come talk to you for just a minute, and then we'll get you on your way. Thank you again for your service in this matter.
All right. And with that, we're done. I'd be changing my name. There are some courts where it is perfectly permissible for the media to show the jury. It's tradition not to, and many courts have rules against it. But
Mr. View, anything from the state?
Your Honor, the victim is present. He's been watching the verdict remotely. He said that he did not want to make a statement on sentencing if the court intended to go forward with sentencing today.
Do we have a jail time credit figure?
I don't. I know he was released from his prison, but I'll get the date. And I can...
Why don't we take 15 minutes? Plan on being back here at 4 o'clock for sentencing. Is that okay with you, Mr. McKenna?
It is, Your Honor.
All right. We'll see everybody back here at 4 o'clock.
We've managed to stick with this court all day as they went through the entire trial experience, including sentencing, in one quick run. Oh, man. The thing is, jurors, their names are in the records on the file. there's a, they're shaking hands. There is a long-standing rule in court that the jurors can be viewed by the public in the courtroom. Anyone who walks into the court to observe can see who they are. They're designed to be selected from your local community, so the odds of them being recognized are high. I don't know. It's funny that we say we can't, but we can't show it on TV. You know, we can't show it on the news. We can't show it on the internet because we need to have them anonymous. And the question is why? Because they're not anonymous in any other way. All right, that was quick. 15 minutes. He's going to be let's be headed back. I'm not sure if I'm a big fan of the white shirt and white tie look. Is that what it is, or is it blue? Can you see? Let's see if it'll change. Looks like white shirt, white tie. Could be blue. Because the internet is a horrible place. At least where I live. I got a prank call during the middle of that, and I asked him to call back. He did not. The shirt looks like the heart of the sun to me. It looks like fusion. Fusion's taking place on his shirt. About light blue shirts, we should probably do a poll. I prefer not to show the jury. I wouldn't want to be shown. My laptop, the chairs are all teal. Here they're tan. There they're teal. So they switch. This is teal as well, then tan. There's too much yellow in this one, but the white is pretty good. Like the styrofoam white, it's blown out, but it's white. In the other view, there's way too much blue and green. Blue and gold. Are you still eating bourbon pickles? Yes. I actually tweeted out a picture of spicy bourbon pickles today when Domino's asked, wrong answers only, what's the best topping on a pizza? So I said spicy maple bourbon pickles, which actually are not good on pizza. I don't like them. Don't like mixing those two. Johnny Thunders. I have major chair envy. I will tell you this. This chair that I like, this high chair, which works really well for my standing desk, which I haven't. My wife, one of the things I got on Father's Day was a standing desk mat. So it's like a padded floor because we have hardwood floors, and standing on hardwood floors all day long is just no fun. I need to bring it down here because it's currently up in my room, and need to get rid of this chair and stand up and exercise more. I already went on a bike ride this morning, though. You can't, attack me for not doing any exercise. I did it pre-trial. And be reunited with your electronic devices. Yes, they do confiscate all their electronic devices in this particular courtroom. Others just tell them not to use them. Others tell them to leave them in their cars, which is a great way to get them stolen. I know someone who just named their mini donkey Pickles. Sweet. Virginia, I've seen, I think it was Kurt, who, by the way, congratulations, hit 150,000 subscribers today. Kurt, Uncivil Law, was saying that if this jury convicts Karen Reed, it will be because of the statements that were played that imply guilt. Don't think an e-bike is exercise. Hey, well, hear me out. My bike accelerates on its own to 20 miles an hour. I ride at 30. So I have to be in the top gear and pedaling. I'm in 7th gear because it only has 7 gears. And pedaling as fast as my little legs will go. Constant tension. It's a workout. I just happen to be working out faster than other people work out. Thought the bikes went to 20. Okay, so technically, you're right, Kerrville. You're calling me out on this one. 20 miles an hour is what they'll do on throttle alone. They will assist up to 28, but I ride at 30. So I'm basically pedaling. You know, I'm basically pedaling at 2 miles an hour for 2 miles, but the other 28 are free. So I'm it's not a workout anymore. You've shamed me into admitting the truth that it's basically worthless. Then why am I so sore? They're banned over here. Where are you at? Mine's a class 2. Usually class 2s are allowed pretty much anywhere a bicycle's allowed. Well, in my head I was working out, and now you've shamed me into admitting the math, and it just doesn't add up. Downhill, tailwind. It's flat. Okay, there's like 2 to 3 feet of elevation change in a 16-mile ride for me. There's nothing. But did you drive backwards into a taillight? No, I did not. Shame, shame. I'm going to have to film myself writing, and you tell me if it's a workout. Okay? That's like saying that running on a treadmill isn't really running because the treadmill pushes your legs back for you. I'm pumping my legs on that bike, and it's a workout. You're trying to burn your bike out. The bike's designed for just use and abuse. It's an off-road bike, full suspension. I hope I don't ruin it. I get a new battery. Second battery arrives tomorrow, which will make it go from from a 20 to about a 35-mile range on 2 batteries. Hey, Angela, welcome. Good to see you here. We're waiting for a little trial we've been following just today, this Jason Snyder trial. You probably didn't hear about it, but you should have, because Santa Claus was involved. We're just waiting for the sentencing, which will happen in just a couple minutes. I agree. There's a couple factors here, Vern. The e-bike, for instance, weighs 70 pounds. And so you add that to the weight that I have, which is, let's just say, substantial, and leave it like that. And now accelerating all that weight above what the e-bike will assist with, it's a workout. I see it like this. It will help me get to 28 miles per hour, but then I have to then it's all me to keep it at 30. My truck is pedal assist, no throttle. I can do it either way. Yeah, Santa Claus was there. You'll have to rewind, because we can't rewind this court. They don't allow that for some reason. Detect vids. Let's see. Orb says, I want to see you go 60 on your bike. The bike, actually, I can get deep into the settings. I've already done it and changed the throttle, so it will throttle up to 61 miles an hour. I don't know why it's 61, but that's the cutoff, 61. I don't think it's safe. John O'Keefe family and an HB going to the courthouse. Whoa. Okay, I see this. I think it's just the end of the day. The judge is going to bring the jury out at the end of the day, just like she did at the beginning, and say, all right, now you're done. Now go home. Greener sent a post on X for me. Says, Manhunt Edition. Iran, or Manhunt Stream Iran edition. Apparently there's a prison break in Tehran, Iran, with prisoners escaping right now and just walking along the side of the road. Might be a little hard to follow the police chatter on that one, Greeners. And I'm pretty sure we don't get the same air traffic control coverage as before. Another update we got was that there will be court on Friday. So Thursday is off, but the court will be here on Friday. That came from Sue. The defense team is traveling back to the courthouse right now. They are 10 minutes away, so we have about 10 minutes. We expect something. We might have conflicting court cases. So let me stop this. To format these drives. All right, so now we have time. It's got another 3 hours of recording now. High def. So with everyone coming back to the courtroom, this does not indicate that there has been any sort of progress, at least reportable progress from the jury. It's, if nothing else, if we look at the time, it's because we're at the end of the day. They did say the jury could go later as a thunderstorm moves into my area. So, but the jury last time said we want to go home at 4. Harley made an e-bike? This is crazy because Harley Davidson, for those that don't know, is a fine, high-end, American-made motorcycle that has a very distinct sound caused by like a slightly out of sync engine. And in the paperwork where they patented the noise that it makes, they described it as potato, 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 potato. Wisconsin made, says Ivan. Let's point out, not just American, Wisconsin American made. You lose that sound with an e-bike. So unless you have like a little speaker on there that sounds like a Harley, I just don't know. You got Buells as well. They're good. What's Crystal? I'm just saying that if you're in a foreign country and have not, don't know a lot about motorcycles, you wouldn't know about a Harley. We have a lot of foreign viewers here. Electric Harley. It's like the modern hard drives that make the fake clicking sound. I believe there was a lawsuit, if I remember correctly, when Harley was trying to patent the sound, right? The distinct sound that a Harley makes. there was a lawsuit, and the Harley representative basically said, line up 10 bikes, do a blind test, blindfold me, I'll tell you which one's the Harley. And the other guys refused to do it. They're like, no, you'll win. You'll win. Here we go. Sentencing.
Back on the record in the case of the State of Ohio versus Jason Snyder, 25 CR 42536. Present before the court is Mr. Snyder, represented by Mr. McKenna. We have Mr. View from the prosecutor's office. We are here today for sentencing. Any reason not to go forward with sentence today?
No, Your Honor.
Excuse me. Couple of housekeeping matters. We do have a charge that carries with it a Reagan-Tokes sentence, being the felonious assault. I did provide Mr. McKenna the notification and definite term Reagan-Tokes. Mr. McKenna, did you have the opportunity to review that with Mr. Snyder?
We didn't read the whole thing, but we've discussed this before, and I'm giving him these copies.
Okay, so Mr. Snyder, I can read all of this to you, or if you're satisfied that you understand Reagan-Tokes, we can just keep going.
I understand.
All right. Secondly, we have notification post-release control. That's Court's Exhibit 2. We have a mandatory period of post-release control of anywhere from 2 to 5 years. No, 18 months to 3 years. Sorry about that. Again, do you want me to read this to you, or are you satisfied that you understand?
I'm satisfied.
All right. Mr. View, on behalf of the state or on behalf of the victim?
Your Honor, as I had put on the record previously, Corrections Officer Hopper was informed of his right to be present and to make a statement to the court. I believe he's watching the YouTube stream, but he indicated to the victim's advocate that he did not want to be present and did not want to make a statement to the court in terms of what the court's sentence is. In terms of the state's presentation regarding sentence in the case, the court, I believe, did you have an opportunity to review the the pretrial services report at the time of bond in terms of his criminal history?
I did.
Given the defendant's prior significant criminal history, including prior violent crimes and multiple sentences that resulted in prison sentences, it's clear that the defendant is not a good candidate for community control, that repeated involvement with the criminal justice system and prison sentences have failed to change his behavior. The seriousness of the assault in this case, and just for purposes of the record, I do stipulate these two charges would merge and the state would elect to proceed on count 1, the felonious assault. I think the court's had an opportunity to hear about the impact of the defendant's criminal actions onto Officer Hopper. Additionally, I think it's clear that the defendant has never taken responsibility for these actions. He showed no remorse in the case. And given the seriousness of the offense, any sentence other than a prison sentence would demean the seriousness of the offense. State's recommendation in this case is an 8-year prison sentence with a maximum indeterminate sentence of 12 years.
I said 10, so 8 to 12.
I have 67 days as the jail time credit.
And no
My
restitution?
understanding is there is no request for restitution.
Mr. McKenna, on behalf of Mr. Snyder?
Judge, on behalf of Mr. Snyder, he's 38 and a half years old. He has a GED and 2 children. He does have a prior record. His demeanor in court was very respectful and polite to the court. And he would request that he get a reasonable sentence, Judge. Thank you.
Mr. Snyder, what do you want to tell me, if anything?
Do I have to say anything?
I definitely am remorseful. I didn't know how old that man was when that happened, so I feel bad on that end of it. I had some stuff going on with my mother. She's sick. She's dying, and one of the things that was taken that was left out was a crucifix that I had in one of them containers with my rocks. I had meditation rocks that I've had with me the whole time, and so that and I kind of remember it a little differently than the way the footage showed, but not trying to be disrespectful. I don't care about prison. I've been locked up my whole life, so if you decide to go with the state's recommendation, it doesn't affect me nonetheless.
You're gonna have to speak a little bit louder. I'm having trouble hearing.
As far as like the sentencing goes, whatever you feel's appropriate. The time doesn't bother me. I'm not trying to be disrespectful, but I've been locked up 20 years, so it's nothing else. I think I might be institutionalized.
All right, well, considering the nature of the offense and all the purposes and principles of sentence, I do think that a prison sentence is necessary. So, Mr. Snyder, I'm going to sentence you to a 4-year definite term. That means that you have an indefinite term of 6, so you're going to receive a prison sentence of 4 to 6 years in prison. I'm going to give you credit for the 67 days that you have already done. I'm not going to impose a fine. I am going to impose the costs. The 4 to 6 year sentence again means that you're presumed to be released at the minimum term, but the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum sentence. Also, this includes a mandatory period of post-release control. That means the adult parole authority is going to supervise you from anywhere from 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you have the right, or then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically, whichever of those is the longer period, it's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you at no charge. You have 30 days from the date of the filing of the judgment entry of sentence, which I anticipate will be today, to file a notice of appeal as of right. Anything else we need to do? Anything I forgot?
No, Your Honor.
All right, good luck to you, Mr. Snyder.
Sure, thank you. Thank you.
It's a sad outlook. I don't care about jail time. Been there pretty much my whole life, at least the majority of it. Wow. The judge went with a light sentence, lighter than the light end the prosecution asked for. 8 to 12 is what they asked for. He went to 4 to 6, so basically halved it. And that concludes the Jason Snyder versus Ohio case. It's now done. And we're going to go ahead and say goodbye for now to Warren County as we watch the clock tick up to 9 hours of deliberation time for, let's swap these out right here. Boom. Let's go back live to the Karen Reed courtroom. And let's turn off box 1. There we go. Court is reconvening at 4:20, which means we're going to be wrapping up for the day. We don't have word of any news, right? That this sounds like it's Judge Beverly Cannoni deciding when we come back in and call it for the day, instead of the jurors announcing something. No news of a verdict or question or anything else. There's been no questions, and it's been a long time since we've had a trial with no questions like this for a full day of deliberation. Usually you get at least one fairly early on, but none in this one. I believe the jury is going home for the day. They'll be back again tomorrow. Fabulous timing. You could be a professional at this. Chef's, yes. So now we're back in the verdict watch with Karen Reed. We expect when the judge comes back in, she tells the jurors she's so proud of them and they're doing the good work, and she's not rushing them, and they need to speak up a little bit or they have to turn off the fans. Something like that is going to happen. And she'll give them the same 3 instructions: not to talk to anybody, not to talk amongst themselves, not to be on social media. Hey, how you doing? It looks like they're wrapping up for the day. No verdict. So we'll set up the studio in the car tomorrow and take it on the road for camping. Yay! The judge, 420. Everyone's drawing the judge says 420, huh? 420. A lot of people picking up on that. It's not fair to us cutting out early. We're not reporting rumors. So unless we have something significant to report, think Julie Janai posted in a question form 6 minutes ago that there's the Karen Reed team returning to the courthouse signals some kind of movement, and she said question mark afterwards. She said verdict question mark question mark, or they want to go home early question mark. So basically, it could be anything. This is not an announcement, or it's not anything I would count as an announcement. Why is my counter so different from everyone else's? There's somebody else who's saying that, oh, that was 5 hours ago. Never mind. That makes sense. It's not a verdict. There would be all sorts of there is so much news wrapped up in this case. There's so much news wrapped up in this case as far as interest that they're going to find out. The court would be telling them and giving them a heads up because they need to know. There's a lot of pieces and parts they have to spin up for a verdict. We've heard nothing from the jury. They've been working in silence this entire time. Nothing. Let's see, is it just me or all the volume levels all over the place today? So low from Courtroom, Scott's mic very soft and then very loud. That's probably... Oh, I've been on the right level all day today. I've just been quiet now and then. My clock is off. That's because the reason why I put my clock off is because the judge instructions to the jury were that they could deliberate through lunch if they chose. And the jury has not spoken to the court about their wishes there. They have not had any communication that way. Lunch is just provided to them. So, yes, the court took a lunch break, but we don't know if the jury did. So my clock assumes that the jury worked through lunch. Did you see the truck chase from Ohio, lumber involved? Is that the one where the guy was like throwing lumber off the back of the truck? The big old... I did see that. That was crazy. We could keep 2 clocks and do a clock shift at the end. We'll have Aperture come in and fix the time for us. How about that? You Can't See Me says our emergency management just said this, that Saturday's flash flood was our highest mass casualty event in our county history. We still have 2 missing with 6 confirmed dead in Ohio County, West Virginia. That is wild. If you've never been through West Virginia is beautiful. It's beautiful, but it has a huge history that's intertwined with the coal mining industry that has reshaped West Virginia and reshaped the mountaintops. But the mountains of West Virginia are just absolutely amazing and beautiful and just lush and green and steep in many places. And if you get a lot of rain, there's nowhere for the water to go, especially if it's been wet previously. And yeah, When John Denver says almost heaven, West Virginia, he means it, right? Mountain Mama, right? Those mountain areas, it's very similar to what you have. I mean, it's close to what you have in Asheville, in eastern Tennessee. You know, that whole area, the same mountain range goes through it, and that's where we had the terrible destruction from the hurricane. Sean White says, Scott, you need to adjust the clock for variance. Just how much variance is? What's the variance that we need to adjust? Missed the verdict of the short trial. I'll spoil it for you, Ashley. Guilty on both counts. Do you see the post from Rob about the alligator near him a week after a bear was near the courthouse? I did. All we need now is like a lion and a tiger, and then you get the lion, tiger, bear, alligator quad combo. The twin cam Harley isn't as much potato as the EVO, and the M8 motor almost doesn't have it at all without replacing the factory cam. See, I can see from your logo you know what you're talking about, but I'm just saying the electric has none of it, right? It's just like it's an electric motor. My bike's almost silent. Of course, it doesn't have anywhere near the pickup of a Harley. Did you hear about the giant shark headed to North Carolina? As my daughter is going to the beach this week with her friends. No, I didn't. I didn't hear about that. We don't know how fast the jury chew their lunch. That's the variance. I don't think you stopped the clock when the jury went to lunch. I did not, because the judge told them they could deliberate through lunch if they chose to. But she then said that the courtroom takes a lunch, and it would be nice if you let them have a lunch break during these times. How's the sound again? I was playing the actual sound. That wasn't me making the noise. That was like the actual sound of the bike. The O'Keefe family's not there yet. Miss Reed is in the courtroom. Earlier today, the jury clock stalled out in court, so if you were off, that might be why. It was on Trial TV that clock stuck. No, that was, I think they were following Law and Crime's clock, and they had some technical difficulties with their clock. I've got my own clock running. This is, I bring mine in from here. This is my counter. I start and stop it myself. It's separate. Court TV clock's only 5 minutes behind you. Probably I started my clock as soon as the jury was dismissed, which technically they can't actually deliberate until they get to the courtroom. If they get to the deliberation room and close the door, and then they can. So that could account for that little time. Do they have a question? If they have a question, they have not let the judge know. There have been no notes from the jury yet in this deliberation. Are we waiting on families and lawyers to arrive? Yes, and also no. The judge is planning to give them one more minute to deliberate. So in just a moment, we're going to probably have the judge come in and then call the jury in. As soon as we hear that the jury is in, I will stop the timer, but we're going to keep it running until then. There was a zebra on the loose. Is that the one they caught with and they picked up with a helicopter and transported it back? I think we talked about that on our podcast last week. Yeah, she's going to dismiss them for the day. Well, what you need to do is synchronize the clock with the infotainment system. Have you done a 3-point turn? Oh, that's good. Mr. Lally and Miss McLaughlin have entered. There's a baby crying in the hallway, says Sue O'Connell on Twitter. Nine hours. Court TV has some very outspoken commentators on it that believe that Karen Read is guilty in this case. And I think the volume that they speak at skews the landscape. Regina, no verdict that we've heard of. No notes. It's just going to be the jury's going to be sent home here in just a minute. Looks like there's some motion in the courtroom. Possibly any second now we'll hear about it. Here we go. I can see the floor is shaking, which means people are coming in. That could be jurors because the camera is mounted on a tripod right near where the juror's at. Don't think we have anything at sidebar. Janet, some judges allow the jury to basically, as soon as they're all together, just start deliberating. Other judges sort of like to oversee the process, and this judge does a little more oversight than others. So she calls them in and dismisses them. Okay, the O'Keefe family is now present. I think we're probably here right at 4:30. She's going to call it. Gym shorts. Yes, one juror is in very casual. Here we go. Got audio. Jurors are coming in. We're going to stop the clock.
Court's back in session. You may be seated.
All right, jurors, we appreciate how hard you've worked today. It's been a long day. I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. Beautiful day, get some fresh air, and we'll see you tomorrow morning, okay? Thank you.
All rise for the court, please. Jurors, follow me.
Might just get a little scheduling.
All right. So we'll see everybody tomorrow morning, okay?
Thank you.
Okay, thank you.
All right.
That's it. That's it. We're done. Wow. A full day with no verdict. Well, at least we got one verdict in the other trial. So tomorrow, here's the plan. We're going to follow it in the morning together here. I'm going to be leaving just before lunchtime to drive for a couple hours to go camping. I will set up Starlink and everything else. We'll follow it there. And fingers crossed. I don't know. We might have to see if we can get some help. Running the live stream tomorrow.
Call from Angela.
Angela, how are you doing?
I'm doing good on my way home.
Yeah.
Yeah. The weird jury. I mean, we haven't heard a peep. I don't know if it's good or bad thing. I hope it's a good thing.
They were told they could ask questions, so they know about that. But
yeah.
Apparently they don't have any questions. It's possible that they took the judge's instructions to heart and they're just going over all the evidence, all of it. They're just like checking the box. Here's this. Here's that. Here's this. And that could take a day or two.
Well, I don't work on Friday, and there is court on Friday, so I hope we are not going to be here until Friday, but I mean, it would be nice that I'll be there live, when the verdict arrives. But I hope sincerely that verdict comes in tomorrow, because this is. Let me put it this way: I'm happy that I'm working, so I'm distracted and not like last year.
Well, yeah, it does help to have a distraction for sure, but
yeah,
I don't know. I'm not nervous now. I mean, look at the length of time this case took. Look how long they're deliberating. This is perfectly normal. As a matter of fact,
well, you know what I did this weekend? What? I raided the house for all the candies, and I told my parents this morning I told you that there's this store called Candy People here where I live, where you buy candy by pound or kilogram or box. And I told them that we need to go there and buy candy because it's cheaper than going to the store and buy, per piece.
There you go. Get some candy. Get some sugar. I've sworn off this stuff. Haven't had any of it for like 8 hours.
Don't move to Sweden there because
it's been 8 hours.
Don't move to Sweden there because we have here. You can buy candy by like an ounce, gram, even a pound if you want, or rocks.
You can buy rocks by the ounce and gram.
Yeah, gram. Well, whichever you choose.
What are you selling over there?
Licorice, chocolate. I'm entering the store. I can send you the picture later. Like the wall with only candy.
Well, I've been off candy for almost as long as the jury's been deliberating, and it's been rough. So I don't know. We'll figure it out.
Well, can I say something? But please, including you and everyone in the chat, to not bite my head off and unalive me in the chat.
Yeah, don't just be nice to her. Be nice. Why? Who's being mean to you?
Well, I love motorcycles, and me and my family have more than a few motorcycles.
Okay.
And none of them is Harley Davidson. And I have been driven on. I don't have a license to drive a motorcycle, but I know people who has a Harley Davidson, and I have been driven on Harley Davidson. And let me put it this way: never again drive and buy.
They vibrate, they shake, and I think that has part of the signature sound. But I've been on one, and it was not the best experience for me. They're fun bikes. They're built very well, very powerful, really nice. They're pretty to look at. It was not the most comfortable ride for me, and maybe it was just the.
Yeah, it is. That's the problem. It is the uncomfort. You know what I mean? Motorcycle ever. Seriously, we have Yamaha, Kawasaki, and Suzuki. Those are like babies in comparison to Harley Davidson. Babies.
I've really enjoyed
drive.
I've really enjoyed my Kawasaki that I had. I really enjoyed riding on Yamahas, and Honda was not my favorite. Although they're good, they're well built machines. I like the Yamaha as far as dirt bikes go. They're good stuff, but.
I'm gonna ask my brother to dig up a picture of all the motorcycles. Although I think we sold one since then, and another one is on sale right now. But just to show you the collection that we have, like including the dirt bike.
Take a picture in the motorcycle garage. Yeah.
Yeah, I will. Although not all can be placed in there. We have like 5-6 motorcycles, and the garage is not that big. So yeah, that was. I really back to Ken Reed. I really hope that we get a verdict tomorrow because it has been.
We're ready. I think everyone's ready for it.
Yeah, we are ready.
Yeah.
Even my friends and family, because they are like, please come. I hope the verdict will arrive soon so I can start talking about the case.
That's awesome. Yeah, I hear that a little bit. You know, it's we know so much about it now that we feel like we've been in the courtroom and we're on one of the teams, and you know, we know all the witnesses by first name and you know all their interests and their proclivities and mistakes and everything else. It's been a long case. It's going to be like this. It's going to be like this for Brian Coburn.
And initials.
Yeah, initials.
Well,
nicknames.
I now know all. Yeah. One good thing is that after I get my license to drive for a car, I know which car I'm going to drive. Toyota, not a Lexus, because that's way out of my price range. But Toyota is a little in my price range.
Yeah.
You know. I know a lot about Toyota now because of this.
My price range is more like Yugo or maybe Hyundai.
Oh, speaking of Yugo, do you know where Yugo is produced? Or was produced, not anymore.
Sweden?
Nope. My home country, Serbia.
In Serbia? Seriously? I didn't know. Yugo...
Yeah.
They made a car that was a lot like what we had. We had one called like a Geo Metro that I put in the same category as a Yugo. They meet the basic qualifications for a car, and nothing else. It's got the 4 wheels in the engine and some seats and a steering wheel. That's pretty much it. So.
I heard rumors, although I don't know how true those rumors are, but rumors going around is they are bringing back the production of Yugo.
Really?
But that's just a rumor.
You might have to get one for old time's sake. So.
Yeah.
Well, Angela.
But considering everything that is happening, yeah. Thank you so much. And I am taking a picture and sending to you of the wall with candy.
Awesome. Can't wait to see the motorcycles. Thank you very much. Good to hear from you.
Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.
All right. We're going to call it a day. I have to pack a little bit for the trip tomorrow. And it's mostly electronic stuff in my bike, and I've got to load like the bike rack on the car and everything else. So, oh, man. It's gonna be fun. It's going to be a good day. It's going to be pouring rain the whole time I'm camping. As long as it's not lightning. I do hope to swim in the lake and detect and find some rings and stuff. That would be good. Find a few rings to pay for the bike. But years ago with a bunch of friends, I did an 8-day motorcycle trip on a Triumph. Beautiful, lots of fun. But man, the rains and the bugs. My mom did a Vespa tour of Europe when she was a kid. I'm pretty sure that was what it was. She was in France and all over. She was all over the place on a Vespa. So cool stuff. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, about 8:30. Pick up the verdict clock at that time. It's 9 hours, 13 minutes, 32 seconds. We can round it up to 33 seconds, but it's been a long one. See some of y'all later on someone else's channel. What's out there? Is there somebody we need to portal to tonight? Anybody? I'm not seeing it. Lawyer Lee? Let's see if we can go to Lawyer Lee. I haven't done her before. Can't see Lawyer Lee. Alright, I got nobody. Got nobody. Find your own way in the world, guys. There's stuff to do out there. Have fun. We'll see you tomorrow. Bye. Oops.
I was told counsel wanted to see me inside bar.